hand over all fresh matters. Don't even wait for me.
End of the list, mayor.
Sit.
End of the mayor.
Again, urgency.
I was working as a temporary vice principal. As per the direction of this honorable court. Now they have given a termination notice, terminating me from the vice principal post. As per, against to the court direction, wherefore there is any
Told it.
end of the
No,
list.
this is also for memo for posting today at the end of the list. No, this is the case with regard to that consumer members, my lord. In fact, yesterday, my lord, given this date today, it is not posted today, 2:30.
ಯಾಕಂದ್ರೆ ಪೋಸ್ಟ್ ಮೆಮೋ ಕೊಟ್ರೆ ಯಾಕೆ ಬರೋದಿಲ್ಲ ಅದು?
My lord, ಇದು 2:30.
ಚೆಕ್ ಮಾಡಿ ಅದು ಯಾರು ಮಾಡೋದು ಕರ್ಸಿ ಅವ್ರನ್ನ ಮೆಮೋ ಅಂತ ಕೊಡೋಣ. ಆಕ್ಟಿವಿಟೀಸ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇನೆ, ಅಥವಾ ಅವರೇ ಬೋರ್ಡ್ ಬೆಂಚ್ ನೋಡ್ಕೋಬೇಕೇನಾದ್ರು. ಮೆಮೋ ಕೊಟ್ರೆ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು.
2:30, my lord, 2:30.
My lord, in this matter, the petitioner has not been given his salary from 9 months, my lord. He has been he has been going through a lot of money problems, my lord. So kindly it may be listed today, my lord, on 2:30.
So this matter relating to 2022. I was working as a maintainer.
Will come on the date.
Now, Lordship had instructed to file an application for earlier hearing. To file the application.
ಆಯ್ತು ಕೊಡಿ.
My lord, it is 2014 matter, my lord.
ಕೊಡಿ 2014 ಕೊಡಿ. ಎಷ್ಟನೇ ಇಸ್ವಿ ಇದು? ವಿಚ್ ಇಯರ್? ಎಷ್ಟನೇ ಇಸ್ವಿ? ಇಸ್ವಿ 23. ಕೊಡಿ ಕೊಡಿ ಬರುತ್ತೆ ಕೊಡಿ ಕೊಡಿ.
The pension of the widower of a serviceman is being reduced now. This is a pending matter, Lordship said.
Which year?
24, my lords. Any date this week. She's the widower of a serviceman, my lords. She has no other source of income. That is the only.
I told you. Yes.
Any date this week, my lords.
Lords, it's a 2023 matter, my lords. Memo for posting.
What is the urgency?
Urgency is that the writ might become infructuous.
Let it become infructuous.
Let them.
What is the urgency? All writ petitions will become infructuous if you don't deal with it appropriately.
Let the matter be.
What is the urgency, Mr.? Please read the file and come back.
My lord, cancellation, removal of librarian assistant, my lord. 23 matter, removal of librarian assistant, my lord. He has no other work, my lord. His
I
challenge.
told yes, yes.
ಸ್ವಾಮಿ petition ಮೆಂಟಲ್ ಅಂಡ್ ಫಿಸಿಕಲ್ ಹ್ಯಾಂಡಿಕ್ಯಾಪ್ಟೆಡ್ ಸ್ವಾಮಿ ಫ್ಯಾಮಿಲಿ ಪೆನ್ಷನ್ ಗೋಸ್ಕರ ಇದ್ ಮಾಡ್ತಾರೆ ನಾಳೆ
I told.
ದಯವಿಟ್ಟು ನಾಳೆ
Petitioner father is suffering from various ailments, my lord. He needs to assist his father. And he needs the money, like arrears of salary that we have filed for.
Which year? Petition is filed in which year?
2024.
That's
told
2024, my lords. We have for respondents, interim stay has been granted, my lords. We are filing for vacating.
Memo, orders application ಹಾಕಿದಿರಾ?
No, my lords.
Have you filed an application of vacating stay?
Yes, my lords, we are.
ಆಯ್ತು orders ಹಾಕಿ.
Petitioner, my lord, senior citizen ಇದ್ದಾರೆ ಇವರು. ಇವ್ರಿಗೆ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ರಿಟೈರ್ಡ್ ಆಗ್ತಾ ಇದೆ, my lord. ಸೊ ಇವ್ರಿಗೆ ರಿಟೈರ್ಡ್ ಅಮೌಂಟ್ ಎರಡ್ ಕಡೆ ಡೆಪ್ಟೇಷನ್ ಮಾಡಿದ್ರು. ಒಂದು ಸ್ಯಾಲರಿ ಆಗಿದೆ, ಇನ್ನೊಂದು
ಬರುತ್ತಮ್ಮ ಬರುತ್ತೆ yes.
ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸ್ ಇದೆ, my lord.
ಎಲ್ಲ ಅರ್ಜೆನ್ಸಿನೇ ಬರುತ್ತೆ. yes.
ನೆಕ್ಸ್ಟ್ ಇಯರ್ 6 months ಗೆ ಇದು
ಆಗ್ಲಿ ಇನ್ನ 6 ತಿಂಗಳು ಟೈಮ್ ಇದೆಯಲ್ಲ, ಇನ್ನ 6 ತಿಂಗಳು ಟೈಮ್ ಇದೆಯಲ್ಲ. yes madam.
Your lordship, I am for the petitioner. He's a retired subedar in this case, your lordship, and is seeking for the disability pension, your lordship, which is not coming for him from last 27 years.
Told. ಮೇಡಮ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರು, ಇನ್ನ ಟೈಮ್ ಇದೆ, ಬರುತ್ತೆ. yes. ಆಯ್ತು ಮೇಡಮ್, ಅಯ್ಯೇ ಹಾಕಿದಿರಾ? ಮತ್ ತಗೊಂಡಿದೀವಲ್ಲ. ಆಯ್ತಾಯ್ತು, ಅಯ್ಯೇಗ ಅದೇನು ಅಯ್ಯೇಗ
2020.
ನೀವು ಬಿ ಗ್ರೂಪ್ ಅಂತ ಬರ್ತೀವಿ. ಆಯ್ತಪ್ಪ, ನೀನ್ ಬಿ ಗ್ರೂಪ್ ಅಂತ ಬರ್ತೀವಿ. ಬಿ ಗ್ರೂಪ್
22 B group, man. 2022 B group. She's terminated from service. She's divorced also, no other source of income.
ಒಳ್ಳೇದಲ್ವಾ? ಅಲ್ಲಿ ಮನೆ ಕೊಡಂಗಿಲ್ವಲ್ಲ.
She is widowed. She has other problems also.
ಆಯ್ತು ತಗೊಳ್ಳಿ.
Lord, case of termination, my lord, without inquiry. Matter was held for some time and.
Cheer.
Lord, it's a matter of 23, my lord, and the petitioners are without
Oh, yes.
employment for the last 4.
ಎಲ್ಲ ಒಂದೇ ದಿನ ಮೂವ್ ಮಾಡಿದ್ರೆ ಬೇರೆ
My lord, I had filed an application on Friday, my lord, because for modification of the interim order passed by this court. Your lordship has a order to post a case for orders today. It has not come, my lord. Let it come tomorrow, my lord.
ಯಾಕೆ ನೋಡಿ ಚೆಕ್ ಮಾಡ್ರಿ.
ಹೌದು.
Lord,
ಸಾಹೇಬ್ರು
it's
ಹೇಳಿದ್ರು.
a BSF matter, my lord. The petitioner was, my lord, serving in BSF hospital. My lord, she sought 1 year, my lord, compulsion transferred to Bangalore. Actually, my lord, there is no post of her in Bangalore. My lord, this honorable court has granted interim order. My lord, she has to go to, my lord, her parent, my lord, that is in Kadamtala, West Bengal. My lord, now she is in Bangalore where there is no post at all. So I filed, my lord, this is for B group, my lord, for respondents.
ನೋಡಿ which year?
24 itself, my lord, because she has sought for only 1 year. It is going to end in, my lord, in 2 months, my lord.
2 months ತಾನೆ
But, my
ಮುಗಿಸ್ಕೊಂಡು
lord,
anyway you have been
but
paying
there
us.
is no post, my lord.
Huh.
There is no post in Bangalore BSF.
You should have filed an application vacating.
Lord, I filed objections, my lord.
Vacating application ಹಾಕಿ ವಾಪಸ್ ಕೊಡಿ. Yes.
Lord, it's a fresh matter, man, termination.
Writ of mandamus.
ಮಿಸ್ಟರ್ ಎಷ್ಟು ಸತಿ ಹೇಳೋದಪ್ಪ ನಿಂಗೆ? 3 ಸತಿ ಹೇಳಿದ್ಯಾ ಆಗ್ಲೇ. Please stop it. Stop it. This is,
Writ
there are
of
other
man-
people waiting.
Writ of mandamus.
There are other people waiting, mister.
Writ of mandamus, my lord. Service matter, promotion. Final year.
ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆಗಿದೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಲ್ರೆಡಿ, ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅದೇ ಎಲ್ಲ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಎಷ್ಟನೇ ಎಷ್ಟಿದಮ್ಮ?
2023.
Yes.
I am ITI candidate, my lord. TPTCL is recruiting non-technical students for the post which is designated only to be. And there is a notification, my lord. It's very existing. So it may be taken on the
Fresh matter.
fresh matter.
2024 ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಸರ್. ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ ನ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ. ನಾವು
ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ನಾನು 3 ಸತಿ ಹೇಳಿದೀನಿ, ಇನ್ನ 4ನೇ ಸತಿನೂ ಹೇಳು ಅಂದ್ರೆ ಹೇಳ್ತೀನಿ. ಒಂದ್ ತಿಂಗಳು ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ, ಅಥವಾ ಒಂದು 15 ದಿನ ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ.
My lordship, pending matter 2019 service matter, my lordship 19 matter.
Hand it over. Yes.
ಇಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್ ಅಲ್ಲಿ ವಿತರಣೆ ಮಾಡಿದ್ದಾರೆ 6 lakhs rupees. 2022 ಮ್ಯಾಟರ್. It was being
Adjournments phase wise. Page number 5.
ಹಿಂಗಾಕ್ರಿ ಅಂತ 3 ದಿನದಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
Adjournments phase wise, page number 5. Serial number 25 to 28. Page number 6, serial number 29 to 38. Page number 7, serial number 39. Page number 8, serial number 40 to 42. Page number 9, serial number 43 to 47. Page number 10, serial number 48 to 52. Page number 11, serial number 53 to 56. Page number 12, serial number 57 to 61. Page number 30.
61, my lords. I appear on behalf of respondents. On the last date of hearing, lordship had directed us to give information about the leave encashment. We are procuring information, my lords. I request for 3 weeks' time.
Respondent seeks time, list on date.
We have informed the other side, my lords.
24th March. 24th March.
3 weeks' time, my lords.
7th April.
Grateful, my lords.
Page number 13, serial number 62 to 68. Page number 14, serial number 69 to 74. Page number 15, serial number 75 to 79. Page number 16, serial number 80 to 85. 82, next week. Counting of.
Counsel for the petition seeks time, list on.
Page number 17, serial number 86 to 86 and 87. Page number 18, serial number 88.
Correct.
List number one for non-compliance first time, serial number one, Mamta Gururao.
2 weeks, 2 weeks.
May I make one submission, Your Lordship? Since the matter is, they are taking precipitative action, they are the casual laborers, skilled casual laborers appointed in the archaeological department, madam. During the course of the day, I will comply the,
Madam, you're not even paid the court fee.
I have paid, Your Lordship, already paid. Other objections, I will comply during the course of the day itself,
One day.
tomorrow, my lord.
List tomorrow if office objections are complete. List tomorrow for preliminary hearing if office objections are complete.
Serial number two, Rajat, yes.
For the petitioner, my lord, the matter is connected with another similar matter, my lord. 27276, the matter is posted on 27/3.
Please comply this office.
I will comply, my lord.
List on 27/3 if office objections. List on 27/3 for preliminary hearing if office objections are complete.
Serial number three, Rahul P.
I kindly pray for 1 week time.
1 week time is granted to the need.
Serial number four, Vijay Naik.
The petitioner in this case, only the list of dates on Hakilanta Swami, I'll happen during the course of the day. May I request the Nalidika urgency the Swami, temporary.
List day after tomorrow if office objections are complete.
Sorry. Serial number
Raju.
five, HB Raju.
Please urgency Swami.
Comply ಯಾವ ಮಾಡ್ತೀರಾ? ನಾಳೆ ನಾಡಿದ್ದು list tomorrow if office objections are complete.
Serial number six for orders matters, Rangnath.
Immediate ಕಳಿಸಿ ಇಲ್ಲೇ ಕೈಯಲ್ಲೇ ಬರೆದು ಸೈನ್ ಮಾಡಿ. Joint counsel for the petition. AGS director accept notice for respondent number 5. Stop. The Joint counsel for the petitioner seeks hand summons for respondent number 3 and 4. The same is granted. Office shall issue hand summons to the respondent number 3 and 4.
Serial number seven, Vicky Tarpi.
Are they 3 and 4?
Serial number seven,
Directing them to appear before the court on date put 3 and 4. Serial number 6 on date put.
Well, this is the
Case
of regularization.
8th March. Yes, Vicky Tarpi.
Serial number seven, Vicky Tarpi.
Case of regularization. Well, I'm just forwarding one letter. 20th of February 2025 in Commercial Tax Department, Courtmaster. The regularization has been effected based on the division bench judgment. The matter went to SLP. SLP was also rejected.
Is government. ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿರಾಗಿರುತ್ತೆ.
ನನಗೂ ನೆನ್ನೆ ಸಿಕ್ತು ಇವತ್ತು. In fact, the division bench has disposed of the writ appeals filed by the government.
ಕಾಪಿ ಕೊಡ್ರಿ.
Upon 10 years, they should be regularized. Matter was taken up to the Supreme Court, SLP was dismissed.
D group employees, huh?
Yes.
You are in case only?
Yella D group. C and D. They are working in a cocoon market, my lord.
What are they working as?
They are working, my lord, some of them as a clerk, some of them as a D group employees and C.
Yes,
35 years they have worked.
Government. The learned senior counsel for the petitioners has placed on record an order passed to the Department of Commercial Taxes, Government of Karnataka, dated 20th of February 2025, in terms of which, several C and D group employees,
Yes, my lord. Amalis.
were regularized in service pursuant to an order passed by the Honorable Apex, pursuant to an order passed by this court, which was upheld by the Apex Court in Civil Appeal 2573/2024. Stop. They learned AGH seeks time to secure instructions.
Only one submission. in University of Agricultural Sciences, I have filed a compilation, my lord. First judgment in the
it applies.
ಅದರಲ್ಲಿ ಅಷ್ಟೇ 10 years. I myself appear. Yes, my lord.
The same is taken on record. The Iran DG is granted to secure instructions list on war time put
5th March.
Next Monday, my lord.
Next Monday, Tuesday.
Please.
Serial number 8, Srinivas V.
My lord, in this case, I went through the affidavit. The documents on which the respondents are now relying on, is it maintained by the petitioner or not? I take instructions, my lord. The last I have it on Friday.
Counsel for the
Lordship,
petitioner,
next
please.
Monday, Lordship.
List on take what date you,
Next Monday.
then next. Joyce.
Serial number 9.
Mr. N.K. Ramesh is directed to accept notice for respond number 1. Mr. Pradeep Kumar is directed to accept notice for respond number 2. 2025 ಬರುತ್ತೆ ಬಿಡ್ರಿ. Next.
Serial number 10.
Non-compliance of office objection. What is the issue?
Well, in this petitioner has been working from 2005 as a physical education teacher. Earlier, he had sought for equal pay for equal. Government granted it, my lord. But the order was challenged by the Karnataka Power Commission Corporation on the ground that the education appellate tribunal appeal does not. Then the court directed as per annexure S, page number 58, that the case of the petitioner shall be considered. He shall make a representation. Now that representation, my lord, has been rejected regarding the equal pay for equal.
Equal pay for equal work ಅಂದ್ರೆ whether work is equal ಅದನ್ನ
Yes, they are regular physical education teacher postally 2005 in the he has working 25 years in the work. 2000 in the 25 years.
You are comparing with which department?
I am not comparing. There is a post which I am discharging duties of physical education instructor in the department. In the institution, KPCL institution.
Equal pay for equal work ಅಂದ್ರೆ ಯಾವ
PUC board has recommended. Kindly see annexure W, page number 81.
You are also working in a
Sanction post, my lord.
PU
It's a
college.
post. Yes, selection post ಆಗಿದೆ ಅಲ್ಲೇ.
AG is directed to accept notice for respondent number.
My lord, I have sought for interim order of stay of termination. There is a threat of termination because I have approached the court and there is a vacation intervening. They will likely to terminate, my lord. 25 years in the ಮಾಡ್ತಾ ಇದೆ.
Regularization of service.
Regularization ಕೇಳಿದೆ because against sanction post more than 25 years. I have asked for regulation equal pay for both.
Appointed on what?
Appointed in 2000, my lord.
On contract.
Selection committee was constituted. In fact,
Whether you are appointed on contract basis or what?
ಅಲ್ಲ regular basis, consolidated salary, not on contract, it's consolidated.
Where is your letter of appointment?
Appointment, kindly see, next share. Page number H. Annexure H is the order, post sanctioning post. Annexure J is the order of appointment. Hangami ನೇಮಕಾತಿ ಆದೇಶ. ವಿಶ್ವವಿದ್ಯಾಲಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಹಾಗೂ ಪ್ರೌಢ ಉಲ್ಲೇಖಿತ ಆದೇಶವನ್ನು ಕೆಳಕಂಡವರು ಹಂಗಾಮಿಯಾಗಿ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ತೋರಿಸಿದ ದಿನಾಂಕ ಅವಧಿಯ ಕ್ರೋಢೀಕೃತ ಕನ್ಸಾಲಿಡೇಟೆಡ್ ಸ್ಯಾಲರಿ 2002 ಒಳಗೆ ಅಪಾಯಿಂಟ್ ಆಯಿತು. 23 years I have served.
Annexure A is ಯಾವ್ದು ಡೇಟ್ ಏನು?
Annexure A is ಇನಿಷಿಯಲ್ ಮೇಲ್ಕಂಡಂತೆ ಕಾಲೇಜುಗಳಿಗೆ ಬೇರೆ ಸರ್ಕಾರ. It was earlier under ವಿಶ್ವವಿದ್ಯಾಲಯ VVNL. Now it is taken over by KPSC. Annexure B is the government order saying that wherever.
Where is your letter of appointment?
Appointment is annexure. Annexure J, page number 32.
Annexure
J, page number 32. ಹಂಗಾಮಿ ನೇಮಕಾತಿ ಆದೇಶ ಮೇಲೆ ವಿವಿಧ ಪದವಿ ಕೆಳಕಂಡವರ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ತೋರಿಸಿದ ದಿನಾಂಕ ಅವಧಿಯವರೆಗೆ ಕ್ರೋಢೀಕೃತ ವ್ಯವಸ್ಥೆಯಂತೆ ನೇಮಕಾತಿ ಮಾಡಲಾಗಿದೆ. ತಾತ್ಕಾಲಿಕವಾಗಿ ಅವಾಗಿಂದ ಕಂಟಿನ್ಯೂಸ್ 2000 3000 ಸಂಬಳಕ್ಕೆ ಕೆಲಸ ಮಾಡಿಸ್ಕೊತಾ ಇದ್ದಾರೆ ರೈಟ್ ಫ್ರಮ್ ದೇನ್. That's why I went to the government seeking for a direction to pay equal pay for equal work. The government allowed my petition.
The AG is that accept notice for respondent number one. PCL yaru?
Government for respondent one, my lord. All others, KPC advocate.
Yeah,
All
KPCL
2 to
yaru?
5.
KPCL. KPCL. Kiran Kumar. You appear for KPCL?
Yes, my lord. Karnataka Power Corporation Limited.
You appear?
Yes,
What's
my
your name?
Shailaja SV, my lords.
Saja SV is that to accept notice for respondent.
Yes, we.
2 to 5.
Yes.
In prayer as for to the next state
Mean
hearing.
stay of termination.
List on date.
My lord, stay of termination.
Where is the country?
25th March. Serial number 11, Keshav Murthy.
I appear for the petitioner in this case.
Ah.
Pursuant to my RTA application, they gave my lord selection list annexure G2, page 1213. ಅದರಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅದು G1 ಗೆ ಜೊತೆಗೆ ಎನ್ಕ್ಲೋಸ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Already, what are the office objections? Better copy.
All the objections are complied.
Furnished. G2.
G2 ಏನು ಅವ್ರು ಫರ್ನಿಶ್ ಮಾಡಿರೋದು ಇಷ್ಟೇ. ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್. Selecting a fourth respondent. Adu, this is given along with annexure G1.
Objection is overruled by accepting the submission of the counsel for the petitioner. Yes.
Here, my lord, 2 courts were called for the physical education, but one SC rural and one general. Rurally, this person has, the fourth respondent has been selected. The petitioner is also one of the candidate, my lord. So, my lord, this petition is more meritorious than the fourth respondent. Our ಒಂದು criteria ಇದೆ. ಆ criteria fulfill ಆಗಿಲ್ಲ ಅಂತ we have requested the information from the RTA. They did not give it.
What is the criteria?
ಅಲ್ಲಿ page 26 ನಲ್ಲಿ ಇದೆ. How that marks should be given to the candidates ಅಂತ page 26 ಅವ್ರದ್ದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಮಿಡಲ್ ಪೋರ್ಷನ್ ದಲ್ಲಿ ಸ್ಕೋರ್ ಕಾರ್ಡ್ ಫಾರ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಅಸಿಸ್ಟೆಂಟ್ ಪ್ರೊಫೆಸರ್ ಆಫ್ ಫಿಸಿಕಲ್ ಎಜುಕೇಶನ್ ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಅಗ್ರಿಕಲ್ಚರ್ ಆರ್ಟಿಕಲ್ ಅಲ್ಲಿ ಈ ಪ್ರೊಸೀಜರ್ ಪ್ರಕಾರನೇ ಅದು ಮಾರ್ಕ್ಸ್ ಅಲೋಟ್ ಮಾಡ್ಬೇಕು. ದಟ್ ವಾಸ್ ಅದು ನಮ್ಗೆ ಕೇಳಿದ್ರೆ ಕೊಟ್ಟಿಲ್ಲ. ಬಟ್ ವಿ ಆರ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್ ದಟ್ ಈ ಡಸ್ ನಾಟ್ ಅದು ಅಕಾರ್ಡಿಂಗ್ ಟು ಅಸ್ ಇಲ್ಲಿ ನಾನೊಂದು ಪ್ರಿಪೇರ್ ಮಾಡಿದ ಅನೆಕ್ಚರ್ ಎನ್ ಪ್ರಕಾರ. ಸೊ ಪೇಜ್ 242 ದಲ್ಲಿ ಅನೆಕ್ಚರ್ ಎನ್ ಅನೆಕ್ಚರ್ ಎನ್ ಇಲ್ಲಿ ಇದು ಎಲ್ಲಪ್ಪ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರ ಟೋಟಲ್ 37 ಆಗುತ್ತೆ. ನಮ್ದು 47.26 ಆಗುತ್ತೆ.
242 ನಲ್ಲಿ ಇಲ್ಲ.
ಎನೆಕ್ಚರ್ ಎನ್ ನಾನು ಒಂದು ಟೈಪ್ ಮಾಡಿ ಎಂ ಅಂಡ್ ಎನ್ ಅಂತ ಎನ್ ಇಲ್ಲಿ ಇದು ಎಲ್ಲಪ್ಪ ಎಂ ಅಂದ್ರೆ ಈ ದಿ ಸೆಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಅವರು 37.92 ಆಗುತ್ತೆ. ಅಲ್ಲಿ ಅದೇ ಇದ್ರ ಪ್ರಕಾರ ಮಾರ್ಕ್ಸ್ ಅಲೋಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು. ಅದನ್ನೇ ವಿ ಹ್ಯಾವ್ ಅಪ್ಲೈಡ್ ಇನ್ ಆರ್ ಟಿ ಐ ಕೊಟ್ಟರೆ ನಾವು ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಅವರು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತಾನೆ ಬಂದಿದ್ದಾರೆ. ಸೊ ನಮ್ದು 47.26 ಆಗುತ್ತೆ. ಆಮೇಲೆ ಜನರಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ ಒಬ್ರು, ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಕೂಡ ಪೆಂಡಿಂಗ್ ಇದೆ. ಆ ಪ್ರಕಾರನೇ ಆಗ್ಬೇಕು ಅಂತ. ಸೊ ವಿ ಸಾಟ್ ದ ಇನ್ಫಾರ್ಮೇಶನ್ ಆಸ್ ಟು ಹೌ ಈ ಮಾರ್ಕ್ಸ್ ಆರ್ ಅಲೋಟೆಡ್ ಟು ದಟ್ ಪರ್ಸನ್.
On what basis you have drawn up annexure N?
Based on the information that the petitioner has about the fourth respondent. That's why, my lord, I have applied through RTA.
Any information is furnished?
Whether
Whether any information is furnished, but how did you make an evaluation of the respondent number 4?
Based on their education qualification, we
take
know.
out notice.
Definitely. And it may be called along with the WP.
AG is directed to accept notice for respondent number 1. Shumagga Agriculture College.
Agriculture University. Yeah. Shumagga Agriculture.
Agriculture College, Shumagga.
2 and 3.
US Shumagga ಅಂತ ಇದೆ ನೋಡ್ರಿ. issue emergent notice to respondent number 2, 3, and 4. List this petition, the appointment of the respondent number 2, 4 shall be subject to the result of this petition. List this
And you
petition
should
along.
record along with the WP number
So and so.
10465/23.
Yes.
10465.
ಆಯ್ತು ಆಗಿದೆ ಬಿಡಿ. Yes, next.
For AUNI serial number 12, Divya Tej Hutchin.
Divya Tej.
Divya Tej
Not seeking amendment of the petition, my lord. Entrustment order was not under challenge, my lord, in the.
Is any objection? Other side, Venkatesh Arbatti.
For amendment, Your Lordship.
Any
I will take.
objection?
Section, my lord. Only pass it over.
Entrustment order he wants to of the writ petition. IA 2 of 24 is filed by the petitioner for amendment of the writ petition. And to challenge an order of entrustment of the inquiry to the Lokayukta. Lokayukta. Under Rule 14A of the ACA CCA Rules 1957. Full stop. Since the order of entrustment needs to be, since the inquiry is entrusted to the Lokayukta in exercise of the powers conferred on the state under Rule 14A, which also has to be examined, the amendment sought for by the petitioner is necessary for the consideration of the relief sought for in the writ petition. Hence, the same is allowed. Counsel for the petitioner is directed to make appropriate amendments in the writ petition and to file an amended writ petition. What is IA 1/22?
For early disposal, my lord.
Yes, IA 1/22 and IA 1/25 stand disposed. List the writ petition for preliminary hearing in B group on date 2021 matters. Jayant Dev Kumar.
26th March. Paper 13.
This, my lords, may recall, my lords, is that matter pertaining to KDB, my lords. This is the connected matter where my lords had requested us to clarify regarding validity of regulation 2019.
Yes.
My lords, an affidavit is ready, my lords. My lords, may kindly have it tomorrow, my lords. I'll have it, file the affidavit.
Affidavit.
Pardon me, my lords.
What is the affidavit?
Regarding my stand in respect of regulation 2019. My lords, may I kindly have it tomorrow, please, my lords. I'll have the affidavit filed.
Tomorrow, Lords, there is. I appear for the KIDB. But Lords could have it on Monday, Lords.
I have reserved one matter.
Yes.
So if you delay it, the matter also will get delayed because I can't. I need to know what is their stance because in 2019 regulations, they challenge it in one
Yes.
petition.
Yeah, I understand. They are relying upon that
They're
here.
relying upon that. So therefore,
Yes. All very,
tomorrow,
very.
tomorrow.
Grateful.
Yes, yes. Government has to objection. Government has to file objection, not file because they're.
Yeah, idralla.
Otherwise, objection, challenge ಮಾಡಿ.
Yes. Anyway, let them take a stance.
Let them take a.
Whether, if they can sustain the writ petition.
Yes. Yes. ma'am.
Without relying upon the
Yes.
2019
They have
regulations.
challenged it here, there they have relied. Could I be follow?
Without even relying upon 2019 regulations, if they can sustain their writ petition on any other ground.
That's my specific contention here, my lords.
No, yes.
Grateful.
Serial number 14, Nagaraj, yes.
Yes, Nagaraj. Early hearing.
With regard to the appointment of the.
IA 1/24 is filed for early hearing. Since the petition is not admitted, IA 1/24 is rejected. List the petition for preliminary hearing in B group on
26th March.
15th, same order, list on 16th, same order, list on 17th, same order, list on
16.
18th, same order, list on.
Lord, serial number 16.
We'll giving dates, madam. Yes.
18, I have to file my objections, my lord. Recently, I have.
What if this? When do you want it?
First week of April, my lord.
My lords, 18 is, I'm guessing it's a different matter, my lords. 18 is something that we have.
I don't know. He says that he wants some time for objections. Kumar.
I appear for 18. I have filed the objections, my lords. I have served the copy.
Objection will file. I want to file a rejoinder, my lords. Maybe
Whatever you want, we'll fix a
Yes,
date.
yes.
Yes.
2nd April.
IA number 19,
19, Srikanth MP.
MP Srikanth.
For the respondent, my lord. Kindly pass on.
Notice ಹೋಗಿಲ್ವಾ IA ಮೇಲೆ? Issue notice on IA 2 of 24. Serial number 20, same order, list on
And April. 3rd April.
21,
Serial number 21.
notice ಹೋಗಿದ್ಯಾ? IA 3 and 4.
Notice issue ಆಗಿದೆ.
ಎರಡರ ಮೇಲೆ ಹೋಗಿದ್ಯಾ?
Reading ಮಾತ್ರ ಹೋಗಿದೆ.
ಎಲ್ಲರಿಗೂ ಸರ್ವ್ ಆಗಿದೆಯಾ ನೋಡಿ ಚೆಕ್ ಮಾಡಿ. Officers directed to put up a note regarding service of notice to the proposed respondents in IA 3 of 24 and 4 of 24. List on date put. Puneet C.
8th March. Serial number 22.
Last occasion, my lord, it was
IA
not
1 of
extended.
25 is filed by the petitioner for extension of the stay granted by this court. It is stated in the affidavit, stated in the application that this court had granted an interim stay which was in force till
Lord, till 10/1/2025 on 10/1/2025.
10/1/25. However, when the matter was listed on 6/3/25, the interim order was not extended. Full stop. Since the petition is yet to be considered on merits, comma, if the interim stay is not extended, comma, the writ petition may become infructuous. Hence, IA 1 of 25 is allowed. The order of stay granted on so and so is extended till the next date of hearing. List on date. Chandrasekhar Patil. Issue notice on IA 1 of 25.
Please.
Srinivas V.
Serial number 24. Srinivas V.
V. Srinivas.
Respondent number 3.
V. Srinivas.
In this, I'm filing my statement of objections, your lordship.
Illi Srinivas.
It may be passed over. Was this? There's some urgency because the lordships have
Pass over.
interim order.
Pass over.
Film hearing matter. Serial number 25. Kalibullah Sharif.
IA 1 of 25 is allowed. Yes, good reason. For the time being, allowed for the time. Yes, Mr. Sharif, held.
In this case, my petition is seeking writ of mandamus that her pensionary benefits had not been given, stating that her husband who has served as a driver nearly 20 years in municipality, my lord. His apartment itself is irregular. So, my lord, the earlier occasion I filed writ petition, my lord. This honorable court has directed to reconsider it, my lord. After thereafter, I filed 2 applications.
AGA. AGA is directed to accept notice for respondents 1 to 3. Notice to respondent number 4 is dispensed for the time being. Copy put out. Please hand over a copy to the government advocate.
Today itself I will give, my lord.
List on date put.
Date, my lord. Next.
Puttar date puttar.
March.
Joseph Anil Kumar.
26.
Petitioner, my lord, kindly pass over the matter, my lord.
Why password, madam? What is the case about?
It's a service matter, my
Please
lord.
read. What is it? I have not read the file.
Yes, my
Please
lord.
argue.
My lord, senior will be there in,
Please argue. Have you read the file?
yes, my lord.
Please read. Please argue.
My lord, petitioner herein is a part-time faculty, my lord. In a first grade college in Mysore, in Kolar, my lord.
Case directed to accept notice for respondents 1 and 2. Mr. Shauri, HR Shauri is directed to accept notice for respondent number 3. Yes, Kumar KG.
Serial number 27. Kumar.
My lords, in this matter, I have filed my wakalat, my lords, 2 weeks back, but my name is not reflected, my lords.
Dismissal order, my lords. Without
Yes.
Dismissal.
Dismissal order, my lords.
Without
It is
inquiry.
Without inquiry. That is the only ground.
Lords, my name is not reflected, my lords. I have filed my wakalat long back.
ಏನು ಗುರುನಾ ನಿಮ್ಮ ಹೆಸರಲ್ಲ ಗುರು ಹೆಸರು? ಯಾರ
My name, my lords, Mangala Gachinmat.
Srimati Mangala Gachinmat has entered appearance for the respondents. Office is directed to show her name in the cause list on.
2 weeks, my lord.
Next week, my lords,
2
because
weeks.
only that is the only ground, my lords.
So, instruction ತಗೊಳ್ಳಿ.
ತಗೊಳ್ಳಿ ನಾನೇ ಹೇಳಿದ್ದೆ.
Next list on date put.
1st April.
Please.
Number 28.
Ramakrishna N. Ramakrishna.
That petitioner seeking, petitioner made representation to the respondents, my lord. Husband of the petitioner died on 17/9/24, my lord. Thereafter, she made several representation to the respondents, my lord. And the respondent issued endorsement by saying that since the husband of the petitioner working under.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ
Sir, ಮಾಡಿದ್ದು.
ಮಾಡ್ಬೋದಾ? ಅಲೋ ಮಾಡ್ಬೋದಾ? AJ directed accept notice for the response 1 to 3. 1 to 4. Notice to RFS dispense for the time being. List on. Yes.
26th March. Serial number 29. Professor Santhan Gowda.
IA 125 is allowed. Yes.
Sorry, my lord.
Dispensation is allowed.
My lord, the petitioner, my lord, was appointed by KPSC
Hmm.
pursuant to recruitment process.
Hmm.
That, my lord, the selection list is at Annexure K, page 96.
Annexure K.
K, page 96. My lord's got it, my lord. This is a notification to the post of second division assistant. Appointing authorities director, department, municipal directorate, Bengaluru. Petitioner's name, my lord, is in the next page, page 97. Serial number 15. Gajendra Kumar. My lord, pursuant to this, my lord, he was asked to report to municipal administrative department. There's at Annexure M, page 104.
Yes.
This is dated 11/6/2020. ಹಿಂಬರ ಗಜೇಂದ್ರ ಕುಮಾರ್ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗ ಕರ್ನಾಟಕ ವಿವಿಧ ಇಲಾಖೆಗಳಲ್ಲಿ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಆಯೋಗದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಡೇಟೆಡ್ ಸೋನ್ಸೋರಲ್ಲಿ ಅಧಿಸೂಚನೆಯನ್ನು ಹೊರಡಿಸಿದ್ದು ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಡೇಟೆಡ್ ಸೋನ್ಸೋರಂತೆ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿ ಪ್ರಕಟಿಸಿದ ಸದರಿ ಅಂತಿಮ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ನಿಮ್ಮನ್ನು ಆಯ್ಕೆ ಮಾಡಲಾಗಿದ್ದು ಈ ಕೆಳಕಂಡ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ. Pursuant to KPSC appointment, I was asked to report there. My lord, when I went to report there, the Annexure R, the impugned endorsement has been issued at page 141, wherein they said that I am not eligible. Agreed by which, my lord, I am before this honorable court. For this reason, page 141, Annexure R. Dated 26/12/2022. ರಾಜ್ಯದ ನಗರ ಸ್ಥಳೀಯ ವಿಷಯ ರಾಜ್ಯ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆ ಖಾಲಿ ಇರುವ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಆಯ್ಕೆಯಾಗಿರುವ ಅಭ್ಯರ್ಥಿಗಳ ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ. ಕಂಟೆಂಟ್ ಇಸ್ ದಿಸ್: ರಾಜ್ಯದ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗೆ ಖಾಲಿ ಇರುವ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಉಲ್ಲೇಖ 1ರ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗದ ಅಧಿಸೂಚನೆ ರೀತ್ಯ ಆಯ್ಕೆ ಆಗಿರುತ್ತೀರಿ. ನಿಮ್ಮ ನೇಮಕಾತಿ ಕುರಿತಂತೆ ದಿನಾಂಕ 16ರಂದು ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲನೆಗೆ ಹಾಜರಾಗಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ಸದರಿ ದಿನಾಂಕವು ನೀವು ದಾಖಲೆ ಪರಿಶೀಲನೆಗೆ ಹಾಜರಾಗಿರುತ್ತೀರಿ. ಆದರೆ ನೀವು ಸ್ಟೇಟ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ವೊಕೇಶನಲ್ ಎಜುಕೇಶನ್ ಜಾಬ್ ಓರಿಯೆಂಟೆಡ್ ಪ್ರಿ ಯೂನಿವರ್ಸಿಟಿ ಡಿಪ್ಲೊಮಾ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸಿ ಕುರಿತಂತೆ ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ಕರ್ನಾಟಕ ಲೋಕಸೇವಾ ಆಯೋಗ ಬೆಂಗಳೂರು ಇವರ ಸರ್ಕಾರದ ಕಾರ್ಯದರ್ಶಿಗಳು ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣೆ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಅವರಿಂದ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಪತ್ರಗಳ ಅಭಿಪ್ರಾಯ ಕೋರಲಾಗಿತ್ತು. ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 4 ಮತ್ತು 5 ಪತ್ರಗಳಲ್ಲಿ ನಿರ್ದೇಶಿಸಿರುವಂತೆ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ ಸೋನ್ಸೋರನ್ವಯ GOCಯನ್ನು PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸುವುದಿಲ್ಲ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಯನ್ನು ನೇಮಕಾತಿಯನ್ನು ರದ್ದುಪಡಿಸಲಾಗಿದೆ. Their grievance is that the job oriented course which I had undertaken pursuant to passing of the 12th is not equivalent to second PUC. At the time of KPSC appointment, the conditions are very clear. They say that PUC or GOC. Kindly see, Mala.
But who has to certify it's an equivalent or not?
The government has issued, sir. I'll take your lordship to the circular also. Government has issued a clarification also thereafter. I'll take your lordship to the circular. And this is at Annexure S, page 146. There are multiple circulars, 2012, 2015, 2019, 2020, all of which have been considered at Annexure S, page 146. I'm sorry. Mulad's got it, Mulad. Karnataka Sarkara ನಡವಳಿಕೆಗಳು. 11th portion is in the next page, page 148. I'll start from the second paragraph. ಮೇಲೆ ಓದಲಾದ ಸಂಖ್ಯೆ 7ರಲ್ಲಿ ಆದೇಶದಂತೆ GOC 2 ವರ್ಷದ ಕೋರ್ಸ್ಗಳು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣಕ್ಕೆ ತತ್ಸಮಾನವೇ ಎಂಬ ವಿಷಯವನ್ನು ನಿರ್ಧರಿಸುವ ಸಂಬಂಧ ನಿರ್ದೇಶಕರು ಪದವಿ ಪೂರ್ವ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಇವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಸಮಿತಿಯನ್ನು ರಚಿಸಿ ಆಯೋಜಿಸಲಾಗಿದೆ. This is ಸಂಖ್ಯೆ number 7. Now kindly see the previous page. ಸಂಖ್ಯೆ number 7 is 2019.
Yes.
And thereafter, ಮೇಲೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 8ರಲ್ಲಿ ಸಮಿತಿಯ ವಿಸ್ತರಣೆಯನ್ನು ಚರ್ಚಿಸಿ ಸಾಧಕ ಬೋಧಕರು ಪರಿಗಣಿಸಿ ಅಭಿಪ್ರಾಯದೊಂದಿಗೆ ದಿನಾಂಕ 24/12/2019 ಈ ಕೆಳಗಂಡ ಸರ್ಕಾರ ಸಭಾ ನಡುವಳಿಕೆಗಳನ್ನು ವರದಿಯನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ಮಾಡಿರುವ ಹಾಗೂ ಈಗಾಗಲೇ ನೇಮಕಾತಿ ಹೊಂದು ಆದೇಶ ನಿರೀಕ್ಷೆಯಲ್ಲಿ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ GOC PUCಗೆ ತತ್ಸಮಾನವೆಂದು ಪರಿಗಣಿಸುವುದು ಹಾಗೂ ನೇಮಕಾತಿ ಸಂದರ್ಭದಲ್ಲಿ ನಿಗದಿಪಡಿತ ಶೈಕ್ಷಣಿಕ ಅರ್ಹತೆ
ಆಗಿದ್ದಲ್ಲಿ PUC ಅಥವಾ GOC ಎಂದು ನಮೂದಿಸುವುದು. There is a government circular on multiple
Is
occasions.
directed to accept notice for response 1 and 2. APSC garu.
KM Prakash.
Mr. KM Prakash is directed to accept notice for respondent
Sinchan
number 3.
appears. Sinchan, Madam Sinchan appears. Yes,
KM Prakash
yes.
normally appears.
Yes.
For respondent number 3. Till the next date of hearing, comma. The
I have not
respondent number.
sought any stay because not asked to report.
Ilva?
No stay.
No, you're not sought for any stay.
No, because they was not asked to report. So if I had reported, then I could have sought for stay.
You should have sought for not to fill up the post of ST.
Because it's a 2012,
Yes.
2022. Plus, if
Yes. Date good.
I say, request this, my lord, short date may be given for this reason.
Yavattu government. List on date. This Girish DS.
March, sir. Serial number 30, Girish.
1 week.
Okay, great.
Girish DS.
My lord, for petitioner. Petitioner was dismissed on 12/11/2024. He is working as a technical assistant at Dharmapura Gram Panchayat, Hiriyur Taluk, Chitrurgarh district.
Odi, please read.
Yes, my lord. Being seriously aggrieved by the orders passed in so and so. Dated 12/11/2024 by dismissing the petitioner who was working as
Read
technical
annexure
assistant.
A.
My lord,
Read annexure A.
annexure. ಮಹಾತ್ಮ ಗಾಂಧಿ ನರೇಗಾ ಯೋಜನೆಯಡಿ ಹಿರಿಯೂರು ತಾಲೂಕು ಧರ್ಮಪುರ ಹೋಬಳಿಯ ಧರ್ಮಪುರ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ತಾಂತ್ರಿಕ ಸಹಾಯಕರಾದ ಶ್ರೀ ವಿಜಯೇಂದ್ರರವರು ನರೇಗಾ ಯೋಜನೆ ಕಾಮಗಾರಿಗಳ ಸಾಮಗ್ರಿ ಬಿಲ್ಲುಗಳು MIS ಮಾಡಿ FTOಗಳನ್ನು ಸೃಜಿಸಿದ್ದು ಸದರಿ 33 ಕಾಮಗಾರಿಗಳ MBಯನ್ನು ದಾಖಲಿಸದೆ ಕರ್ತವ್ಯ ಲೋಪವೆಸಗಿರುತ್ತಾರೆಂದು ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಹಾಗೂ ಸಾಮಾಜಿಕ ಜಾಲತಾಣದಲ್ಲಿ ಹರಿದಾಡುತ್ತಿರುವ ಮೊಬೈಲ್ ರೆಕಾರ್ಡ್ ಕ್ಲಿಪ್ನಲ್ಲಿ ಸಾರ್ವಜನಿಕರಿಗೆ ಮಹಾತ್ಮ ಗಾಂಧಿ ನರೇಗಾ ಯೋಜನೆಯಡಿಯಲ್ಲಿ ರೂಪಾಯಿ 3 ಲಕ್ಷದ ಕಾಮಗಾರಿ ಅನುಷ್ಠಾನಗೊಳಿಸುವಲ್ಲಿ 4% ನಂತೆ 12,000 ರೂಪಾಯಿಗಳಿಗೆ ಹಣದ ಬೇಡಿಕೆ ಇಟ್ಟಿರುತ್ತಾರೆ.
ಯಾಕೆ 40% ಅಲ್ವಾ?
4%.
40% ಕೇಳಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ, ಇದು ದಿಸ್ ಅಲಿಗೇಷನ್. ಇದು ಅಲಿಗೇಷನ್. ಅದು ವಾಟ್ಸಪ್ ನಲ್ಲಿ ದೇ ಹ್ಯಾವ್ ಸರ್ಕ್ಯುಲೇಟೆಡ್. ಅಲ್ಲಿ ಜನ ಎಲ್ಲ ಸೇರ್ಬಿಟ್ಟು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಇದು ಸುಳ್ಳು ಇದು ಆರೋಪ ಮಾಡಿದ್ದಾರೆ ಇವ್ರ ಮೇಲೆ. ಮತ್ತೆ ಮೈಲಾಡ್ ಅವ್ರು 8/11/2024 ನಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್
ಬೇರೆ ಕಡೆ ಕೆಲ್ಸಕ್ಕೆ ಕಳಿಸ್ಲಿ ಬಿಡಿ ನಿಮ್ನ.
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವ್ರಿಗೆ ಎನ್ಕ್ವೈರಿನೂ ಆಗಿಲ್ಲ. ಎನ್ಕ್ವೈರಿ ಆಗದಲೆ
You are an outsourced employee.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
So therefore, if you are not fit to work, you don't work. You are an outsourced employee. You have been provided by some outside agency. ನೀವು ವಾಪಸ್ ಹೋಗಿ, they will send you to some other place.
ಅಲ್ಲ, ಡೆಪ್ಯುಟೇಷನ್ ಕಳ್ಸಿರ್ ನಾವ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು petitioner. ಮೈ ಲಾರ್ಡ್.
Now the Jilla Panchayat does not want you for all the illegalities which you have committed. What is your right to say that, you should be appointed, continued there? You are an outside agency.
ಅಲ್ಲ, they have falsely alleged all the circulations.
ವಾಪಸ್ ಹೋಗಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಷ್ಟೇ. ನಿಮ್ಮ ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾರೆ? ವಾಪಸ್ ಹೋಗಿ. ಕೆಲಸ ಸಿಗೋದು ಕಷ್ಟ. ಸಿಕ್ಕಿದ್ಮೇಲೆ ಗೌರವವಾಗಿ ನಡ್ಕೋಬೇಕು.
2016 ಇಂದನೂ ವರ್ಕ್ ಮಾಡಿದ್ದಾರೆ.
ಕರೆಕ್ಟಪ್ಪ. The allegation is that ಅಂದ್ರೆ
ಅಲ್ಲ,
ರೂಪಾಯಿ ಕೆಲಸ ಮಾಡಿದ್ರೆ 1,000 ರೂಪಾಯಿ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ. And you will be part of it. MB is a basic document. MB ನಲ್ಲೇ ನೀವು ಎಂಟರ್ ಮಾಡ್ತಿದ್ರೆ ಎಷ್ಟು ಮಣ್ಣು ತೆಗೆದ್ರು. Suppose if it's an earthwork, this is a ಮಹಾತ್ಮ ಗಾಂಧಿ ತಾನೆ.
ಹೌದು ಸರ್.
ಮಹಾತ್ಮ ಗಾಂಧಿ ಕೇಸಲ್ಲಿ ಮಣ್ಣು ತೆಗಿತಾರೆ. ಎಷ್ಟು ಅಡಿ ತೆಗ್ದಿದ್ದಾರೆ ಅಂತ ನೀವು ಎಂಟರ್ ಮಾಡಿದ್ರೆ ನಾಳೆ 20 ಅಡಿ, 30 ಅಡಿ, 40 ಅಡಿ, 50 ಅಡಿ ಎಷ್ಟು ಬೇಕಾದ್ರೂ ಆಗ್ಬೋದಲ್ವ? ತೆಗ್ದಿರೋದು 1 ಅಡಿ, ಕ್ಲೈಮ್ ಮಾಡೋದು 30 ಅಡಿ. MB ಖಾಲಿ ಇಟ್ಟಿದ್ದೀರಿ, ನಾಳೆ 30 ಅಡಿ ಬರೀತೀರಿ. ವಾಟ್ ಇಸ್ illegalities? ಬರ್ಕೊಳ್ಳಿ. Should know how to maintain your job. ಕೆಲಸ ಸಿಕ್ಕಿದಾಗ ಅದನ್ನ ಕಾಪಾಡ್ಕೊಳ್ಳೋ ಜವಾಬ್ದಾರಿ ನಿಮ್ದು. The petitioner is challenged an order dated 12/11/2024 by which by which his services was terminated. Next para. The petitioner the respondent number one, in the course of implementation of the Mahatma Gandhi National Rural Employment Guarantee Scheme, invited applications from manpower providing agencies for various posts in Chitradurga district. Full stop. Accordingly, the petition was referred by the respondent number 4 to the respondent number 1. Full stop. The petitioner contends that the respondent number contends that the Commissioner of Rural and Panchayat Raj Department, Commissioner Henry, Secretary Alva, the Secretary of Rural and Panchayat Raj Development formed a committee to inspect the material bills with regard to certain work allotted under the Mahatma Gandhi Narega scheme. Full stop. The petitioner was issued with a show cause notice dated 2/5/2024 to explain his carelessness concerning 40 projects while preparing the material bills. Stop. The petitioner seems to have submitted his reply stating that in every project measurement book, the SMR andreno, what is SMR amount? Paragraph number 6 of the writ petition, the SMR amount andreno. Para 6 of the writ petition, Mr.
Yes, my lord.
SMR amount andreno. Huh? What is SMR? What is FTO?
SMR
Sumoto
revision.
Huh?
Special mandatory redemption.
Special mandatory
Redemption.
ಏನಂಗಂದ್ರೆ
It's a technical word.
ಟೆಕ್ನಿಕಲ್ ವರ್ಡ್ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ನಿಮ್ ಮನ್ಸಿಗೆ ಬಂದಾಗ ತಿಳ್ಕೊಬೇಕಲ್ವ ಏನು ಅಂತ.
My lord.
Stating that in every project measurement book, the special mandatory redemption amount was mentioned, and after verification, it was uploaded in the Google form. Full stop. The respondent number 3 thereafter issued an office order dated 24/5/2024, deputing various technical staff to different places. Full stop. Accordingly, the petitioner was also deputed to take charge of Aimangala, Hartikote, and Gannanaikanahalli Gram Panchayats, lying in Hirur Taluk. Full stop. The petitioner stated that he had not committed any error, any mistake while implementing the project and was not negligent. Full stop. The petitioner thereafter submitted a request to the respondent number 1 to transfer him from Hiriyur Taluk to Chitradurga Taluk. Full stop. The respondent number 3 was thereafter deputed the petitioner to take charge of Harti Kote, Hosa Yelnadu and Yarballi Gram Panchayats in Hiriyur Taluk. Full stop. While the petitioner was working at Harti Kote, he was served with a show cause notice dated 8/11/2024, calling for an explanation regarding certain audio clips that was circulated in the social media, where the petitioner had laid a demand for 4% of the contract value in respect of a work allotted to a contractor. Full stop. The petitioner submitted his explanation and denied the charges. Full stop. Thereafter, the petitioner submitted a request to the respondent number 1 and 2 to permit him to work, which was followed by permit him to work. However, the respondent number 1 was terminated by the impugned order. Being agreed by the same comma, the petition is before this court. The learned counsel for the petitioner contends that the termination of the petitioner is on the ground that the petitioner had failed to carry out certain entries in the measurement book, and that he had made a claim for 4% for implementation of 4% for processing the bills in respect of a contract for a value of rupees 3 lakhs. Full stop. He therefore contends that the respondents must have conducted a semblance of an inquiry before brandishing the petitioner. Full stop. He also contends that the petitioner was not guilty of any misconduct or any negligence in duty, and therefore the impugned order is illegal, colorable, and has to be set at naught. Next para. The petitioner was deputed by the respondent number 4 to work at the office of the respondent number 2 and 3, 1, 2, and 3. So the petitioner was deputed to work at different places in Hiriyur Taluk. So it appears that the respondents came to know of certain let-ups and lapses in the performance of duties by the petitioner. They also came to know about a demand made by the petitioner from a contractor to process his bills. The respondent number 1 has therefore passed the impugned order terminating the service of the petitioner and handing him back to the respondent number 4. Full stop. The petitioner is not appointed on a regular basis, and therefore, but is through a manpower supplying agency. Full stop. If the respondent number 1 is not satisfied with the work done by the petitioner, the respondent number 1 is always entitled to return the services of the petitioner to the respondent number 4. This is precisely what is done by the respondent number 1 by passing the impugned order. Therefore, there is no error warranting interference with the impugned order. Hence, the writ petition is dismissed.
For 31, Silpa Rani.
Teacher, Mala, social science teacher in respondent number 2, Karnataka Residential Education Institution Society, Mala. Since from 2009, my lord, he is working in the said institution, my lord. His service certificate, my lord, Annexure A, my lord. And he have filed for the regularization, my lord. He have filed the repetition number.
Price yaar Siddharth Baburov. Siddharth Baburov.
Please, ma'am.
AJ's director accept notice for respondent 1, Siddharth Baburov for respondent number 2. Till the disposal of this writ petition, comma, the respondent number 2 shall not disturb the petitioner disturb services of the petitioner as a social teacher
Social science teacher.
at Morarji Desai Residential School, Begur, SC-135, Sringeri Taluk, Chikmagalur District. Yes, list on date good.
4th April.
Shashank.
Serial number 32, Shashank K.
Yes. Shashank.
Petitioner applied for the Anganwadi teacher, my lordship. And the 4th appointment has selected the petitioner for the same through provisional order dated 14/9/2021 and call for objection. That is page number 45, much. 45. But nobody has filed objection to the same.
45.
45. Is the type copy. But nobody has filed objection.
This is a provisional list, huh?
This is provisional list. Subsequently, my lordship, the 4th appointment has one more provisional list, one more, they have one second. It is page number 49, my lordship. 49. They have issued one more provisional list. In the list, my lordship, they have deleted this petitioner and inserted the name of the 6th respondent. Page number 49, my lordship. Subsequently, my lordship, for this, the petitioner consented to file a writ petition.
Did you file objections to this?
I have filed objection, my lordship.
Where is the objection?
Annexure K. Annexure K, my lordship. Page number 51. This is my objection.
ಓದಿ ಏನ್ ಹೇಳ್ತೀರ?
ಮೇಲ್ಕಡೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುವುದೆಂದರೆ ನಾನು ಗಿಣಿಗಲ್ಲು ಗ್ರಾಮದ ಅಂಗನವಾಡಿ ಕ್ಷೇತ್ರದ ಶಿಕ್ಷಕಿ ಹುದ್ದೆಗೆ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಅಂತೆಯೇ ಮಾನ್ಯ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಮತ್ತು ಯೋಜನಾ ಇಲಾಖೆ ಮತ್ತು ಆಯ್ಕೆ ಪ್ರಾಧಿಕಾರ ಕಮಿಟಿಯಿಂದ ನನ್ನನ್ನು ಪರಿಗಣಿಸಿ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿ ನನ್ನ ಹೆಸರನ್ನು 14/9/21 ಬಿಡುಗಡೆ ಮಾಡಿರುತ್ತೀರಿ. ಹಾಗೂ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಮಾನ್ಯ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಉಳುಗೋಡು ಅಂಗನವಾಡಿ ಕೇಂದ್ರ ಉಳುಕೊಪ್ಪ ಗಿಣಿಕಲ್ಲು ಅಲ್ಲಿಯೂ ಸಹ ಕೂಡ ಪಟ್ಟಿಯನ್ನು ನೋಡಿ.
Within 3 kilometers from the panchayat ಮಾಡ್ಬೋದಲ್ಲ?
But I am a local head manager. I am
You might
residing.
be local, but within 3 kilometers ಮಾಡ್ಬೋದು ಅಂತ ಇದೆಯಲ್ಲ
They
notification.
are residing in.
ನಿಮ್ಗೆ ಅವ್ರಿಗೆ ಮೆರಿಟ್ ಯಾರಿಗಿದೆ ಜಾಸ್ತಿ?
No, they are panchayat, separate panchayat.
ಆಯ್ತಪ್ಪ, ಮೆರಿಟ್ ಜಾಸ್ತಿ ಯಾರಿಗಿದೆ? ಮೆರಿಟ್ ಯಾರಿಗೆ ಜಾಸ್ತಿ? ಅವ್ರಿಗೆ. Within 3 kilometers ಅಲ್ಲಿ ಮಾಡ್ಬೋದು ಅಂತ ಇದೆಯಲ್ಲ notification.
But my one submission.
If a person.
But they have not filed objection.
For what?
For provision list. They are not filed in
That's
objection.
okay. If a person is more meritorious and if she is residing within 3 kilometers from the Anganwadi, she could be considered on Tidiyala.
The village is separate village. 3 kilometers there, but village is
Correctappa, nim village yavadu?
Ginikallu, same village.
Huh?
Ginikallu.
Inikallu.
Same village.
Same village. Village ಹೆಸರೇನು?
Ginikallu.
Ginikallu. ಪಂಚಾಯತ್ ಇದು ಅಂಗನವಾಡಿ ಇರೋದು ಯಾವ ಊರಲ್ಲಿ? ಗಿಣಿಕಲ್ಲು. ಯಾವ ಊರಿಗಿರೋದು ಅಂಗನವಾಡಿ ಅದು?
ಮಾಸ್ತಿಕಟ್ಟೆ.
ಎಷ್ಟು ಊರಿಗಪ್ಪ ಅಂಗನವಾಡಿ ಇರೋದು? ಒಂದೇ ಊರಿಗ? ಒಂದೇ ಊರಿಗೆ. Are you sure?
Are you sure? Yes. I am residing in Ginikallu only. But she is residing in Mastikate.
Where is the notification?
Annexure G, my lordship.
ಓದು.
This is the criteria, my lordship. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕ ಸಲ್ಲಿಸಲು 18-30 ವರ್ಷ ವಯೋಮಿತಿ ಒಳಗಿರಬೇಕು. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕರು ಆಯ್ಕೆಗೆ ಸ್ಥಳೀಯರಾಗಿರಬೇಕು. ಇದು ಕಂಡೀಷನ್, my lordship.
ಎಸ್ ಓದಿ.
Second condition. ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಸಹಾಯಕರ ಆಯ್ಕೆ ಸ್ಥಳೀಯರಾಗಿರಬೇಕು.
ಪೇಜ್ ನಂಬರ್
32, my lordship. Is a condition to selection.
ಓದಿ ಯಾವ್ದು ಏನ್ ಕಂಡೀಷನ್?
And second condition, ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತ ಸಹಾಯಕರ ಆಯ್ಕೆ ಸ್ಥಳೀಯರಾಗಿರಬೇಕು. This is condition, my lordship.
ಕಂಡೀಷನ್ ನಂಬರ್
2,
ಸ್ಥಳೀಯರಾಗಿರಬೇಕು.
ಸ್ಥಳೀಯರಾಗಿರಬೇಕು.
ಹಾ.
Actually, I am also localite, my lordship. I am residing in the same village. Same panchayat.
2014, mister.
Yes, my lordship.
Subsequent to them, notifications are issued. 2015 or 18 ಅಲ್ಲೆಲ್ಲ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ within 3 kilometers ಅಂತ. ಅದ್ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ನೋಡ್ಕೊಂಬಂದ್ ಹೇಳಿ.
Tomorrow.
List tomorrow. Learn counsel for the petition seeks time, list tomorrow. ಪರಮೇಶ್ವರಯ್ಯ.
Yes, a paper.
ಹಾ.
My lord, if your lordship permits, my lord, I may permit it to file my statement of. Followed by decision of dismissal court order.
ಇದೆ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ತಗೊಳ್ತೀರಾ?
ತಗೊಂಡಿದ್ದಾನೆ.
ತಗೊಂಡಿದ್ದೀರಾ?
Please, my lord, they have taken the contention, my lord, only. They are relieved and then he take a.
First ನಿಮ್ ಕೇಸ್ ಏನು ಅಂತ ಹೇಳ್ರಿ.
Please.
Taken a contention.
Challenge the annexure G, my lord, page number 21. Read, my lord, short order, my lord, 1/3/2025 order, my lord. ಪ್ರಸ್ತಾವನೆ ರಾಷ್ಟ್ರೀಯ ಶಿಕ್ಷಣ ಸಮಿತಿ ರಿಜಿಸ್ಟರ್ ಶಿವಮೊಗ್ಗ ಈ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ HSR ರಾಷ್ಟ್ರೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಶಿವಮೊಗ್ಗ ಈ ಕಾಲೇಜಿನ ಪ್ರಾಂಶುಪಾಲರಾದ ಶ್ರೀ ಎಸ್ ಚೆನ್ನಪ್ಪ ಇವರು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ 7/10/24 ರಾಜೀನಾಮೆ ನೀಡಿರುವುದನ್ನು ದಿನಾಂಕ 29/10/24 ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆಯಲ್ಲಿ ಸರ್ವಾನುಮತದಿಂದ ಅಂಗೀಕರಿಸಿ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಯಲು ಅನುಮತಿ ನೀಡಲು ನಿರ್ಣಯಿಸಿರುತ್ತಾರೆ. ಈತನ್ಮಧ್ಯೆ ದಿನಾಂಕ 28/11/24 ಆಡಳಿತ ಮಂಡಳಿಗೆ ಮಾಡಿರುವ ಮನವಿಯಲ್ಲಿ ಸದರಿಯವರು ದಿನಾಂಕ 7/10/24 ನೀಡಿರುವ ಮನವಿಯನ್ನು ಹಿಂಪಡೆದು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಯಲ್ಲೇ ಮುಂದುವರಿಯಲು ಅನುಮತಿ ನೀಡಲು ಕೋರಿರುತ್ತಾರೆ. ಅದರಂತೆ ಈ ಕಚೇರಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಈ ಸಂಬಂಧ ಉಲ್ಲೇಖ 2 ಪತ್ರದಲ್ಲಿ ವಸ್ತುನಿಷ್ಠ ವರದಿಯನ್ನು ಜಿಲ್ಲಾ ಉಪನಿರ್ದೇಶಕರ ಮೂಲಕ ನೀಡಲು ತಿಳಿಸಲಾಗಿತ್ತು. ಅದರಂತೆ ದಿನಾಂಕ ಉಲ್ಲೇಖ 1 ಜಿಲ್ಲಾ ಉಪನಿರ್ದೇಶಕ ವರದಿಯಲ್ಲಿ ಚೆನ್ನಪ್ಪ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ರಾಜಿಯನ್ನು ಅಂಗೀಕರಿಸುವಂತೆ ಪುನರ್ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಎಸ್ ಚೆನ್ನಪ್ಪ ಪ್ರಾಂಶುಪಾಲ HSR ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಶಿವಮೊಗ್ಗ ಇವರು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಯಲು ಕೋರಿರುವ ಮನವಿಯನ್ನು ದಿನಾಂಕ 30/12/24 ನಡೆದ ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ರಾಜೀನಾಮೆಯನ್ನು ಹಿಂಪಡೆಯಲು ಅವಕಾಶ ನೀಡದೆ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಲು ಕೋರಿ ಜಿಲ್ಲಾ ಉಪನಿರ್ದೇಶಕರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಮಾನ್ಯ ಶಿಕ್ಷಣ ಸಚಿವರು ಆಡಳಿತ ಮಂಡಳಿಯ ನಿರ್ಣಯದಂತೆ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಅಂಶಗಳನ್ನು ಪರಿಸಿ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ. ರಾಷ್ಟ್ರೀಯ ಶಿಕ್ಷಣ ಸಮಿತಿ ರಿಜಿಸ್ಟರ್ ಶಿವಮೊಗ್ಗ ಈ ಸಂಸ್ಥೆ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ HSR ರಾಷ್ಟ್ರೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಪ್ರಾಂಶುಪಾಲ ಚೆನ್ನಪ್ಪ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಆಡಳಿತಾತ್ಮಕ ಹಿತದೃಷ್ಟಿಯಿಂದ ಅಂಗೀಕರಿಸಿ ಸದರಿಯನ್ನು ಭೂಗೋಳಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕ ಮುಂದುವರಿಯಲು ಅನುಮತಿ ನೀಡಿ ಆದೇಶಿಸಿದೆ. In this case, my lord, the annexure.
22 ಏನೋ ಇರ್ಬೇಕಲ್ಲ, it should be certified by.
Please, my lord, they have produced the citations, my lord. This honorable court, my lord, passed the order.
Jump to citation, what is the provision relating to resignation?
The
First ಅದನ್ನ ಓದಿ, ಆಮೇಲೆ citation ಹೋಗಿ. ನೋಡ್ರಿ ಅದು Education Act.
Education Act 97, my lord, only
ಏನ್ ಹೇಳುತ್ತೆ?
regarding resignation is concerned, my lord.
Go to section 97(2).
Please, my lord.
What does it say?
Any employees. 1983 Act, my lord, Education Act. Resignation, my lord. Any employee or a private education institution may resign from his service by giving a notice to the governing council in accordance with the sub-rule 2. Every such notice is resignation shall conform to the term and conditions of service governing such employees and be in the prescribed form attested by an officer duly authorized in this behalf by the state government.
ಆಗಿದೆಯಾ ಅದು? 97(2).
Subsequently, they have accepted, my lord.
Mr. ಇನ್ನೊಂದ್ ಸತಿ ಓದಿ 97(2)(b) ನ.
Please, my lord.
ಓದಿ.
Be in the prescribed form attested by the officer duly authorized in this behalf by the state government.
97(3) ಓದಿ ಇವಾಗ.
3, my lord, no resignation which is not in accordance with subsection 2 shall be valid. Be or be of any effective whatever. My lord, before the acceptance by the department, my lord, the petitioner, my lord, has immediately filed the one more application, my lord, for withdrawal of his resignation.
ಅಲ್ರಿ ಅಲ್ಲಿ ಇರೋದೇನು ನೀವ್ ಹೇಳ್ತಿರೋದೇನು ನಾನ್ ಕೇಳ್ತಿರೋದೇನು
Please, my lord.
ನಿಮ್ಮ ರೆಸಿಗ್ನೇಷನ್ ನ
Please.
ಇಸ್ ಇಟ್ ಬೀನ್ ಡ್ಯೂಲಿ ಆಥರೈಸ್ಡ್ attested by a officer duly authorized by
The state government.
ಮಾಡಿದ್ಯಾ
Illa. That's why, my lord.
ಅಷ್ಟೇ ಅಂದ್ರೆ ನೀವು
That's why I am.
ಅಂತ ಹೇಳ್ತಿದ್ದೀರಿ.
That's why I am stated then, and then, my lord, similar matter, my lord.
My lord, it is a resignation, my lord, to the post of principal. My lord, he wanted to continue as a lecturer. My lord, that was placed before the governing council. It was accepted,
All
then
right.
it was sent for
If it is
approval.
not in accordance with section 97(2)(b),
My lord, my submission is this, my lord, that 97, my lord, the rider is put to see that, my lord, it is, the management should not extract resignation under pressure. My lord, this is not a resignation to the employment. My lord, he has said it is given voluntarily. Then, my lord, in the withdrawal also, he says that, my lord, now his family problems are over, so he intend to withdraw. There is no element of pressure. There is no allegation, my lord, against the management.
yes.
Management immediately accepted that, my lord. After acceptance, he comes and says, I may be permitted to withdraw it.
When did he give the request for withdrawal?
My lord,
What
may,
is it?
may just file my objections, my lord. I have stated all that.
Good, told.
My lord,
Annexure C is the first.
ಹೇಳಿ ಅವ್ರು ಹೇಳ್ತಾರೆ.
Please,
Your resignation letter is 710,
please, my lord.
24.
my lord, your lordship may kindly turn to page 9, my lord, of the objection, annexure R32.
R32.
ಹೌದು, ಪೇಜ್ 9 ಸ್ವಾಮಿ. ದಿನಾಂಕ 29/10/2024 ಮಂಗಳವಾರ ಸಂಜೆ 4 ಗಂಟೆಗೆ ರಾಷ್ಟ್ರೀಯ ಶಿಕ್ಷಣ ಸಮಿತಿ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ನಡೆದ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸಭೆ ನಡವಳಿಕೆಯ ಉದಾಹರಣ. ಶ್ರೀ ಸೋ ಅವರು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಯ ಕರ್ತವ್ಯಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿ ತನ್ನನ್ನು ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿರುವುದನ್ನು ಸದರಿಯವರು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸುವ ಬಗ್ಗೆ ನಿರ್ಣಯ. ಸೋ ಈ ಕಾಲೇಜಿನ ಪ್ರಾಂಶುಪಾಲರಾದ ಶ್ರೀ ಚೆನ್ನಪ್ಪ ಇವರು ತಮ್ಮ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಯ ಕರ್ತವ್ಯಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡಿ ತನ್ನನ್ನು ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಸುವಂತೆ ಕೋರಿರುವುದರಿಂದ ಸದರಿಯವರು ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕರಿಸಿ ಉಪನ್ಯಾಸಕರ ಹುದ್ದೆಯಲ್ಲಿ ಮುಂದುವರಿಯಲು ಅನುಮತಿ ನೀಡಲು ತೀರ್ಮಾನಿಸಿದೆ. ಮೇಲ್ಕಂಡಂತೆ ಶ್ರೀ ಎಸ್ ಚೆನ್ನಪ್ಪ ಅವರು ತಮ್ಮ ಪ್ರಾಂಶುಪಾಲರ ಹುದ್ದೆಗೆ ನೀಡಿರುವ ರಾಜೀನಾಮೆಯನ್ನು ಅಂಗೀಕಾರಕ್ಕಾಗಿ ಇಲಾಖೆಗೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ಅಧಿಕಾರ ನೀಡಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಇದಾದ ನಂತರ ಸ್ವಾಮಿ ಅವರು he submitted an application, my lord, to withdraw it as per annexure E, my lord.
Annexure?
E, page 18, writ petition ನಲ್ಲಿ.
ಯಾವತ್ತು?
ಅದು 28/11/2024. ಇದು ಆಲ್ಮೋಸ್ಟ್, ಮೈ ಲಾರ್ಡ್, after about a month.
ಯಾವತ್ತು ಅಕ್ಸೆಪ್ಟ್ ಆಯ್ತು ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ?
ಗವರ್ಮೆಂಟ್ ಇಂದ, ಮೈ ಲಾರ್ಡ್, annexure
1/3/2025, page number 21.
Yes.
ಆಮೇಲೆ, my lord, voluntarily he got relieved. He gave the charge, my lord, to the senior most lecturer.
Did you hand over charge?
Please,
Huh?
because of, my lord, they have on 7/3, the writ petition is come up before the Sabha court on 7/3, my lord, at 2:30. Before that, my lord, they have served the order passed by the management, pressurize the petitions, my lord. Then the same day, my lord, on 7/3, he has hand over to charge, my lord.
ಅಲ್ರಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರೆ ಪ್ರೆಷರೈಸ್ ಹೆಂಗೆ? ಲಾಯರ್ನ ಕೇಳಲ್ವಾ?
Please, my lord, but
ಲಾಯರ್ ಕೇಳ್ದಂಗೆ they yielded to the pressure.
in local, my lord.
Huh?
Local, my lord.
ಏನ್ ಲೋಕಲ್?
And
ಲಾಯರ್ ಇಟ್ಟಿದ್ದಾರೆ, ಲಾಯರ್ ಇಟ್ಟ ಮೇಲೆ ಪ್ರೆಷರೈಸ್ ಮಾಡಿ ಹೆಂಗ್ರಿ ಚಾರ್ಜ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡುತ್ತೆ?
then, my lord, this Sabha court, my lord, the same contention raised by the
ಅವರೇ
similar-
ಟೈಪ್ ಮಾಡಿಸಿ
in
ತಂದು
similar.
ಕೊಟ್ಟಿದ್ದಾರೆ.
You have to challenge it before the concerned authority, 131.
Please, my lord, but here, my lord, the similar circumstances, my lord, kindly see the order passed by the Sabha court, my lord, in WP number 22/556 of 2023. Earlier occasion, I had.
Whether in that case,
Same is,
charge was handed over,
please, madam. And then they have taken the contention matter, hand of
WP number,
writ petition number 22556 of 2023. Court of Session.
ಇದೆ ಓದಿರಿ.
Please, madam.
ಹಾ.
Fourth para, my lord.
ಹ್ಮ್.
These, sorry, my lord. Second para, my lord. The second respondent by the impugned order dated 14/1/2022 has informed the third respondent that the petitioner's resignation is accepted and therefore he must be relieved, and consequently the third respondent has relieved the petitioner, giving additional charge to the post of another employee. In this case also, my lord, given the,
So why did you hand over charge?
because of, my lord, that's why, my
Why
lord,
did you hand over charge?
pressure is, my lord,
ಮತ್ತೆ ಹಂಗಾರೆ 131 ಬನ್ನಿ, ಎಜುಕೇಶನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ. ಪ್ಲೀಸ್ ರೀಡ್ 131.
one 30, my lord.
131.
One 31, my lord, review any application from any person interested by themselves as to the regularity, correctness, legality, and propriety of any decisions or order passed therein. And if in any case it appears to the state government that any such decisions or order should be modified, nullity or reversed and remitted for reconsideration, they may be passed order accordingly. Please, my lord, before, my lord,
ಹೋಗ್ಬೇಕಲ್ಲ ನೀವು.
I can understand, my lord. Before that, my lord, the petitioner approached the Samal court, my lord.
Mr. What was ಈ ಕೋರ್ಟ್ ಬಂದಾಗ
Please,
ನಿಮ್ಮ ರಾಜೀನಾಮೆ ಅಂಗೀಕಾರ ಮಾಡಿದ ಯಾವುದು? ನ್ಯಾಷನಲ್ ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ, ವಿಚ್ ಇಸ್ ನಾಟ್ ಎ ಸ್ಟೇಟ್.
please.
That is not a state.
At the, this is, my lord, the order passed by the director, my lord, annexure, impugned order annexure, 21, my lord, page number G, my lord.
ಹೌದಪ್ಪ, that is 1325.
13/20/25,
So where should you challenge this order?
director order, my lord.
Where should you challenge it?
Please, my lord.
Huh?
Before that, my lord,
ಅಲ್ಲಿ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು?
applicable order,
ಮತ್ತೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಲ್ವಾ?
but before that, my lord, he submitted the resignation, my lord. In same circumstances, my lord, the Honorable Supreme Court, my lord, kindly see the judgment of the Honorable Supreme Court, my lord. The appellate authority, my lord, raised the same question, my lord, in the civil appeal number 1480 of 2012, my lord, decided on 22/2024, my lord.
What?
Please, my lord.
So this is a University of Mumbai. This is a University of Mumbai, so therefore writ petition is maintainable. National Education Society, how is writ petition maintainable?
Marwadi Saleman through its secretary to another, my lord.
The said writ petition was filed by the appellant being agreed by an order dated so and so passed by the Mumbai University and College Tribunal, Mumbai.
Please, my lord.
So writ petition is maintainable.
Please, my lord.
How is a writ petition maintainable against National Education Society?
This is also, my lord, the private respondent, my lord, they have filed the appeal before the authorities, my lord.
ಹೌದು, ಟ್ರಿಬ್ಯುನಲ್ ಮುಂದೆ.
Tribunal, they have appeal.
ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ.
Please, my lord, the tribunal, my lord, hold that it is.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ, 131 ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Pass over.
34, Leela P. Devadiga.
ಮೇಡಮ್ ಇದು The learned counsel for the respondent number 3 has filed a statement of objections. The same is taken on record. Order sheet Almadi. Yes. Leela Adiga, Dev Adiga.
Yes, Your Lordship, I appear for petitioner. Your Lordship, in this matter,
IA
Your Lordship,
125 is allowed. Yes. IA
Your-
125 is allowed. Writ petition is not allowed.
yes,
madam.
please. Your Lordship, in this matter, Your Lordship, I sought for a direction to publish the seniority list. Your Lordship, because I am working as a professor. In the year 2017, Your Lordship, combined list was published, which was silent before this honorable court. And this honorable court quashed those combined lists. Thereafter, directed them to consider 5 most senior. Your Lordship, kindly see the order at page number 174, annexure R. And relevant portion available at 206, my lord. The writ petitions are allowed in part. It is hereby declared that two impugned final combined seniority list dated so and so shall not be taken into consideration for the purpose of appointment to the administrative post of the First Respondent Institute. The Governing Council of the First Respondent Bangalore Medical College and the Research Institute is hereby directed to consider the 5 senior most professors in various specialties or categories on the basis of merit list furnished by the KPSC to the government and on the basis of which the appointment orders were issued to the petitioners and the respondent herein. Pursuant to this order, Your Lordship, what happened is respondent, they issued a draft list that is available at page number 212, annexure G. Perhaps, Your Lordship, that this order was challenged before the divisional bench of this honorable court, but there was, as on today, Your Lordship, there is no order of stay. And the draft notice list is issued at page number 212. And there is a reference to the order passed by this honorable court at second para.
Yes.
And then, Your Lordship, page number 214 is the list. Draft
Yes.
list. Your Lordship, because we are appointed by the KPSC in the year 1991. And some of them are appointed in the year 1997. And thereafter, Your Lordship, in the year 2017, we have been promoted as professors. In spite of that, Your Lordship, my name was not shown in the draft list. Thereafter, without issuing the final list, Your Lordship, now the application is called for the post of director cum dean. That is available at page number 220, my lord, annexure J. Prior to the issuance of final list, Your Lordship, they have issued the call for the invitations from the eligible candidates. Now, Your Lordship, unless the seniority list is issued, Your Lordship.
Yes, government purport.
I take notice for R1, Your Lordship.
AGA is directed to accept notice for respondent number
1.
Respondent number 1. What about BMC? Yaar is that?
Earlier,
Sumana.
Suman Baliga used to appear, Your Lordship. I don't.
Sumana Baliga.
No, I don't think madam is not appearing now.
It doesn't appear.
No. I asked her in the morning.
BMRCL.
I think Abhishek Malli Patil.
K. Krishna is directed to accept notice for respondents 2 and 3. Since it is stated by the learned counsel for the petitioners,
Yes, Your Lordship.
that the respondent number 2, without finalizing the seniority list of professors or
the professors.
associate,
Professors.
seniority list of professors as per the direction of this court in WP number 8306 of 2020, connected with WP number 14144 of 2018. And that respondent number 2 has notified, has issued a notification, as respondent number 2 has issued a notification inviting candidates with 10 years teaching experience as professor / associate professor for the post of director, the said notification reserves to be stayed till the next date of hearing.
Your Lordship, I am not for stay of the.
Not sought for stay.
No. Why? Because there is another petition is pending, which is being disordered. This notification is stayed.
Not to take anything.
I am only seeking because.
What is this interim order that you have sought for, madam?
Yeah, because they are relying on the, it is brought to my knowledge that because they are relying on the draft seniority list, they cannot rely on that. Unless the seniority list is issued, your lordship, they cannot even publish the notification inviting
But you
application.
refer to some final seniority list published on 6/3/23. You also mentioned about
Yes,
the
Your-
final seniority list dated 6/3/23.
That's, my lord, it's a draft seniority list. In fact, final seniority list.
You have mentioned about the draft seniority list in the interim prayer and also the final seniority list.
Yes, your lordship.
ಇದರಲ್ಲಿ ಯಾವ್ದು
Final seniority list also they have published, they have uploaded in the website. But in fact, that is not based on the order passed by this honorable court. This honorable court has said that they allow to pass issue the seniority list based on the appointment order.
Yes.
But this, in fact, this is issued subsequent to the notification. This is on 13/2025, Annexure H, your lordship, kindly see, 2015.
Now, where is the seniority list according to you, which is the draft?
Draft is available at 214, my lord.
214.
214.
What is 215 then?
Then 215 is they say that it is the final list. But this is issued subsequent to the notification, my lord, not prior to that. This is on 13/2025. They can't rely on this, my lord. And this is also based on the speciality. They are divided into categories.
Correct. Recruitment is 1910.
Yes, your lordship. Prior to that.
Were you not eligible as an associate professor?
My lord, I am very much eligible because the lordship may kindly see the annexure.
Madam, professors or associate professors can
Professor,
also,
I am professor. Right now I am professor, my lord.
if you have 10 years teaching experience,
Your
you
lordship,
can also apply.
Your lordship, I have applied because because the government is not, one thing is there is a stay up in another matter. Unless my contention is, your lordship, unless the final seniority list is issued, they cannot finalize the procedure.
Why?
Because they'll have to, in terms of the order, they'll have to issue the.
Every person who is in the post of a professor
Yes, your
or
lordship.
an associate professor who's put in 10 years of teaching experience can apply.
Yes, your lordship.
If you are a professor with 10 years teaching experience, you
Yes,
can
sir.
apply.
No, I applied.
You applied.
Yes, your lord, I
But-
applied. Because my concern is like they'll have to issue seniority list because they'll
So
see.
why
the
is,
seniority
how
list.
are you linking seniority with application to the post of director? Anybody can apply who has put in 10 years.
But they'll see the seniority list, your lordship.
Yes. ಅದು ಹೊಡೆದಾಕಿದನು ಅದು ಹೊಡೆದಾಕಿದನು. The apprehension of the petitioner is that the respondent number 2 has published a notification dated 19/10/2024 inviting applications to the post of director cum dean. Full stop. Dean, and that the respondent number 2 is likely to rely upon the seniority list of professors, which is not in sync SYNC with the order passed by this court in WP numbers also. WP number 8306 of 2020 connected with WP number 14144 of 2018. Full stop. She therefore contends that the seniority list finalized by the respondent number 2 should not be taken into consideration for the purpose of recruiting to the post of director.
Come dean.
Full stop. In view of the aforesaid submission, comma, the what has happened to the writ appeal?
Writ appeal is pending, my lord.
No interim order is passed?
No, your lordship. This impugned order is not stayed.
Or is there any order passed in writ appeal?
In fact, pursuant to the application, pursuant to the notification, your lordship directed the parties there to apply for the post.
In view of the above, comma, any selection to the post of director cum dean of the respondent number 2 shall be subject to the result of this petition.
I request for a date, your lordship. If the seniority list is concluded, my lord, then
Madam, seniority ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. You are unnecessarily bringing in a connection
no,
between.
because there is a communication between, I can't rely on those documents. There is a communication
Seniority
between
ಇದಕ್ಕೆ
the,
ಸಂಬಂಧನೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು.
no, there is a communication between the departments and the state government, that because they cannot, they'll allow to rely the
Yes.
notification, draft seniority list.
ಹನುಮಂತಪ್ಪ ಹರವಿಗೌಡ.
I'm for the petitioner, my lord. My lord, the petitioner is seeking writ of mandamus against the fourth respondent, my lord, shall consider the to implement the on judgment of the court, my lord, in OS number 287 of 2011, the passed by so the court, my lord, regarding so the treating so the petitioner as the legally wedded wife of so his husband Subramanian, late, my lord. The suit was decreed, my lord, on 24/1/2024. Annexure A, my lord, the page number 47, 46, page number. Order made, sir. The suit of the plaintiff is hereby decreed with the cost made. Page number 46, my lord, 46, Annexure A. It is
This is an ex parte decree.
46, my lord, page number 46.
This is an ex parte decree.
Please, my lord.
Ex
No,
parte.
not expert, not it is. After hearing all the parties, so decreed, my lord. Not expert, my lord. Contesting parties.
ಯಾರ ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಯಾರು ಇದ್ದಾರಲ್ಲಿ?
Private parties only, not her husband. Husband, the pendency of the suit, he died. A loss brought on record. Page number, my lord, 18. Subramaniam. Page number 18, my lord, 18.
Yes.
Subramaniam, who died dependency of the suit, my lord. He is a loss brought on record, 8, 9, 10. My lord, the 11th defendant is said to be the second wife of so the late 7th defendant, my lord. But she has not filed objections, my lord. Can you see, my lord, the fair in the honorable court has made the categorical observation. Page number 45 of the judgment, my lord, is
Yes.
50, my lord, page number. The defendant number 7, 11, if one after appearance has not contested the case by filing written statement to or by the adducing evidence, my lord, she appeared not to find objects.
To be implemented.
Either direction to the
ಅಲ್ಲಿ ಏನ್ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಬೇಕು? Your status as a wife of defendant number 11 is declared.
please, madam. Now, the service benefits are not given to the petitioner, my lord. That's why.
Have you made any claim based on this?
My lord, I made, my lord. I made, my lord.
ಎಲ್ಲಿದೆ ಅದು?
I made representation before the authorities. Fair, my lord, in the judgment of the court, my lord, can you see, my lord, page number 31?
ಎಲ್ಲಿದೆ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್?
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, my lord.
ಅಲ್ಲಿ ಕೊಟ್ಟಿದೆ ಅಂದ್ರೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದೆ?
Legal notice, my lord, Annexure C. Annexure C, my lord, page number 50. Issued legal notice to the government to sanction the online service benefits after death of so her husband. But till date, the government not the action so far.
Government ಬರ್ಕೊಳ್ಳಿ. AG has directed accept notice for respondent number 1, 2, 3, 4, 5, 6, 7.
All respondent minutes, government.
All respondents ಸರಿ, but you are sought for
Please, only.
mandamus ಕೇಳಿದಿರಲ್ರಿ?
Please, man. ಆಗೋ ಸರ್.
ಮತ್ತೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡೋದ್ ಬೇಡ, ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ನ?
ಅಲ್ಲ, private party my lord, is a second wife, no concern, lord. Second.
I do not know whether
Please,
they are
please, please.
second wife, third
Please,
wife.
please.
You are sought for a mandamus to implement the order and grant the service benefits to you. Would they be heard or not?
ಅಲ್ಲ, private parties, I'm the others are his daughters, my lord, daughters, sons.
Right, if you want to take the risk, you can take the risk.
Please. Date, my lord, pension the service.
Date. Yes,
Please.
next.
6. Ali Patil PS.
Not appear.
Malik Patil, yes.
Not petitioner, not at annexure, not D, page 23 may kindly be seen, Lord.
23 na?
I was transferred from Lord, from Shivamogga to Gadag. And one Srimati Bharati Alagundi Mat, Lord, was from Belgaum to Hubli. Lord, both of them, Lord, requested, Lord, to transfer Bharati to Gadag and petitioner to
Hubli. It was the request, my lord, was recommended by the second respondent, my
Eಲ್ಲಿದೆ
lord,
request?
as per annexure C.
Where's the request?
Annexure D8, page 18, my lord, page 18.
Hmm.
It was recommended, my lord, to consider. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ, my lord, ಕಾಂಬ್ಳೆ ಸೋನ್ಸೋ ಇವರನ್ನು ಅನುದಾನಿತ ಆಯುರ್ವೇದ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ ಮತ್ತು ಆಸ್ಪತ್ರೆ ಹುಬ್ಬಳ್ಳಿ ಇಲ್ಲಿನ ದ್ವಿತೀಯ ಸಹಾಯಕ ವಿನ್ಯಾಸಗೊಳಿಸಿ ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮವನ್ನು ಜರುಗಿಸುವುದು. But again, same place has been given. Page number 28, my lord.
For how long you have been in this place?
I was there, my lord, from Shivamogga 15 years, my lord, for 2015 in the ಈಗ ನಾವು transferred. From Belgaum to, my lord,
ಇದನ್ನ ಉಪಯೋಗಿಸ್ಕೊಂಡು ಅಲ್ಲೇ ಜಾಗದಲ್ಲೇ ಇರೋದು ನೀವು?
ಅಲ್ಲ, ನನಗೆ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ವಿ, my lord, because it is convenient for both of them, my lord, for the Bharati as well as for me. ಅವ್ರಿಗೆ ಗದಗ್ ಕೊಡೋದ್ರ ಬದಲು, ನನಗೆ ಗದಗ್ ಕೊಡೋದ್ರ ಬದಲು ಹುಬ್ಳಿಗೆ ಕೊಟ್ಟಿದ್ರೆ, ಅವ್ರಿಗೆ ಹುಬ್ಳಿ ಕೊಡೋದ್ರ ಬದಲು ಗದಗ್ ಕೊಡ್ಬೋದಾಗಿತ್ತು. Both of them are, my lord, working as an SDC.
ಎಲ್ಲ ಹಾಕಿದಾರೆ ನಿಮ್ನ?
Second division assistant.
ಎಲ್ಲ ಹಾಕಿದಾರೆ ನಿಮ್ನ?
Which place they have been posted, sir, now for petition? ನಮ್ಮ ಪಾರ್ಟಿ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
ಶಿವಮೊಗ್ಗ
SDA, my lord, only.
ಅಲ್ರಿ ನಿಮ್ನ ಎಲ್ಲ ಹಾಕಿದಾರೆ ಇವಾಗ?
Page 18, 28, my lord.
ಶಿವಮೊಗ್ಗಕ್ಕೆ ಹಾಕಿದಾರಾ?
ಯಾರ place ನಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ? ಶಿವಮೊಗ್ಗ.
My lord, Ashok Kamble is petitioner, my lord, from Shivamogga to Gadag ಅಂತ ಖಾಲಿ ಇರುವ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ ಮತ್ತು ಆಸ್ಪತ್ರೆ ಗದಗ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೀವ್ ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಿತ್ತು?
ಐ ಆಸ್ಕ್ ನಾಟ್ ಫಾರ್ ಹುಬ್ಳಿಗೆ ಕೊಡೋ ಅಂತ ಕೇಳಿದ್ವಿ. ಅಲ್ಲಿ ಖಾಲಿ ಇದೆ ಇತ್ತು.
ನೀವು ಮುಂಚೆ ಇದ್ದಿದ್ದಲ್ಲಿ?
ಸಾರಿ ಮೇಡಮ್,
ನೀವು ಮುಂಚೆ ಇದ್ದಿದ್ದಲ್ಲಿ?
ಐ ಆಮ್ ಶಿವಮೊಗ್ಗ ಹೇಳಿ ಮೇಡಮ್.
ಶಿವಮೊಗ್ಗ?
ಹಾ, ಶಿವಮೊಗ್ಗ. ಪೇಜ್ ನಂಬರ್ ಕೈಂಡ್ಲಿ ಸಿ ಮೇಡಮ್. ಪೇಜ್ ನಂಬರ್ 28, 23 ನಲ್ಲಿ ಜಿಲ್ಲಾ ಆಯುಷ್ ಆಸ್ಪತ್ರೆ ಶಿವಮೊಗ್ಗದಿಂದ ಗದಗಿಗೆ ಪ್ರಪೋಸಲ್ ಇತ್ತು. ನಾನು ಗದಗ್ ಬದಲು ಹುಬ್ಳಿಗೆ ಕೊಡು ಅಂತ ಕೇಳಿದ್ದೆ. ಈಗ ನಾವು ಸೇಮ್ ಥಿಂಗ್ ಇಸ್ ಕನ್ಫರ್ಮ್. ಅವರು her name is also at serial number 1, page 23. She was earlier working at Belgaum to Hubli.
ಅವ್ರನ್ನೆಲ್ಗೆ ಹಾಕ್ತಿದ್ದಾರೆ? ಭಾರತಿನ?
ಹೌದು, ಅವ್ರ ಹೆಸರು ಭಾರತಿ. BA ಅಳಗುಂದಿ ಮಠ ಅಂತಂದ್ರೆ ಭಾರತಿ.
ಅಲ್ಲ, ಭಾರತಿನ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ ಎಂದಿದ್ದು? ಭಾರತಿ ಗದಗಲ್ಲಿ
ನಾವು she has been posted to ಹುಬ್ಳಿಗೆ.
ಪೇಜ್ 18 ಓದಿ ಒಂದ್ಸತಿ.
ಪೇಜ್ 28 ನಲ್ಲಿ
18 ಓದಿ.
18 ನಲ್ಲಿ ನೋಡಿ.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ 3 ಮತ್ತು 4ರ ಮನವಿ ಪತ್ರಗಳನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಕಳುಹಿಸುತ್ತಾ ಸದರಿ ಮನವಿಗಳಲ್ಲಿ ಕೋರಿರುವಂತೆ ಶ್ರೀಮತಿ ಭಾರತಿ ಅಳಗುಂದಿ ಮಠ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಇವರನ್ನು DGM ಅನುದಾನಿತ ಆಯುರ್ವೇದ ವೈದ್ಯಕೀಯ ಮಹಾವಿಶ್ವವಿದ್ಯಾಲಯ ಮತ್ತು ಆಸ್ಪತ್ರೆ ಗದಗ ಇಲ್ಲಿನ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮತ್ತು ಶ್ರೀ ಆಕಾಶ್ ಕಾಂಬ್ಳೆ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಇವರನ್ನು ಅನುದಾನಿತ ಆಯುರ್ವೇದ ಹುಬ್ಬಳ್ಳಿ ಇಲ್ಲಿನ ದ್ವಿತೀಯ ದರ್ಜೆ ಸಹಾಯಕ ಹುದ್ದೆಗೆ ಮರು ವಿನ್ಯಾಸಗೊಳಿಸಲು ಮುಂದಿನ ಇವ್ರನ್ನ ಭಾರತಿನ ಪಾರ್ಟಿ ಮಾಡಿದಿರ ಇಲ್ಲಿ?
ಅಲ್ಲ, ಅವ್ರಿಗೆ she is due for retirement next month.
ಬಟ್ ಅವ್ರನ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡೋದು ಹೆಂಗಾಗುತ್ತಲ್ಲ?
ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ by that time.
But you should make Bharati as a party to this petition. Bharatiನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು.
ಮಾಡ್ತೀನಿ.
Learned counsel for the petitioner seeks permission to implead Srimati Bharati Alagundi Mata.
ಅಳಗುಂದಿ ಮಠ.
Second division assistant. Second division assistant, Ayurveda Medical College and Hospital Hubballi. As respondent number 4, the request sought for is granted. The learned counsel for the petitioner is directed to implead the said person. Full stop. AG is directed to accept notice for response 1 to 3, issue emergent notice to respondent number 4, list on yavat.
Yep, next week.
Take whatever date you want. Please implead that person.
I'll do it.
Issue emergent notice to respond number 4, Amma.
34, Prakash.
MH Prakash.
Please.
The writ of mandamus is sought to the respondent number 1. And all the petitioners are group C and D employees, respond number 1, an autonomous institution under the respond number 3. Commencing from 2010 till 2016, they were appointed on temporary basis for a period of 1 year, and they were appointed.
How long you are working?
If my lords kindly turn to the recent representation annexure N at page 138.
138.
138. It is narrated since how long, commencing from petition number 1, 14 years, 4 months, 13 years, 11 years. And
many of them were not even completed 10 years.
please. The thing is, my lord,
I accept notice, my lords, for the university. My instructions are, my lords, they have been relieved
post
already.
relieve, what, this is the development, my lord, on 3/7/2024, as
Yes, sir.
usual, every.
Sir, after Uma Devi, why did you continue to take these people on daily wages?
Please.
My lords, these are not taken by the university also. My lords, this is completely contrary to the university regulations, where principal has appointed the said.
Have you taken any action against the principal?
Yes, my lords.
What action have you taken?
Proceedings has been initiated against the principal.
Yeah.
There are proceedings which are going on.
ಆಮೇಲೆ ಏನಾಗಿದೆ?
My lords, so inquiry.
2010, you are not taking any action.
I'll seek instruction, my lords. Today I've got time.
ನೀವೆಲ್ಲಾನು ಡೈಲಿ ವೇಜಸ್ ಅಲ್ಲಿ ತಗೋತೀರಾ, ಹೈಕೋರ್ಟ್ ಬಂದು ರೆಗ್ಯುಲೈಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
I'll seek instruction, my lord.
It
10
will
days.
become some kind of illegal activity indulged by the statutory authorities.
I'll take instruction, my lord. I don't have a. It's already been relieved is what my.
No, the thing is relieving order.
When did
They
you
were
relieve
allowed
them? When did you relieve them?
Lords,
at annexure G, page number 130, on 3/7/2024, an order was issued.
3/7?
3/7/2024. And subsequently, my lord, they have allowed all the petitioners to resume their work by oral orders. Lord, to substantiate at least to some extent at annexure K at page 135, 2 of the petitioners were directed to resume their work on 28/10/2024. And at annexure L page 136.
ನೀವು ರಿಲೀವ್ ಮಾಡಿ ಏನು ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರಾ?
No, my lords.
Then?
My lords, they were not a regular employee at all because.
Sir, you have continued them for over 15 years. What is the great urgency that you relieved them?
My lords, we are not taking any employees, my lords, replacing them with the other.
That is okay. Have you at least issued a regular recruitment notification?
Lords, these are all not the sanctioned posts at all.
It may not be, mister. You have continued them from 2010. What was the great need when they filed a writ petition before this
My lords,
court?
I seek instruction 1 week, my lords. I don't have papers. Today I got instructions.
Mr.
Abhishek Kumar,
Abhishek Kumar
please,
is directed, accepts notice for the respondents.
1 week time. I'll seek
So-
instruction.
Don't terminate them or
Lords, it's already done. As per their prayer itself, 3/7/2024 is what they're
No,
seeking for.
No, I have
prayer
produced the
may be looked
subsequent
into for a-
documents, and in fact, I have
Next week,
stated.
my lords, I'll answer it.
so what is there to show that you have worked even after 3/7?
Lord, that's what I have shown. And annexure K L at page 136 on 30/11/2024. So far as 26 of the petitioners. Then the recent one, my lord, at annexure P page 140, 4/3/2025. ಕಾಲೇಜಿನಲ್ಲಿ ಪ್ರಾಂಶುಪಾಲರ ಆದೇಶದಲ್ಲಿ ಈ ಹಿಂದೆ ನೇಮಕವಾಗಿ ಆದೇಶವಿಲ್ಲದೆ ಜುಲೈ 2024ರಿಂದ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ನೌಕರರು ತಾವುಗಳು ನಿರ್ವಹಿಸಿದ ಸಂಪೂರ್ಣ ಕಾರ್ಯಭಾರವನ್ನು ಅವರ ಹೆಸರಿನ ಮುಂದೆ ಸೂಚಿಸುವವರಿಗೆ ಹಸ್ತಾಂತರಿಸಲು ಸೂಚಿಸಿದೆ.
Till the next date of hearing, the respondents are directed not to.
My lords, it's already relieved, my lords. Let there be a
Continue
status
the
quo
ser-
order. If in
not
case
to
we have not
discon-
relieved, my lords,
Not
we'll
to discontinue the services of the petitioners. Yes, list on when do
And-
you want it?
And not even one petitioner is
My lord.
paid with the salary.
It may be said, my lords, if in case they have relieved already, my lords, that may not be,
Let it, we can't examine all those things at the interim stage.
my lords, at least that observation may be made, my
Yeah.
lord, if in case they have been relieved.
Ah.
My lords, we cannot continue, my lord, because it's,
ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ರಲ್ಲ ಅನೆಕ್ಷರ್ ಇದ್ರಿಗೆ ಲಾಸ್ಟ್ ಅನೆಕ್ಷರ್ ಕೆ ನಲ್ಲಿ ಆಫ್ಟರ್ ದಿ ಇಂಪ್ಯೂನ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್ 4/3/25 continued them.
my lords, next week, my lords, I will take instruction. 2 days time, my lords, at least I'll take instruction.
Day after tomorrow.
Please, ma'am.
At least
Day after tomorrow.
let them not,
Don't take any precipitative action in these 2 days.
Please, my lords.
In the meanwhile, the respondent shall not take any precipitative action against the petitioners. Yes.
please.
Oblige.
Serial number 38, Muralidhar KB.
For petitioner. Petitioner is a retired junior assistant. Lord, petitioner was placed on independent charge, my lord, in 1998. My lord, as it was independent charge, my lord, he had foregone that, my lord. Lord, the government, the respondent corporation on more than one occasion, my lord, has said that, my lord, an independent charge which has been placed, if anyone, my lord, if that has been foregone, that cannot be held as a regular promotion. And therefore, my lord, you have sanctioned the increment of 20 years, my lord, in 2007. Way back in 2007, it was sanctioned, my lord, but at the time of retirement, my lord, they have passed an order, my lord, recovering that amount which has been sanctioned to him.
ರಿಕವರಿ ಆಗೋಗಿದ್ಯಾ ಇಲ್ವಾ?
Recovery ಆಗಿದೆ ಸ್ವಾಮಿ, recovery ಆಗಿದೆ.
ಆಗೋಗಿದ್ಯಾ? ಯಾರು ಕೊಡ್ರಿ ಇದೆ?
ರಕ್ಷಿತಾ
ಎಲ್ಲಿಯವರು ಕೊಟ್ಟಿದ್ದಾರೆ? ಶ್ರೀನಿವಾಸ್ ಗೌಡ. ಎ ಚಂದ್ರಚೂಡ್ ಏನು ಚೆನ್ನೈ ಗೌಡ ಬೆಸ್ಕಾಂ ಮಾತ್ರನಾ? ಶ್ರೀನಿವಾಸ್ ಗೌಡ ಆರ್ ಶ್ರೀನಿವಾಸ್ ಗೌಡ ಬೆಸ್ಕಾಂ. ಸ್ವಾಮಿನಿ ಗಣೇಶ್ ಮೋಹನ್ ಅಂಬಾಳ್ ಬೆಸ್ಕಾಂ. ಕರೆಕ್ಟ್ ಲಿಸ್ಟ್ ತರಿಸ್ಕೊಳ್ರಿ ಯಾರು ಇದಾರೆ ಅಂತ. ಇಷ್ಟೇನ ಇರೋದು? ಎ ಚಂದ್ರಚೂಡ್ is directed to accept notice for the respondents. Please. Yes.
For final hearing matters, serial number 39, Yogesh D. Nayak. You, Anil Kumar.
For the petitioners,
ಯೋಗೇಶ್ ನಾಯ್ಕ್.
it's my colleague.
Ready?
I filed wakalat.
Ready.
Here, central government has
Last
to say,
vacation.
not me, I am for the institute, which is controlled by the central government. In fact, we did not file objections. Also, what we say is that whatever central government has to say, because the central government has passed the order. Last time, Bandhu, Assistant Solicitor General took time.
The 2012 matter ಅಲ್ಲ ಇದೇನೋ
How the last,
ಪುಸ್ತಕ ಅಲ್ಲ?
I don't know, for the last 3 occasions, it is for them to say, man.
ಯಾರು? ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಷ್ಟೇ.
Central government, no, because they issue common guidelines to all the centrally funded technical education institutions. We are one such institution.
Yes.
These are the covered matters, my lord. Last occasion, I served the list of authorities. The very identical prayer has been considered by the Punjab and Delhi High Court, my lord. Whatever the relief sought for in these petitions also.
What is sought for in this petition?
Sought for.
Respond number 1.
Senior counsel is standing there. Why are you pushing? Come to this side. You are virtually throwing him out.
The matter.
You appear for which respondent?
Respond number 1, my lord.
ASJ.
Please, my lord.
Ah.
Is in portal 1, my lord.
Let him argue. Have some patience with the way you're virtually you're elbowing him out. ಹಿಂಗ್ ತಳ್ತಾ ಇದ್ದೀರ ಅವ್ರು ಹಿಂಗೇನೆ. ಅಲ್ಲಿಂದ ಹೇಳ್ಬೋದಲ್ವಾ?
All these, my lord, petitioners are pensioners who were retired from 1986 to before 2006, my lord. Yes. On 1/1/2006, my lord, 6th pay commission, my lord, report was effected. On the basis of the, my lord, 6th pay commission report, the government accepted the
report of the sixth pay commission, my lord, and recommended, my lord, to fix the pay fixation benefit, my lord, in terms of the 5.1447 of the report, my lord.
When was the earlier pay fixation?
Lord,
Before 1/1/2006?
1/1/2006,
When was the previous pay fixation?
96, my lord. 96.
96.
96.
Hmm.
The prayer sought for by these writ petitions, my lord, page 35.
Hmm.
To quash the office memorandum dated 3/10/2008 under annexure N to the writ petition issued by so and so, and declare the communication dated 25/5/2010 under annexure R to the writ petition insofar as denies IRs of the pension determined in terms of paragraph 5.147 of the report of the Central Pay Commission, and pension of 50% of the pay in the pay band at 48,000 per month, and academic grade pay of 12,000 per month to the petitioners, senior professors as arbitrary, discriminatory, high-handed, without authority of, and consequently directly respond to issue a writ in nature of mandamus to pay to the petitioner pension, family pension, as the case may be, computed on the basis of the pay fixation benefit in terms of the paragraph 5.147 of the report of the Central Pay Commissioner, a minimum pay of 48,000 in the pay band of 37,400 to 67,000, together with academic grade pay of 12,000, whichever is higher. The very similar prayer, my lord, was identical issue, Lord, before the Central Administrative Tribunal, thereafter, my lord, in Punjab and Haryana High Court. I produced the judgment, my lord.
Issue first year issue
Issue, my lord.
So what is the issue?
Annexure N, my lord, 3/10/2008. To taken away the benefit was granted, my lord, 5.
Annexure N.
N, my lord. Annexure N.
Ah.
Page 112, my lord, page number. Before that, my lord, the recommendation of the Pay Commission report, my lord, page 61. This is the recommendation. Annexure D, page 48. Fitment benefit to the fast pensioners, page 61, my lord. This is the sixth Pay Commission report.
Yes.
Page 65.147. Fitment benefits to the fast. The Commission notes that modify post 1/1/1996 pensioners. Further, full neutralization of price rise on or after 1/1/1996 has also been extended to all the pensioners. Accordingly, no further changes in the exact rules are necessary. However, in order
Extent rules,
extent rules are necessary. However, in order to maintain the existing modified parity between present and future retires, it will be necessary to allow the same fitment benefit as is being recommended for existing government employees. The Commission accordingly recommends that all the past pensioners should be allowed fitment benefit equal to 40% of pension, excluding the effect of merger of 50% dearness allowance, dearness relief as pension in respect of pensioners retiring on or after 1/4/2004, and dearness pension for other pensioners respectively. The increase will be allowed by submitting the effect of,
Subsuming.
please, the increase will be allowed by submitting the effect,
Subsuming.
sorry, subsuming the effect of conversion of 50% dearness relief, dearness allowance as dearness pension, dearness pay. Consequently, dearness relief at the rate of 74% on pension, excluding the effect of merger, has been taken for the purpose of computing revised pension as on 1/1/2006. This is consistent with the fitment benefit being allowed in case of the existing employees. A table annexed 5.11 showing fixation of pension of the existing pension in the revised dispensation consequent to implementation of the recommendations of this commission has been prepared and should be used for fixing the revised pension of the existing pensioners. The fixation as per this table will be subject to provision that revised pension in no case shall be lower than 50% of the sum of the minimum of the pay in the pay band and the grade pay thereon corresponding to the pre-revised pay scale from which the pensioner has retired. To this extent, changes would need not be allowed from the fitment shown in the fitment table. My lord, the recommendation is 50% of, my lord, lower than 50% has to be fixed for retired employees. My lord. The said recommendation was accepted by the, my lord, union government by on 30th August 2008, annexures E and F, my lord. Thereafter, my lord, annexure N to take on away the benefit was granted, my lord, under sixth pay commission report.
Next year, N,
Annexure N, page 112, my lord.
Lord, may interrupt, sir, one minute. Lord, in this case, if your lordship may kindly see writ petition 46289. In this case, my lord, 46289, the objections counter affidavit is filed by the respondent number 1, that is the Union of India. However, if your lordship may kindly see, Cyber Code, sir.
yes, go on.
Please, my lord. It is signed by the registrar of NITK. My lord, this would not have been done according to us, my lord, because it's the Union of India. If it is to be filed, your lordship got it, my lord. Sorry. It is filed on 8th November 2007. Either Cody.
2007 or 17?
2007.
How can it be filed in 2007?
I'm sorry, 17. See, 17. Sorry.
Illival ಇಲ್ಲಿ.
Sir, 2017. If your lordship may kindly see the second paragraph, my lord, first paragraph, who has signed it?
Hey, why did you file a counter affidavit to this?
Lord, that I got to know now only, my lord, in the last week. How could NITK file it? How could the union file the NITK's counter?
No, that is right. This is a counter affidavit filed by you.
Please, my lord, counter affidavit filed by the Union of India,
Ah.
but signed by NITK, which cannot be done. Therefore, I sought clarification on this, my lord. And the only issue here is this, my lord, that 310-2000, the 310-2008.
There is a statement of objections filed.
Please, my
You
lord.
filed a statement. You
This
not
is-
filed a separate statement.
No, my lord, this
Only
is the
counter
counter affidavit is for the central government says it's this thing. If your lordship may kindly see, you file
Right,
the.
but your predecessor has filed this.
That is the reason, my lord, I have sought, my lord, it could not have been done, my lord. Because the NITK may say, my lord, to give it, but on the other hand, my lord, it is the Union of India. And that, my lord, that 310-2008 order was challenged and it is confirmed and it is covered by the judgment as what my learned friend also says. Therefore, my lord, if your lordship may give me some time, I will also verify this, my lord, that how could such a counter affidavit be filed?
ಎಷ್ಟೊತ್ತಿ ಬಂದಿದೆ ಇದು? This was listed on 6th. At your request, it is adjourned.
Please, my lord, I have sought many times, my lord. It is not that I have not sought time, my lord. The reason is this, my lord. We are also unable to trace out this, my lord. The department is.
So then allow it to rest, Mr. 2012 writ petition.
Finally, my lord, 1 week time, my lord. If your lordship may grant me 1 week time, my lord. If it is covered, I will say it is covered, my lord. I don't take much time.
The learned ASJ again seeks time as a last chance list on. When do you want it?
10 days time.
It is made clear that no adjournment shall be granted on the next.
After
hearing
filing
date.
counter, my lord, decisions was rendered
Mhm.
by the High Court. After
After
filing
the-
counter.
Same counter. In the
ಹೌದು. ಇದು all-
similar counter in the other petition.
ಎಲ್ಲ ಕೇಸಲ್ಲಿ decisions taken by the Haryana and Delhi High Court.
If you say
Subsequent.
adopted the same counter in the other courts,
True, my lord.
what steps have you taken to get the judgments annulled?
matter of fact, my lords, I may just point out one thing. 2007 had confirmed. That is, actually, I am bound by what they say. Therefore, I don't want to say anything more. But pointing out that 2015 ನಲ್ಲಿ Supreme Court confirm ಮಾಡಿದೆ. 310/2008 order is set aside ಅಂತ ಹೇಳಿ. Reason given was, it is contrary to the cabinet decision. Cabinet adopted a resolution, a detailed resolution, and Punjab and Haryana High Court, when the matter reached through the CH-18 to the Punjab and Haryana High Court, Punjab and Haryana High Court said that this 310/2008 is product of some imagination of the junior functionaries, for which they had no authority. Only cabinet decision could be changed only by the cabinet. Then similar matter went through CA principal branch to Delhi High Court. Delhi High Court simply said, my lord, we agree with the Punjab and Haryana High Court. Matter was taken to Supreme Court.
Against the Delhi High Court.
Against all.
Delhi and Punjab.
All high courts, including one Kerala High Court. So the Supreme Court confirmed it by a reasoned order. We see no reason to interfere with the orders impugned. Especially petitions are accordingly dismissed. We accord then, my lords, they sought time. We accordingly grant 4 months right from today to the petitioner to comply with the impugned orders, failing which content applications pending before the tribunal can be revised by the concerned petitioners to take their logical conclusion. All these petitions, my lord, they are squarely covered, except I think one of the batch of the writ petitions is filed by directors. They want their pension to be calculated on director's pay scale. That may not be permissible because though they were holding the post, they were at that point of time granted principal's pay scales. That had director's pay scales had not been given. Except to that extent, my lords, it will have to be.
10 days time. Fine.
10 days ಇಲ್ಲ. ನೀವು ಆಗ ತುಂಬಾ ಟೈಮ್ ತಗೊಂಡಿದ್ದು ನೀವೇ ಹೇಳಿದ್ರು.
Please, my lord, I do admit, my lord.
Next Monday.
Lord, Monday, Wednesday, my lord, finally.
2012
Lord, the reason is this, my lord, Saturday, Sunday, 2 days, it's a non-working days.
2012 matters will come up.
Please, my lord, finally, my lord.
ಅಲ್ಲಲ್ಲ ನಾವು 2000 ಎಲ್ಲಿವರೆಗೂ 2018 ವರೆಗೂ ಮಂಡೇಸ್ ಮತ್ತೆ ತಗೊಳ್ತಾ ಇರೋದು. 19, 20 Tuesday, 20, 21 Wednesday. So that everybody gets an opportunity.
So the next week, my lord, then the next week.
Next Monday, yes, next.
Great.
40. C. Shankar Reddy, number 40.
See Shankar Reddy. There is no appearance for the petitioner. Even on the last day, there is no appearance. Hence the petition is dismissed for non-translation.
Last day he was appeared.
Huh?
Last day he was appeared.
Either respondent number 1 guy.
Please,
See Shankar Reddy.
he was here only.
Yeah, what is the issue about? Idra, was he here?
It was heard last time. Only, my lord, for clarification of the board. It was adjourned in the last week.
Yeah, respond 1 year.
Please, your lordship.
Yes, you are ready.
Maybe pass over, your lordship.
Pass over.
Grateful.
41.
Subramanya Bhatt.
That's appear for the petitioner. Lords, on the last occasion, Lords, Lords had instructed me to seek instructions from the petitioner, my lords, as to whether want to contest the matter or not. My lords, with that regard, my lords, petitioner is saying he wants to contest, my lords. But the thing is, the post is not there. And he is now working in a temporary post in Mysore University. And my lords, I have made my submissions, my lords. With
I don't remember. You have to start afresh. Is there some direction to respondent number 2 on the last date to comply the order dated 3/3/25?
I represent 4 and 5. The other day, senior counsel was present and he had made a submissions that annexure B.
So there's some
Seva
direction.
Dhruvikarana.
Sorry, put it.
They have asserted that the same certificate has been produced.
Yes, what are the facts?
Plus the facts is with regards to my lords, my
ಆಯ್ತು ಹೇಳ್ರಿ,
Discuss.
First, I'll take to my
This
lords.
was
ಕಂಪ್ಲೈಂಟ್.
not from my side, but the other side has, the respondent
That is
council has
respond-
made a submission that the annexure B, what the petitioners have produced, is the same copy that is available in the original records of the
Yes, Mr.
university, which doesn't contain the date, etc.
My lords,
Please argue.
lords, the matter is with regards to the selection process where I've challenged, my lords, why I was not being called for an interview. My prayer is with that regard, my lords. Lords, may kindly turn to page 10, my lords. Where I've sought a mandamus. That is my prayer. Now, my lords, I'll start with the facts. Goes like this, my lords. I have a 10 years of experience, my lords, as a lecturer in Sanskrit. My
My dear friend, what is the recruitment notification? What was the
My
post
lords-
notified?
my lords-
ಅಲ್ಲಿಂದ ಶುರು ಮಾಡ್ಬೇಕಲ್ವಾ?
my lords, I'll take. Kindly turn to annexure D, my lords.
Annexure
D,
D.
my lords.
D
Page
for-
number 26.
Ah.
My lords. In that, it says must be a holder. That is, my lords, I have applied to the first post, my lords. That is serial number 1. Yojana Sahayakaru. Must be a holder of master degree in relevant subject with 55% of marks. Must have studied Sanskrit as optional subject in the degree course.
This is project assistant, huh?
Out, my lords. Preference being given to the candidates who have cleared national eligibility test and acquired vidworth in traditional system of in the field of specialization anta kottidare. My lords, then my lords, I have also applied for the second post, that is serial number 2, my lords, Upakula Sachivar.
Vice Chancellor.
Yes, my lords. My lords, there also they say the same thing, but preference being given to the candidates who have cleared national eligibility test ಅನ್ನೋದು ಆ ಒಂದು criteria ಒಂದಿಲ್ಲ. My lords, I have been called for the second post. Interview ನನ್ನ ಕರೀತಾರೆ. First post, my lord, the first post where I have applied, my lords, I have not been called for an
What
interview.
was the option given by you? Have you given any option?
My lords, no, my lords.
Option ಗೆ ಕೇಳಿದಿರಾ? First post ಇದು, second post ಅದು ಅಂತ?
ಇಲ್ಲ, my lords, I have not asked. I have applied to both the post, my lords. One, I have got a call, and other, I have not got a call. My lords, my prayer is, my lords, I should have been called for an interview. I fulfill the eligibility criteria. My lords, I am 39 years of age. Now, my lords, that is produced in my application certificate, my lords. My lords, may kindly turn to page 32, annexure E.
Yes.
There, my lords, 39 years. ಜನ್ಮ ದಿನಾಂಕ 1973. My lords, now they have a relaxation thing. That is, my lords, kindly turn to page 29. Where, my lords, serial number 1, ಅಭ್ಯರ್ಥಿಯು ಕೇಂದ್ರ/ರಾಜ್ಯ ಸರ್ಕಾರ ಅಥವಾ ಸರ್ಕಾರದ ಸ್ವಯಂ ನಿಯಂತ್ರಣದಲ್ಲಿರುವ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ ನಿಗಮಗಳಲ್ಲಿ ಹುದ್ದೆ ಹೊಂದಿರುವ ಹಿಂದೆ ಹೊಂದಿದ್ದಲ್ಲಿ ಗರಿಷ್ಠ ವಯೋಮಿತಿಯನ್ನು ಅವಳು ಎಷ್ಟು ವರ್ಷ ಅವಧಿ ಆ ಹುದ್ದೆಯಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವರೋ ಹಿಂದೆ ಸಲ್ಲಿಸುತ್ತಿರುವ ಅಷ್ಟೇ ವರ್ಷಗಳು ಅಥವಾ 5 ವರ್ಷಗಳು ಅವಧಿ, ಅದರಲ್ಲಿ ಯಾವುದು ಕಡಿಮೆ ಅಷ್ಟು ವರ್ಷಗಳು. My lords, my lords, now I have submitted my let's kindly turn to annexure B, my lords. That is my service certificate.
Annexure?
Annexure B, page number 21. There, my lords, kindly see, my lords, ಒಟ್ಟು 10 ವರ್ಷಗಳು.
ಯಾರು ಇಶ್ಯೂ ಮಾಡಿರೋದು? ಭಾರತಿ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಕಾಂಪೋಸಿಟ್ ಪ್ರಿ ಯೂನಿವರ್ಸಿಟಿ ಕಾಲೇಜ್.
My lords, it's a aided institution, my lords.
ಏಡೆಡ್ಗೂ ಇದೆಯಾ ಇದು? Notification also covers employees working in aided institutions.
My lords, it covers, my lords.
Please read again. Page 29.
My lords, ಅಭ್ಯರ್ಥಿಯು ಕೇಂದ್ರ ರಾಜ್ಯ ಸರ್ಕಾರ ಅಥವಾ ಸರ್ಕಾರದ ಸ್ವಯಂ ನಿಯಂತ್ರಣದಲ್ಲಿರುವ
ಸ್ವಯಂ ಅಲ್ರಿ, ಸ್ವಾಮ್ಯ.
My lords,
ಕನ್ನಡ ಓದಕ್ ಬರಲ್ವಾ?
ಸ್ವಯಂಯ.
ಸ್ವಯಂಯ ಅಲ್ಲ, ಸ್ವಾಮ್ಯ.
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 Apologies. ರಾಜ್ ನಿಯಂತ್ರಣದಲ್ಲಿರುವ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರ ನಿಗಮಗಳಲ್ಲಿ ಹುದ್ದೆ ಹೊಂದಿದ್ದಲ್ಲಿ ಗರಿಷ್ಠ ವಯೋಮಿತಿ ಅವನು ಅವಳು ಎಷ್ಟು ವರ್ಷಗಳು ಅವಧಿಗೆ ಆ ಹುದ್ದೆಯಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿರುವರೋ ಹಿಂದೆ ಸಲ್ಲಿಸಿದರೋ ಅಷ್ಟೇ ವರ್ಷಗಳು ಅಥವಾ 5 ವರ್ಷಗಳ ಅವಧಿ, ಅದರಲ್ಲಿ ಯಾವುದು ಕಡಿಮೆಯ ಎಷ್ಟು ವರ್ಷಗಳು?
ಅಷ್ಟು ವರ್ಷಗಳು.
ಅಲ್ಲ,
ಅಷ್ಟು ವರ್ಷಗಳು ಎಷ್ಟು ವರ್ಷಗಳಲ್ಲ ಅದು.
ಅಷ್ಟು ವರ್ಷಗಳು. ಮಲಾಜ್, ನೌ ಐ ಫಾಲ್ ಅಂಡರ್ ದಿಸ್ ಕ್ರೈಟೀರಿಯಾ ಮಲಾಜ್.
ಎಲ್ಲಿದೆ? ಏಡೆಡ್ ಎಂಪ್ಲಾಯೀಸ್ಗೂ ಇದು ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂತ ಇಲ್ಲಿದೆ. ಸರ್ಕಾರದ ಸ್ವಾಮ್ಯ ಅಥವಾ ನಿಯಂತ್ರಣದಲ್ಲಿರುವ ಸ್ಥಳೀಯ
Malaj, now the institution is getting a grant, Malaj.
Correct, Mr. This age relaxation,
Malaj.
Is it applicable
Malaj.
even to
Malaj.
employees of a private aided institution?
Malaj, that is
Is
what
it applicable?
Malaj, it's applicable.
How?
Malaj, now the same translation is in the statement of objections filed by respondent number 5. Annexure R5, Malaj. K anta ida. Page number is not there, Malaj.
Yes. Page 22, annexure R5.
R5K, Malaj.
K.
Malaj, there. Page number 4. Continuing page number 4, Malaj. In case of candidates who is or was holding a post under the university of government or local bodies, bracket corporation, city, municipal council or undertaking of government, by number of years he or she is holding such post, the number of years holding such post or 10 years, whichever is less, correspondingly age will be relaxed. Now, Malaj. Malaj, there first it says, no, Malaj, in the case of candidate who is or was holding a post under the university of government. Now, Malaj, university of a government in the sense that grant and aid institution also comes under it.
University notification latara illappa. Notification alle atara illa. Your translation eno ಮಾಡ್ಕೊಂಡಿದ್ರೆ.
This is the cadre recruitment rules, Malaj.
ಯಾವುದು?
Now what I'm referring to, Malaj.
Annexure
5K anta. R5K.
Yes.
Now, my lords, I fall under that criteria. I'm eligible, my lords.
Yes.
My lords, now when I am eligible, I was not called. Now, my lords, in the notification it says preference shall be given. And the preference is, my lords, preference is during the point of appointment, not at the point of selection process. Now, selection process only calling for an interview is also a part of it. Now, my lords, I have submitted a judgment 1992 SEC 69, my lords. In that, my lords,
paragraph 7, where, my lords, I would read, in word selection is understood in the sense, meaning thereby only a final act of selecting candidate with the preparation of the list for appointment. Then conclusion of the tribunal may not be justified, but the round phrases cannot give us square answers. Before accepting the meaning, we must see the consequences, anomalies, and uncertainties that it may lead to. The tribunal, in fact, does not dispute the process of selection being in the issuance of the advertisement and the ends with the preparation of selection of appointment. Indeed, it consists of various steps like inviting applications, scrutiny of application, rejection of defective applications, elimination of ineligible candidates, conducting of examination, and calling for interview, my lords, and preparation of list of successful candidates for appointment. Now, my lords, this point, my lords, that is conducting of examinations, calling for interview, and calling for interview, my lords. ಅದನ್ನ ಇವ್ರು ಬಿಟ್ಟಿದ್ದಾರೆ. I have not been called for an interview. The main purpose of doing interview is whether I am eligible or not. Now, my lords, without doing the interview itself, I am considered ineligible. Matte, they submit that they have called others for interview, my lords.
Yes.
That is, my lords, kindly turn to Annexure G.
Yes.
Where they have called so many other candidates, and I am left out, my lords. Now, let them give preference during at the point of appointment, not at the time of this thing. I am eligible now.
So you're already working in Kuvempu Institute of Kannada Studies. You're still
Malad-
working there.
He's still working there only.
Huh.
He's working in a temporary post.
Research assistant.
My lords, I don't know whether he is research assistant, but
ನಿಮ್ ಕಾಸ್ಟ್ title ಹಂಗಿದ್ಯಪ್ಪ?
my lords, now, as of now, I don't know, my lords. He's saying I'm working in a temporary post. He's not telling much of the information. With that instructions, my lord, this is my submission.
Yes. Yes, sir.
Please, Mars. The first, no doubt, Mars, and technicalities, so far as the appointment of respondent number 4 and 5, I represent the respondent number 4 and 5, is concerned. In the writ petition, petitioner has not sought for any prayer. Question of quashing doesn't arise. That is the first submission without entering into the merits. My lord, so far as the question which my lord is enough to put it regarding the eligibility to appear for the interview, the same question, my lord, I shall read it before, if I can say so. The very petitioner, he has filed another writ petition. I'm passing on the judgment, my lords. It's not that. I filed another writ petition. In that writ petition, this is Sanjay Guru. In that writ petition, a certain content reference will be drawn, but I can pray my lords to kindly come to para number 17, 18, and 19 of the judgment. Very petitioner, my lord.
Yes.
It is thus clear that the candidate working under the university or the government or the local bodies such as corporation, city municipal councils or undertakings of the government would be entitled for the higher age limit corresponding to the number of years they had rendered their services. They are subject to the maximum tenure. It is to be borne in mind that the exemption granted is in respect of the age limit in the specified category of a candidate, that is a candidate who worked either in a university or under the government or a local body. The exemption will have to be considered strictly and cannot to bring within its purview institutions other than those prescribed as could be seen from clause 9A of the exemption, specifically to those. Then para number 19. It is to be borne in mind that the private educational institutions would always be private institutions even if it was receiving the grant in A. So therefore, my lords, therefore, my first submission is since he does not fall within the requirement of the category, therefore, my lords, he is not entitled to be called for the interview. The many about 80 applications were there, many people were called for the interview. Amongst them,
But why did you call him for the next post?
but I did not call it.
Whatever.
Well, no, true, my lord. I did not call. It is the university which has taken such a stand. Because the reasons what they have pointed out, I cannot say beyond this line. What they have pointed out is number of applications there were very less, 10 or 12. And so far as this post, the small post, it is more than 80 applications were there. The scrutiny has been done. According to the requirements, they have called for the interview.
What is the maximum age?
My lords, the permissible age is 35 plus 5 years they can add. So, since he claims through the private educational institution, number one, and in the normal course, my lords, they should have applied through the employer itself. That is also one of the conditions that is available on page number 31 of the writ petition. ಉದ್ಯೋಗ ಮೈಲಾಡ್ ಉದ್ಯೋಗದಲ್ಲಿರುವವರು ಅರ್ಜಿಗಳನ್ನು ತಮ್ಮ ಉದ್ಯೋಗದಾತರ ಮೂಲಕ ನಿಗದಿತ. So on these two counts, he was not called for. And so far as this is concerned, my lord, I need not get to
Government.
Apart from that, NET, etc. is there.
That's okay, but age
limit doesn't fall.
Age relaxation, vice chancellor ಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಇವ್ರಿಗೆ ಅಂತ ಕೇಳ್ತೀನಿ.
ಅಲ್ಲ, ವೈಸ್ ಚಾನ್ಸಲರ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಜಸ್ಟ್ ರಿಜಿಸ್ಟ್ರಾರ್, ಸಾರಿ,
ಕುಲ ಸಚಿವರು ಅಂದ್ರೆ ಏನು?
ಅಲ್ಲ ಕುಲ ಸಚಿವರು, ರಿಜಿಸ್ಟ್ರಾರ್, ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್.
ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್, ವಾಟ್ ಇಸ್ ಏಜ್? ಸೇಮ್ ಅಲ್ಲ?
ಸೇಮ್ ಕಾಣಿಸ್ತದೆ, ಅಲ್ಲೂ ಸೇಮ್ ಕಾಣಿಸ್ತದೆ.
ಅವ್ರಿಗೆ ಹೆಂಗ್ ಕಳ್ಸಿದ್ರಿ ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ಗೆ? Whether he was recruited to the post of deputy registrar? Selection
ಅಲ್ಲೂ ಆಗ್ಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಈ ರೀಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು.
ಡೆಪ್ಯೂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್
ಅದಕ್ಕೋಸ್ಕರ ಈ ರೀಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು. ಮುಂದಿನ ಡೆವಲಪ್ಮೆಂಟ್ ಹೇಳ್ತಾನೆ, ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಹೇಳಿಲ್ಲ ನಮ್ಮ ಕಡೆಯಿಂದ ಏನು ಮುಚ್ಚಿಟ್ಕೊಂಡಿದ್ದೇವೆ ಏನಾದ್ರು ಭಾಗ. ಮುಂದೇನಾಯ್ತು ಅಂತಂದ್ರೆ ಈ ರೀಟ್ ಪಿಟಿಷನ್ ದಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಇದ್ದಿದ್ದು, so far as the appointment of deputy registrars are concerned, they found that it is illegal. This learned single judge found that it is illegal, and you may consider then his application. Then the matter went to the division bench. Division bench, so far as this finding is concerned, that minimum of 5 years experience and he should be, and whatever the employee of the university is concerned, the division bench has agreed. However, division bench has disagreed only to the extent that whether this, petitioner could have been called for the interview. Therefore, the division bench what did is, so far as the termination, setting aside the appointment order of the respondents in that case is concerned, division bench has upheld it. So far as eligibility is concerned, the division bench has observed that it is still under doubtful condition. Therefore, university is required to decide regarding his eligibility. That was the finding.
Yes,
I shall give nothing. We are not. ಬರ್ತೇನೆ, ಎಲ್ಲವನ್ನೂ ಹೇಳ್ಬೇಕು. That was the finding given by the division bench. Later, my lords, this division bench order was also challenged before the Supreme Court. The question before the Supreme Court was only with reference to the relieving of the particular respondents in that case is concerned. In that case, the Supreme Court has ordered, no, status quo. Order copy. Only one copy is there. Only, sorry, my lords. Status quo regarding the respondents therein is concerned. So now the question, so far as coming to the present writ petition is concerned, we have to restrict our submissions only regarding his eligibility. So far as eligibility is concerned, both the learned single judge and the division bench both have confirmed the same. Therefore, my respectful submissions to my lord would be that this question may not arise. More so on equity also, my lords, I should not, I am working for there more than 12, 15 years. And
no, we're not going to disturb this one.
That's
ನಿಮ್ಗೆಲ್ಲ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇದೆಯಾ ಇದೆಲ್ಲನು 5 years ಇದೆಲ್ಲ ಇದೆಯಾ
ಅದೆಲ್ಲ
must be a holder of master's degree in relevant subject with 55% of marks.
ಅದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ R4 ಇದರಲ್ಲಿ ನಾವು we have produced it, all those documents. And it is not his case that I don't have the qualifications or the age for that matter.
Yes, 55% marks ಎಲ್ಲಿದೆ?
Pardon?
What is there to show that you have secured 55% marks?
Please, my lord may kindly turn to annexure, sorry, we have filed R4 and R5, both the people have filed separate
Utayana Hegde, 383 marks. Sanskrit ಎಲ್ಲಿದೆ?
Karnataka State Open University, Sanskrit 600 plus. My lord may kindly turn to page number 10, R5C.
R5C, na?
My lord, R5C.
Page number 10, na?
Page number 10 anta ತೋರಿಸಿದ್ದಾರೆ.
Page number R4C is page number 10.
No, there are two things are there. R5C is one. Other one.
R5C ಅಂತ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ, R4C ಅಂತಿದೆ, 4D ಇದೆ.
Separate. Two separates we have filed it, my lord. R5 has filed one objection, R5 has filed a separate.
R5C, yes.
Total, my lord got that? 1,000 marks, he has scored 600 marks, first class here.
Must be a holder of master's degree. ಎಲ್ಲಿದೆ? Master's degree ಎಲ್ಲಿದೆ? R4 the master's degree ಎಲ್ಲಿದೆ?
ಕೊಡ್ತೇನೆ. ಇದು R5, ಈಗ ನಾನು R5C ತಮ್ಮ ಒಪ್ಪಿಗೆ ಆದ್ರೆ ನೆಕ್ಸ್ಟ್ ಬರ್ತೇನೆ ಅಲ್ಲಿ.
R4 ಹೇಳ್ಕೊಂಡು ಹೋಗಿ. R4 the master's degree ಎಲ್ಲಿದೆ?
R4 marks. R4. Please, man, once.
Acharya Pariksha.
Here, master, page number 10, here also,
MA
out of 1,000,
671.
annexure R4C,
Yes,
out of 1,000, he has scored 671 marks.
yes.
Which is not a part of record, one statement I'm making on the basis of my learner friend's instructions, my lord. Present respond number 4, my lord, he has resigned, he went elsewhere also. Well, but R5 is continuing. But the appointment,
R5 the master degree ಎಲ್ಲಿದೆ?
so R5 page number
MA final degree 600.
Sanskrit marks.
Yes.
R5C, my lords,
Then
page 10.
age ಎಷ್ಟು? How old are these two
No,
people?
my lord, they are within the, I mean, no question of, we are within the wage, my lord. That is not the question.
Secondary.
At that time, they were below 35. Later, my lord, they have become 36. That. But at the time, they were below 35. Both.
Yes, Mr. Aಷ್ಟೇ, huh?
Lords, with that regard, my lords, respondent 4 and 5. My lords, my thing is on respondent, they had the
Correct, upon in view of the finding recorded by a coordinate bench of this court,
my lords.
that you could not have sought for age relaxation. How can you still argue the same point?
That's all.
Good. The petitioner has sought for a writ in the nature of mandamus to direct the response 2 and 3 to interview him to the post of planning assistant. Planning assistant or project assistant? Yojana Sahayakanu project assistant.
Project assistant.
Project assistant. Wide
Planning assistant. Planning assistant.
planning assistant.
Planning assistant.
Wide planning assistant, wide notification, recruitment notification dated 16/7/2012. He has also sought for writ in the nature of mandamus to direct the response 2 and 3 to select and appoint him to the post of planning assistant if he is found fit after an interview. Next para. The petitioner contends that the respondent number 2 published a notification dated 16/7/2012 inviting applications from eligible candidates to various posts, including 10 posts of planning assistants and deputy registrars, deputy registrars,
And many other posts.
full stop, including ಅಂತ ಹೇಳಿದೆ. 10 posts including planning,
Including.
full stop. The qualification prescribed for the post of planning assistant was a master degree in the relevant subject bracket Sanskrit with 55% of marks, and he or she must have studied Sanskrit as an optional subject in the degree course. Full stop. Preference was to be given to candidates who had passed national eligibility test and acquired vidvat in tradition system in the field of specialization. Full stop. The petitioner contends that he possessed all the qualification except the national eligibility test. Full stop. Therefore, he applied for the post of planning assistant as per the application dated 10/8/2012 along with all the relevant documents. Full stop. Petitioner contends that though he possessed all the eligibility, he was not called for an interview that was held on 4/1/2013. Full stop. He came to know of the interview through one of his colleagues and later contacted the respondent number 2 over phone. Full stop. The respondent number 2 informed the petitioner that he was not eligible for appointment on the ground that the petitioner had crossed the maximum age prescribed. Full stop. The petitioner contends that he had worked as a lecturer in Sanskrit for 10 years and therefore he was entitled for relaxation of 5 years and thus he was eligible to apply to the post of planning assistant. Full stop. He contends that In same notification, he had also applied for the post of deputy registrar, and that he was issued with an intimation dated 13/9/2012 to appear for an interview that was scheduled on 21/9/2012. Full stop. The petitioner therefore contends that the reason cited by the respondent number 2 for not interviewing the petitioner was unsustainable. Full stop. The respondent number 2 thereafter published a list of candidates who were interviewed by the respondent number 2 on 4/1/2013, and thus filed this writ petition seeking for a writ in the nature of mandamus to direct the respondents 2 and 3 to interview him and to select him to the post of planning assistant if he is found fit after an interview. Full stop. During the pendency of this writ petition, respondents 4 and 5 were selected to the post of planning assistant, and therefore they were impleaded in the writ petition, though no relief was sought for to set at naught the appointment orders issued to the respondents 4 and 5. Full stop. Next part. The learned counsel for the petitioner reiterated the above contentions and contended that since the petitioner had worked in an aided institution for more than 10 years, he was entitled for relaxation of age up to 5 years, and therefore 5 years. So he contends that if the said benefit was given, the petitioner who was 39 years old as on the date of the application, was eligible to apply. Full stop. He referred to the cadre and recruitment rules of the respondent number 2 and contended that the respondent number 2 had admitted granting the benefit of relaxation of age in respect of all those employees who are working in the university. Therefore, he contends that the petitioner must have been granted the benefit of relaxation in age. Full stop. Next paragraph. The respondents 4 and 5, the respondents 1 and 2 have contested the writ petition ನೀವೇ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಿ?
2 and 3 ಹಾಕಿದೀವಿ.
Respondents 2 and 3
Sanskrit University 6/3/2013.
2 and 3 have contested the writ petition by filing a ಯಾವತ್ತು ಹಾಕಿದಿರಿ?
6/3/2013.
Contested the writ petition by filing a detailed statement of objections containing inter alia
Para 4. Para 4.
containing inter alia that as per the notification, the maximum age to apply in the general category was 35 years. And if an applicant had rendered service in any central state/public sector/local authorities under the control of the government or boards or corporations, then such applicant would be entitled to relaxation of age to the extent of his service subject to a maximum of 5 years. Full stop. It is contended that the petitioner ನೀವೇನು ಒಪ್ಕೊಂಡಿದ್ದಂಗೆ ಇದ್ದೀರಾ ಇಲ್ಲಿ?
ಆರ್ಟ್ ಅಂತ ಬಿಟ್ಟೋಗ್ಬಿಟ್ಟಿದೆ.
ಆರ್ಟ್ ಬಿಟ್ಟೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? Full stop. It is contended that since the petitioner claimed that he was working in a private institution as a lecturer in Sanskrit for 10 years, he would not be entitled to the benefit of relaxation of age.
Last 4 lines are
Full stop. Next paragraph. The respondent number 4 has also contested the writ petition by filing a detailed statement of objections containing inter alia 4 and 5 and 3. I filed the detailed statement also containing inter alia that they possessed all the qualification and eligibility and also cleared the national eligibility test and hence was called for an interview. Full stop. They also contended that the petitioner is not entitled, the petitioner was not eligible and therefore was not called for an interview. Next para. The learned senior counsel representing the respondent number 4 and 5 submitted that the relaxation of age as per the recruitment notification is only applicable to central/state government/local authorities/public sector undertakings and not to an employee of a private aided institution. Full stop. He contended that as a matter of fact, the petitioner who was not selected to the post of deputy registrar, questioned the same in WP number 21896/2013 and 28172/2013, and a coordinate bench of this court held that the petitioner is not eligible for relaxation of age. He contends that this finding has become final as the petitioner has not challenged the order passed in the writ petition. He therefore contends that this writ petition also has to meet the same fate. Full stop. Next para. I have considered the submissions of the learned counsel for the petitioner and the learned senior counsel representing the learned counsel for the response 2 and 3 and the learned senior counsel representing the respondents 4 and 5. Next para. The recruitment notification issued by the respondent number 2 specifically provided the eligibility criteria
26
as
XLD.
specifically provided the qualification for the post of planning assistant as follows. With page 26, Alama, serial number 1. Red pencil mark. Serial number 1. Full stop. As regards the eligibility, it's specified as follows. Vayomiti intide, serial number 3. The relaxation of age was provided as follows. 3 ಒಳಗೆ ಕೆಳಗಡೆ ಒಂದು small Roman 1 ಅಂತ ಅದೊಂದು red pencil mark. Full stop. The petitioner was admittedly aged 39 years as on the date of the application. Full stop. He claims that he was employed as a teacher at Bharati Residential Composite Pre-University College between 2000-2001 to 2010-11 and contended that the said college was aided by the state government, was granted aid by the state government. Full stop. However, the notification which provided for relaxation of age did not admit relaxation of did not provide for relaxation of age in respect of employees who are employed in a aided institution. Full stop. This very question was considered by a coordinate bench of this court in WP number 21896 of 2013 connected with 28172/2013, where it was held as follows. Paragraph number 18 and 19. 17, 18, 19. Full stop. Therefore, the contention of the petitioner that he was entitled for relaxation of age, is already answered by a coordinate bench of this court, and therefore the petitioner cannot reassert the said question to claim that he is entitled for to claim that he was entitled to be interviewed by the respondent number 2 for the post of assistant planning assistant. Full stop. In that way of the matter, this writ petition does not merit consideration and hence it is dismissed.
Grateful. Number 42, S.M. Babu.
That's all. That is one page.
Not the last occasion, the
Ah.
response had taken
Ah,
time to raise that grounds in the additional affidavit. Contending that there was no such notification issued by the government of India.
yes.
The
Ah.
Lordship could remind.
Yes.
I filed my additional
They
statement
they
of
have filed the objections. Lord, it's very important, Lord, that Lordship may kindly take in the serial number 44, serial number 44, a similar matter. There, my lord, in the additional affidavit, they have produced the judgment of the High Court of Punjab and Haryana.
My lords,
There may be
yet to
most
file the affidavit, additional statement of objections, my lords.
in that 44.
Serial number 44, my lords. I've served a copy to him.
See number 44 allama. Ground counsel for the respondent
Same
has
is-
filed a statement of objections. The same is taken on record. Yes.
Lord, may recollect the facts. my
Yes, I remember the facts.
lord. Now, Lordship may kindly take the judgment, my lord. Here, Lord, may annexure R1.
Ah,
This is judgment of Punjab and Haryana.
ah,
Lord, Lordship may kindly take, my lord, page 9. Next page, my lord. There, my lord, they are referring to the pad. In this petition, the petitioners challenge the grant of certain benefits to the private respondents. The private respondents were all ex-service who had sought for their educational qualification of diploma plus 10 years experience, entitled to them to be considered as degree holders. At that time, this was claimed on the basis what was stated to be a notification dated 26/5/1977. That is what, my lord, that is the issue before your lordship. Now, based on this issued by the government of India and unrelated, this is important, my lord. At that time, on basis stated to be a notification issued by the government of India. In an unrelated case, Central Administrative Tribunal had declared that notification to be a fictitious, and it was on this ground that the petition is partly laid. During the pendency of this petition, an affidavit dated 21/11/2017 of the Secretary to the India has been placed on record, which wherein has unequivocally stated that no such notification was issued by the government of India, Ministry of Human Resources Development, which was the concerned ministry or the other department. Today, it has been agreed before me that in fact, no notification was ever issued. And senior counsel appearing on behalf of the private respondents has argued that this fact by itself could not be a sole determinative because the fact that the matter is that of various office memoranda were issued, wherein this decision was taken now for the past more than 45 years. This benefit has been granted to ex-servicemen across the border, and there may be hundreds, if not thousands, such persons who have been given the benefit of such. Now, I'll skip. Now, Lakshmi, kindly take minute. Page number 11. On the other hand, learned senior counsel appearing for the private respondent raised the following points. It is contended that for the past 40 years, not only the Union of India in all its departments, but even all the state governments in all the departments have recognized and accepted this benefit, which was given to the ex-servicemen. Then, my lord, he has other contentions have been urged, my lord. Then last paragraph. Learned Counsel for Union of India has very fairly stated that there is a huge lapse on the part of the government machinery, in so much as for 40 years, a particular benefit has been given to many persons without there being any authorization for the same. He has rejected the, have gone missing because as per the notification, it is not a piece of paper which is just signed by one person. He has drawn our attention to the court that the affidavit of the secretary, wherein the secretary has categorically averred that neither the central record unit section or the ministry nor the department publication, which is a repository of the Gazette of India, have any regard to this notification. Consequently, the possibility that the notification actually exists but was misplaced could not exist. Now, my lord, may I request, my lord, may come to the next page, 14, my lord, page 14.
13 ಅಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ
15.
third paragraph. In my considered view.
ಅಲ್ಲ ಅದಕ್ಕೆ ಮೊದಲು in my considered opinion, yes, ma'am. In view of the affidavit of the Secretary, Ministry of Department, referred to above, it has to be held that the benefit of treating the private respondents as degree holders were wrongly granted. The Union of India, this is how, my lord, where there is a mistake, it can be rectified. That is the decision referred to there, my lord. Now, Lord, may I request this, my lord? Page number 12. That I have read, my lord. I have read that. Now may kindly take, my lord. Page 14. Reluctantly, it has to be held that the benefit given to the private respondents can be withdrawn to that extent, my lord, the government.
Reluctantly ಅಲ್ಲ, resultantly.
I'm sorry, resultantly. Land Council, Union Council of the private respondents then argued that the decision of Central Administrative Tribunal to which reference was made earlier has been challenged before the court, and the division bench has issued notices saying that the present case that be heard along with the said petition or be adjourned, await the decision of the division bench. In my opinion, there is a glaring difference between that case and this case, because the present case, for the first time, the unequivocal stand of the government of India has emerged that the fact that there was no notification dated 26/5/1977 before the tribunal, and the stand of the Union of India was not so unequivocal. In the circumstances, the prayer cannot be accepted. Accordingly, the petitions bearing number so and so are allowed. The impugned seniority list. There, my lord, what they have taken based on this benefit, not they have taken the seniority.
Yes.
Therefore, the seniority list was quashed. Let them redo the list. Then my lord, may kindly see. RA number so and so is allowed. The order dated 18/2015 is recalled. Writ petition is dismissed in terms of the order passed in number so and so. This is the judgment, my lord. Now, in the other writ petition, my lord, the judgments of the Supreme Court. The counter last occasion, my lord, the
Yes.
copies of the judgments. There, Last may kindly see, my lord. The order is at page 3. This appeal is directed against the judgment and order passed by the High Court of Punjab and Haryana at Chandigarh in number so and so. We have heard the Land Council for the parties to this list. Having gone through the records of the case, we are of the considered opinion that the appeal being devoid of any merit is liable to be dismissed and is dismissed accordingly. Then, my lord, however, the question of law raised be kept open to be agitated in an appropriate case, against which, my lord, a review petition was filed at page 1. There is a delay of 671 days in filing the present review petition, for which no satisfactory explanation has been offered. The review petition is liable to be dismissed. Lord, my respectful submission is, Last may kindly see the SLP which was filed before the Supreme Court by the appellant, that is, my lord, Haryana Power General Corporation Limited, versus, my lord, where, my lord, the benefit had been granted by the judgment, some of the judgments of the Punjab and Haryana. And this judge, we do not know whether any appeal was filed against this judgment which I now read, my lord.
But ultimately, if the court.
Ultimately, it has been categorically held that there was no notification issued by the government of India. In fact, at that point of time, my lord, the government of India was not the authority. It is the education department of the, and this government authority came to force in the year 1985. And that notification was issued in the year 1977. That has also been pointed out in that judgment.
But that must have been issued by the Defense Ministry.
The ministry,
Must
at
have been
that
issued
point
by
of
the
time,
Defense Ministry.
no, this is what it has been held, Rashmi, kindly see. Paragraph.
ಇದು ಗವರ್ಮೆಂಟ್ ಆಫ್ ಇಂಡಿಯಾ ಮಿನಿಸ್ಟ್ರಿ ಆಫ್ ಎಜುಕೇಶನ್ ಸೋಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಅಂತ ಹೇಳಿ.
My lord, at page 10, my lord. My lord, page 10 of the counter filed in serial number 44, that is WP number 38,413. ಅದರಲ್ಲಿ ಆ ಜಜ್ಮೆಂಟ್ ಓದ್ತಾ ಇದ್ನಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಆ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪೇಜ್ 10 ಅದರಲ್ಲಿ stated that no such notification was issued. Second line I am reading. Stated that no such notification was issued by the Government of India, Ministry of Human Resources Development, which was the concerned ministry, or in factual any other department. Today it has been agreed before me that in fact no notification was ever issued. Land Senior Counsel appearing on behalf of the private respondent has argued that this fact by itself could not solely determined, because the fact of the matter is of various office memorandums were issued wherein this decision was taken, and now the present for the past for more than 45 years this benefit has been granted to ex-servicemen across the border, and there may be hundreds if not thousands of such persons who have been given the benefit, and in these circumstances to withdraw from the private respondents at this stage would be extremely unfair. There is a reference to stating that, my lord, this notification was not at all issued. Against which, my lord, there is no document to show that this judgment has been reversed by either the Supreme Court or any other.
The high courts have
Yes,
taken a view
that
and
has to be relied upon.
Supreme Court has already upheld that order passed by
Yes,
Punjab
yes,
and
yes.
Haryana.
Yes, my lord. No, the doubt which I felt was that the SLP that was filed before the Supreme Court, Lakshmi kindly see the cast title, my lord. There, my lord, I had a doubt. The civil appeal 591. That judgment, my lord, which has been produced
Yes.
on the other side. What of the either
841.
ಅದೇ ಸರ್.
ಅದರಲ್ಲಿ page 3. Civil appeal number 591. As Lakshmi kindly see the appellants. Haryana Power General Corporation Limited. This is not the private party. This is the authority.
They have challenged it.
But there was no. That means, my lord, if they want to challenge this, my assumption is that unless there was an order against the government,
Correct. ಏನ್ ಮಾಡ್ತಾರೆ? ತಪ್ಪು
there was
ಮಾಡಿ.
no. And suppose if there was a order against the government, then only, my lord, the Haryana government could challenge. That is the only doubt, my lord, I felt that since that has been several petitions were allowed and benefits have been granted for more than 40 to 45 years.
So that also is considered.
Yes. Yes,
Punjab
ma'am.
and Haryana is considered that also.
Yes, ma'am. That has been considered by the Punjab and Haryana High Court, my lord.
They cannot be perpetuated.
Yes, that is the only argument I would have.
Good. In these two writ petitions,
Lord, one is in respect of Karnataka Power Corporation Limited. And the other writ petition is, my lord, in respect of Karnataka Power Transmission Limited.
these were called WP number 3989-97/2013,
Relate to Karnataka Power.
filed by is filed seeking for a writ in the nature of certiorari right to quash the communication bearing number A1.P1C/6871 dated 24/2/2012, issued by the respondent therein, by which by which
50.
ಏನಂತ ಮಾಡಿದಲ್ಲಿ
ಅದೇ Lakshmi kindly see, my lord, immediately after the names ಕೆಳಗಡೆ ಆದರೆ ಸದರಿಯವರುಗಳು IAF ನಲ್ಲಿ ಡಿಪ್ಲೊಮೊ ಇಂಜಿನಿಯರಿಂಗ್ ಅಥವಾ 10 ವರ್ಷಗಳ ಸೇವೆ ಸಲ್ಲಿಸುವುದನ್ನು ಇಂಜಿನಿಯರಿಂಗ್ ನಲ್ಲಿ ಪದವಿಗೆ ಸಮಾನವೆಂದು ಹಾಗೂ ರಾಜ್ಯ ಸರ್ಕಾರ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಅರ್ಹತೆ ಇರುವ ಬಗ್ಗೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಆಫ್ ಟೆಕ್ನಿಕಲ್ ಎಜುಕೇಶನ್ ಅಥವಾ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ KPSC ಅವರ ಆದೇಶ ಪ್ರತಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ.
by which, it held that the petitioners had failed to produce documents to establish that
ಡಿಪ್ಲೊಮಾ ಇನ್ ಇಂಜಿನಿಯರಿಂಗ್ ಆಗಿ 10 ವರ್ಷ
establish
ಆಯ್ತು.
that the the authorities of Indian Air Force by which they failed to produce any documents to establish they had served for 10 years as diploma engineers in the Indian Air Force. The petitioners have also sought for written in the nature of mandamus to direct the respondent to reconsider their cases in accordance with the communication bearing number F18-19/75/T2 dated 26/5/1977 for the post of assistant engineers and grant all consequential benefits. Full stop. The petitioners in WP number 38413 of 2013 have sought for writ in the nature of mandamus to direct the respondent therein to consider his case in accordance with the communication bearing number F18-19/75/T2 dated 26/5/1977 for the post of assistant engineer electrical civil and grants, the petitioners were all working, petitioners possessed a diploma in electrical/mechanical and were employed in the Indian Air Force. Full stop. Later, after their retirement from the force, they applied against a notification issued by the respondent for recruitment to the post of
junior engineers and were accordingly recruited as either junior engineer mechanical or junior engineer electrical. Full stop. The petitioners contend that on they working as junior engineer electrical/mechanical for 10 years, they are deemed to possess an engineering degree as per the Government of India Ministry of Education and Social Welfare notification bearing number F-18-19/75/T2 dated 26/5/1977. Consequently, they contend that as per the cadre and recruitment rules of the respondent corporation, the qualification required for being appointed to the post of assistant, appointed or promoted, To be transferred and posted.
to be transferred and posted to the post of assistant engineering was a degree in engineering. Therefore, they were all entitled to be appointed as assistant engineers. Full stop. However, the respondent issued a communication stating that the petitioner did not produce petitioners in WP number 3989-97 of 2013 had failed to produce any documents to show that they had worked for 10 years or more in the Indian Air. Full stop. Being agreed by the same, the writ petition, the petitioners in WP number 3989-97 of 2013 have filed the writ petition. Next para. The petitioner in WP number 38413 of 2013
Sought for mandamus.
has sought for a mandamus to consider his case for transfer by to the post of assistant engineer by applying the notification dated 26/5/1977 referred supra. Next para. The learned counsel for the petitioners in both the writ petitions invited the attention of the court to the certificate issued by the Indian Air Force, which indicate that the petitioners were all employed in the Indian Air Force as Indian Air Force in various trade and were Indian Air Force as tradesmen. Full stop. Since the petitioners had satisfactorily completed the work of tradesmen satisfactorily, the Indian Air Force granted them a certificate, granted them a diploma in mechanical engineering in the concerned field. It also stated that the Government of India, Ministry of Education Social Welfare had issued a OM number F-18-52/75.
No, next minute, last one. F-18-19.
F-18-19/75/T2 dated 26/5/1977. Recognizing such diploma holders plus 10 years of technical experience in the appropriate fields as equivalent to a degree in engineering, and that the said certificate is valid for the purpose of selection of gazetted posts and services under the central government or the state government. He therefore contends that the petitioners had all worked for more than 10 years after their appointment as junior engineers, and hence they were deemed to possess an engineering degree and hence were entitled to be appointed as assistant engineers. Therefore, he contends that the impugned order holding that the petitioners had failed to produce documents to establish that they put in 10 years of service in the Indian Air Force after they were conferred with a diploma in mechanical engineering, is improper and falls foul of the notification issued by the Government of India. Full stop. He therefore contends that the case of the petitioners has to be considered in the light of the official memorandum issued by the Government of India referred supra. He also contends that the petitioner in WP number 38413 of 2013 should be given the said benefit, and his case should be considered for appointment by transfer to the post of assistant engineer. Full stop. Next para. The writ petition is opposed by the respondent in both the writ petitions. Full stop. Initially, the respondent in WP number 3989-3997 of 2013 contended that
there was no equivalence published by the Government of Karnataka.
contended that
there is no equivalence.
contended inter-alia
No, paragraph
Bande,
5.
bande, bande.
Paragraph 5. my lord.
Yes, note that contended inter alia that the petitioners had failed to produce the necessary certificates from the Government of Karnataka Technical Education, whether diploma plus 10 years technical experience was equivalent to a degree in engineering. Full stop. Hence, it was contended that the cases of the petitioner was not considered. Full stop. Later, an additional statement of objections is filed contending that the official memorandum relied upon by the petitioners purportedly issued by the Government of India, Ministry of Education and Social Welfare, was fictitious, and that the same fell for consideration before the Punjab and Haryana High Court in LPA number 26/2018. Full stop. In the said proceeding, an affidavit was filed by the Secretary of the Ministry of Human Resources, who stated that there was no such notification issued by the Government of India, Ministry of Human Resource Development. Full stop. It therefore stated that the petitioners have sought to rely upon a fictitious official memorandum to claim that 10 years plus diploma in mechanical engineering would be equivalent to a Bachelor of Engineering degree. Full stop. The respondent in WP number 3938413 of 2013 has also filed a detailed statement of objections and has enclosed therewith an order passed by the Punjab and Haryana High Court in CWP 16224 of 2016, where in similar circumstances, the High Court of Punjab and Haryana had accepted the claim of the Union of India that there was no notification dated 26/5/1977, and what was sought to be relied upon was not in existence. Full stop. The reference is also sought to be made to the judgment of the Punjab and Haryana High Court in LPA 26 of 2018, referred above. And the order passed by the Honorable Apex Court in Civil Appeal 591/2009, passed in filed against the judgment of the Punjab and Haryana High Court in CWP 17974 of 2006. Full stop. Therefore, it is sought to be contended with the respondent that the notification sought to be relied upon by the petitioners is fictitious, and hence it cannot be the claim of the petitioners that they possessed a Bachelor in Engineering degree on they putting in 10 years of service, cannot be accepted. Next paragraph. The learned counsel for the respondent in both the writ petitions reiterated the above contentions and contended that the notification relied upon by the petitioners is non-existent and fictitious, and therefore they cannot be held to possess a Bachelor of Engineering degree. Full stop. Next, I consider submissions of the learned counsel for the petitioner and the learned counsel for the respondent. Next para. The petitioners are highly relying upon a certificate issued by the Indian Air Force, which reads as follows. Copy of page 21 of the writ petition. The petitioners therefore contend that after they put in 10 years of technical experience in the appropriate field, the diploma in engineering would be equivalent to a degree in engineering and is valid for the purpose of selection of gazetted posts and posts and services under the central government or the state government. Full stop. No doubt, the respondent and others and other government entities have accepted this certificate from time to time and has appointed several persons by transfer to a higher post. However, the respondent has now contended that the notification, which is the basis of the claim of the petitioner itself, did not exist, and that the same was considered by the Punjab and Haryana High Court, which and was also upheld by the Honorable Supreme Court. Therefore, the question of now granting the benefit of equivalence to the petitioners based on the official memorandum referred supra does not arise. Full stop. The claim of the learned counsel for the petitioner that petitioners that the benefit is given to various employees by state government would be of no consequence as a mistake cannot be allowed to be petitioners are not entitled to any reliefs. Consequently, both these petitions are dismissed. Right.
Next mat. Next week will not have prepared.
ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ಹೊಟ್ಟೆ ಹಸಿವಾಗ ಏನು ಜಾಸ್ತಿ
Next
ಕೇಳ್ಬಾರ್ದು.
week.
Sir, may I mention serial number
ಟೈಮ್
59?
ಕೊಡೋದಿಲ್ಲ. ಏನ್ ಮಾಡೋದು?
12 ಏನು ಸಂಬಳ ಏನು ಇಲ್ಲ 20
ನೀವು ಇಷ್ಟೊಂದು ಕೇಸ್ಗಳು ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮೇಲೆ ಅರಿಯರ್ಸ್ ಅವೆಲ್ಲ ಮೇಲೆ ಅರಿಯರ್ಸ್ ಅವೆಲ್ಲ ಹಾಕಿದ್ರು.
ಅರಿಯರ್ಸ್ ಎಲ್ಲ ಒಂದ್ ಕೇಸಲ್ಲಿ ಹಾಕೋಬೇಕಪ್ಪ, ಇಷ್ಟೊಂದು ಕೇಸ್.
ಅರಿಯರ್ಸ್ ಗ್ರಾಂಟ್ ನೇಡು ಆಮೇಲೆ ನನ್ಗೆ ಇವನ್ನ ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಒಬ್ಬೆ ಮಾಡಿಲ್ಲ
ಆಯ್ತು.
ಅವೆಲ್ಲ ಇದ ಮೇಲೆ
ಸರಿ.
Passport matter, serial number 24. Serial wants speak. Filing rejoinder.
Copy.
I shall copy and.
Copy.
Okay.
Yes.
Well, the government advocate was supposed to file the statement of objections. Senior counsel is held up in 21, my lord, his part.
ಹೇಳಿ ಕೇಸ್ ಏನು ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ಏನು?
My lord, the president of the Apex Cooperative Bank, the petitioner have been appointed as a CEO of the Apex Cooperative Bank, Karnataka Apex Society, my lord, on 13/1/2025. Now, my lord, thereafter, my lord, he has made several communications regarding the appointment of the petitioner. Government have clarified in Annexure C that his appointment, my lord, should be placed before the RBI and NABARD permission. They are obtained, and they are obtaining. They are in the process of obtaining the permission of RBI and NABARD.
ಎಲ್ಲಿ ಅದು?
My lord, Annexure C, page number 12. It is the government's letter, my lord, which, my lord, further, may I take you directly, your lordships, to page number 7, paragraph number 7, page number 13, my lord. Hence, I want to submit that in the best interest of Apex Bank, RBI may kindly rectify the action taken by the government of Karnataka in good faith and in public interest. In my humble view, the procedural action obscure us from substantial issue of a good and capable officer being posted as CEO of Apex Bank. Now, my lord, the annexure C1 is also one such letter, my lord,
No, this
where
letter- This letter was in respect of the petitioner.
petitioner, his ratification of his appointment as a CEO. Now, my lord, in the meantime, the president writes a letter that is called in question before this honorable court, my lord, annexure F, intimation to vacate the office of CEO. That is called in question before this honorable court. Now, my lord, apart from this, my lord, I filed a rejoinder also today.
Annexure F ಅಲ್ಲಿ ಏನಂತಿದೆ?
My lord, intimation to vacate the office of the CEO. He wants me to vacate the office of the CEO. This is to intimate you that pursuant to your appointment to the post of Chief Executive Officer of Karnataka State, so and so, is in contravention of our 35B read with section 56 of the banking regulation, and said posting is also not in consonance with section 29G of the Karnataka Cooperative Societies Act and annexure E to rule 56 of the Karnataka Cooperative Society rules 1960. The above view is also reaffirmed by the General Manager, Governance Section, Department of Regulation, Central Office, Reserve Bank, Mumbai, whom I met personally on 4th March 2025. RBI has further directed the bank to address the non-compliance without any further delay and question why action was not taken immediately on receipt of the NABARD. In order to protect the interest of bank as well as board of directors from legal and regulatory non-compliance consequences out of in excess of my powers and duties as president of bank, you are requested to vacate the office of CEO immediately without any further delay. My lord, government has taken steps to ratify appointment by writing letters to the NABARD and RBI. Now, my lord, to ratify my appointment, he should have been placed before the board. Therefore, my lord, I just filed the rejoinder. Annexure G, which I have referred to, my lord, here also the government again writes to him to hold a board meeting. My lord, may I take your lordships to page paragraph number 4 in that, my lord. As per bylaws of the bank, the president, even though head of the bank, the executive powers in communicating the board decisions and acting upon the board always vest with the chief executive officer. Hence, the correspondence happened from your side to many authorities is not backed up by suitable provisions of law. The state government has already requested RBI as well as NABARD to ratify the posting of Shri M.K. Jagdish KS as the chief executive officer of the bank, and it is in waiting. Meanwhile, a letter to vacate the office has been given to the chief executive from your side, which is not in accordance with law and lacks authority.
Now, what is the Appointment procedure for CO.
29.
Cooperative Societies Act.
29G, capital G.
Senior ಬರ್ತಾರೆ ಅಂತ ಅದಕ್ಕೆ ಹೇಳ್ಸು. Senior is held up. May just,
No, then before senior comes, let us know at least the fundamental things. Early
29G,
senior,
my lord.
29?
29G has got an overriding effects of the Cooperative Societies Act.
29G na?
Yes, my lord.
Odu.
Sorry, my lord. I'll just take, I'm sorry. I've extracted in the rejoinder, my lord. I'll just read that one.
ಇಲ್ಲ book ಇಲ್ವಾ?
ಇಲ್ಲ, book ಇದೆ.
ತಗೊಳ್ಳಿ.
Place ಅದು. Appointment of chief executive. My lord, I'll take your lordships to two, my lord, subclass two. Subclass two in that. The government or the registrar may appoint chief executive officer, chief executive, where such society makes a request for appointment of a chief executive. My lord, 29G, proviso two, my lord.
Proviso 2 is on the appointment of the chief executive.
My lord, not that one, my lord, subclass two. The government or the registrar may appoint chief executive where such society makes a request for appointment of chief executive for a term which will not less than 5 years and remove such a chief executive. Provided further that,
ಗೊತ್ತಾಗ್ತಿಲ್ವಲ್ಲ ಶ್ರೀನಿವಾಸ್.
my lord,
29G2 na?
yes, my lord, G2.
G2 says on the appointment of the chief executive.
Roman 2, I
Roman
think,
2, Roman 2.
under the two provisos,
Yes, my lord.
under that second
Okay.
proviso, there is a
Ah.
Roman 2. In other
Roman 2.
cases,
In other cases,
Yes, please go on.
yes, my lord. In other cases, the government or the registrar may appoint chief executives where such society makes a request for appointment of a chief executive for a term which will not be less than 5 years and remove such chief executive. Now, my lord, your lordship may kindly come.
Society makes a request.
Society makes it.
Because assisted societies already government ke power ಇದೆ.
correct.
In other societies, only when the concerned society makes a request.
That's all,
Yes.
that's all.
On rule two, my lord, an appointment of chief executive to a cooperative society by the government or the registrar, the person appointed as a chief executive by the society, if any, by whatever name called shall cease to be the chief executive. 29G2, on appointment of chief executive to a cooperative society by the government or the registrar, the person appointed as chief executive by the society, if any, by whatever name called shall cease to be the chief executive. Lord. So therefore, if the society has done any appointed chief executive, it will cease to exist on appointment of the petitioner by the government itself. So therefore, it has got an overriding effect. Now, my lord, whether to, lord, to confirm the appointment of the petitioner, the matter should have been placed before the board of directors. If that has been done by the president, instead of reading all these letters, if the board ratifies my appointment, I'll be the chief executive officer. If board rejects it,
This is an assisted society.
No, it's not an asset.
Not an assisted. So therefore, it is, the society will have to make a request.
Correct.
my lord, in other cases, my lord,
Senior Bandhu.
Of course, my lord, all that we are confining our writ petition is only to the effect. Let the board accept or send it with recommendation or do it. It's not for the president to say, I will send it to RBI, etc. Because your lordship may kindly see. Objections ಕೊಟ್ರಾ? 29. 28C, my lord. I'm
Yes.
sorry. 28 capital C.
Yes.
Kindly see G and H. The board of a cooperative society may exercise all such powers and perform all such duties as may be necessary or expedient for the purpose of carrying out the functions under the Act and the rules and bylaws, without prejudice to the generality of the foregoing powers. Such powers and duties shall include, Your Lordship may kindly see G. To determine the cadre strength, establishment of society, qualification, pay scale, and other allowances admissible to each employee and other conditions of service of the employee as prescribed under Rule 3. H. To appoint the chief executive and such other employees as are not required to be appointed by chief executive of the society subject to the provisions of section 29G. In respect of the previous officer who was appointed, even according to the case of the respondent himself, Your Lordship may kindly see, he was appointed in June and they sent a communication to the RBI that is at page 21, annexure R3.
21 of the objections.
Objection.
Oh, page 20 may kindly be seen.
Yes.
It is dated 27/6, meeting of the board. It was resolved to reappoint so-and-so as chief executive officer of the bank on contract basis for a period of 11 months from so-and-so as per the fit and proper criteria of Reserve RBI. It is also resolved to authorize the president of the bank to fix the remuneration of the chief executive officer. Then under annexure R3, on 13/11/2024, RBI sends the confirmation.
Yes.
All that we are requesting is, yes, they may say we have this objection, that objection. Place it before the board. If the board accepts and sends it to RBI, very well. If the board rejects, very well. It is not for the president to do it in individual capacity.
Was may kindly see 29G, my lords, as your lordships rightly pointed out.
29G, no?
29G. The power of the board also, your lordships noted that under clause G or F, it is subject to provision of section 29G. Now may I read 29G? For every cooperative society, there shall be a chief executive who shall be appointed and be removable by the society, provided that subject to such rules as may be prescribed. In the case of an assisted society, which I am not, other than a society in a cooperative credit structure, which this is, the government or the registrar shall have the power to appoint. So therefore, I'll just pause here. In an assisted society, the government shall have the power. So there's no taking away the power of the government in an assisted society. Furthermore, provided further that a society in a cooperative credit structure shall have the option of getting the chief executive appointed by requesting the government or the registrar as the case may be. So therefore, in a cooperative credit structure, there is the option. So therefore, the power is with the society itself. It is only when certain cases, they may request the government or the registrar as the case may be to appoint. So in the previous case, as Mr. Jaikumar Patil pointed out, at annexure R2 to our objections, a chief executive, one Mr. C.N. Devraj, page 20, annexure R2. So it was resolved to reappoint C.N. Devraj, assistant registrar so-and-so. Then, my lords, on the next page, in the letter by the RBI, they refer to, right on top, my lords, refer to an application dated July 6th. So then we wrote to the RBI because under the scheme of the Act, under the scheme of the Banking Regulation Act, even as a cooperative bank, we need the approval of the RBI. So we write to the RBI to approve the board's resolution of appointing Mr. Devraj. Now kindly see what the RBI does in the meantime. Lords. That my lords will find at page 33. In the meantime, what happens? They approve Mr. Devraj's reappointment. January 13th, I'll just, before I take my lords to the document, January 13th, the petitioner is appointed by the government. Now, admittedly, my lords, the learned senior also has been fair enough to say that there is no ratification as on today by the RBI. Even the state government is on record saying that there is no ratification by the RBI.
No, but how did the government appoint him?
That is the whole question. Did the government have the power is the question. There was no request.
In the bylaw.
There has to be a request. So the government could not have unilaterally appointed. And therefore, even if that's my second point, assuming there is ratification by the RBI, that's a secondary question. Could the appointment have been made unilaterally by the government? Now, kindly see what the RBI says. Then the president, the respondent number 3, writes to the RBI saying, now I have 2 CEOs. January 13th, the petitioner is appointed. C.N. Devraj, the RBI has already approved. Now, what am I supposed to do? I write a couple of letters. Please clarify what the position is. Now, what the RBI writes, my lords will find at page 33. Now, please refer to your email letter. This is, of course, written to the secretary, but at page 34, in the CC section, copy forwarded to, my letters are also referred to at page 34. So I'll just read out the entire letter, my lords. Please refer to your email letter dated so. So in this regard, we would like to inform you that we have not received the copy of the C&R rules provided by Government of Karnataka or the posting of Shri M.K. Jagdish, who is the petitioner, as CEO of Karnataka so-and-so, stated to be attached along with the said mail. Nonetheless, on an application made by the bank, the Reserve Bank has already granted approval for reappointment of Shri C.N. Devraj as CEO of the bank for a term up to June 10, 25, vide RBI letter dated so-and-so. With regard to appointment of Shri M.K. Jagdish as CEO of the bank, in place of Shri C.N. Devraj, whose services will consequently get terminated before a specified tenure, we would like to draw your attention to the provision of Section 35(1)(b), read with Section 56 of the Banking Regulation Act, in terms of which, inter alia, no appointment, reappointment, or termination of a managing director or CEO by whatever name called shall have effect unless such appointment, reappointment, or termination is made with the previous approval of the Reserve Bank. In this regard, they refer to the Orissa High Court judgment. So therefore, what the RBI says is this: we have already approved the appointment of what's the name of this? C.N. Devraj. So therefore, there is no question of appointing somebody else in his place without our approval. So therefore, my lords, consequent to this letter, we request the petitioner to vacate the office. Now, my lords, whether they get RBI approval or not, whether that's possibly a subsequent event for if that has to be worked out, that's so be it. But even then, my lords, I would go one step further and say there is no question of the government unilaterally writing to the RBI seeking post facto approval. So therefore, my lords, as of now, we have a CEO in place. All we have said is please, and CEO has very wide-reaching powers. We can't multiple power centers taking decisions at the same time, which is why we said, please vacate your office. That's all.
Is the relief sought for in the writ petition?
To quash Annexure F, my lords, which is the letter at communication dated 5/3/25, where the respondent number 3 has asked the petitioner to vacate his office. So as of now, there is undisputedly no right for him to sit as CEO. So as of now, there is no question of the 5/3/25 letter being upheld.
Petition could really.
Is there any letter from the RBI approving
The
of?
bank has not sent at all. It is for the board to send.
No, but you look at 29G.
29G, of
Roman
course, my lord,
2.
a contention is raised that it will not come under assisted society, which has been a dispute which is going on because as a shareholder, it is not there. But for all the NABARD loans, etc., state government remains a guarantor for refinancing loans. Therefore, assisted society, it has been in dispute saying that is guarantee only for the end user, not for the bank. Several things are being contended. And Apex Bank is held to be state. Under Article 12, for the other purposes, it is held as state.
Let us see what is the meaning of an assisted society.
2A11, my lords.
Both.
Assisted society means a cooperative society which has received the government or state assistance in the form of share capital or loan or grant or guarantee for repayment of loan or interest. 2A11.
Yes.
Read it again, Malas. Means a cooperative society which has received the government or state assistance in the form of share capital, loan, grant or guarantee for repayment of loan or interest.
Yes.
And apex society is defined as a federal society whose area of operation extends.
Credit structure. Cooperative credit structure. B2.
Yes, yes. That is at 2B2.
Yes.
Cooperative credit structure means and includes a primary agricultural credit cooperative society by whatever name called, central cooperative bank, state cooperative bank, agriculture and rural development bank, and state agriculture and rural development bank.
Yes, sir. Ashtena?
Please.
Good. The petitioner has sought for a writ in the nature of certiorari to quash the communication dated 5/3/2025 bearing number so and so issued by the respondent number 3, by which the petitioner was directed to vacate the office of the chief executive officer of the Karnataka State Cooperative Apex Bank Limited. The petitioner has also sought for a writ in the nature of mandamus to direct the respondent number 3 not to interfere in the discharging of the official duties by the, discharging of his official duties. Next para. The petitioner claims to be an KS officer of super time scale and was posted as the chief executive officer of the Karnataka Cooperative Apex Bank, Bangalore, with a transfer notification dated 13/1/2025, bearing number so and so. After he was posted, he assumed charge on 13/1/25 and was discharging his duty. Full stop. He contends that the principal secretary to the respondent number 1 had communicated the issue of appointment of the petitioner to NABARD and RBI for ratification. Full stop. Ratification, void letters dated 25/2/2025. Full stop. On 15/1/2025, the respondent number 3 addressed a letter. D1 addressed a letter.
Annexure R3 that is there.
There is an annexure D1 on the
They have also produced, we have also produced.
15/1/25.
15/120.
15/1/25. Seeking clarification, 15/1/25, we argue to the manager, to the Reserve Bank of India, to the concerned officer of the Reserve Bank of India, seeking clarification regarding the posting of the petitioner as a chief executive officer. Full stop. The petitioner contends that the respondent number 1 by communication dated 18/1/25 had clarified that the president of the bank had not authorized, was not authorized to clarify any administrative matters. Full stop. The petitioner contends that the respondent number 3 was hell-bent to trouble him, addressed communications to the authorities including NABARD. Full stop. After a letter was received from the NABARD, the respondent number 1 furnished a detailed reply elaborating the experience of the petitioner in the field of cooperation and other service experiences, and therefore requested not to entertain any communication from the respondent number 3. So petitioner therefore contends that the respondent number 3 has no authority it had issued an intimation to vacate the office of the Chief Executive Officer in terms of a communication dated 5/3/2025. Being agreed by the same, the petition is before this court. Next para. The senior counsel representing the petitioner submitted that the petitioner was appointed as a chief executive officer of the bank. And the respondent number 1 had addressed a letter dated 25/2/2025 to the Reserve Bank of India to ratify the action taken by the respondent number 1 in appointing the petitioner. He contends that prior to this letter, the respondent number 1 had addressed a letter dated 21/2/2025 to the NABARD to ratify the action taken by it in appointing the petitioner as a chief executive officer. He contends that it is for the board of the Apex Bank to consider the appointment of the petitioner and forward it to the Reserve Bank of India and then appoint for approval. And the president of the bank has no authority to compel the petitioner to vacate the office of the chief executive officer. So the learned senior counsel in this regard invited the attention of the court to section 29C bracket sorry 28C 2 H and contended that it is a board which is empowered to appoint the chief executive officer and such other employees as are not required to be appointed as chief executive officer of the society subject to the provisions of section 29G. He therefore contends that the bank has no authority to issue a letter directing the petitioner to vacate the office of the chief executive officer. Besides this, he contends that the respondent number 1, on coming to know of the letter issued by the president of the bank, has addressed a letter dated 13/3/2025 and marked copies with the Reserve Bank of India, NABARD, calling upon and called upon the president of the society of the bank to convene a meeting of the board of directors and place the subject of posting the petitioner as the CEO for suitable decision. He therefore contends that until the board of directors of the bank decide upon the appointment of the petitioner, the president of the bank has no business to direct the petitioner to vacate the office of the CEO. Full stop. The writ petition is opposed by the respondent number 3. Respondent number 3, who has filed a detailed statement of objections containing inter-alia. That the Karnataka State Cooperative Apex Bank was established under the Karnataka Cooperative Societies Act 1959 for conducting banking activity and has become a scheduled bank. Full stop. It is an apex bank as defined under section 2A and a cooperative credit structure as defined under section 2B2 of the Act 1959. Full stop. It is contended that when cooperative societies engage in banking business, in addition to the regulatory laws applicable to cooperative societies, the central laws governing banking are applicable to an apex bank. Full stop. It is contended that the Reserve Bank of India by circular dated 25/6/21 directed all primary cooperative banks in the country to appoint managing directors / chief executive officers of such banks as per the eligibility criteria prescribed by it, and to remove / terminate all such managing directors, chief executive officers of banks who are not fit and eligible. Full stop. It is contended that the bank submitted an application dated 6/7/24 seeking approval from the Reserve Bank of India for reappointment of Mr. H.N. Devraj as the Chief Executive Officer of the bank. This appointment was approved by the Reserve Bank of India by this letter dated 13/11/2024 as per section 35B (1) small b, read with section 56 of the Banking Regulation Act 1959. Accordingly, Mr. C.N. Devraju was appointed as the reappointed as Chief Executive Officer on 27/6/2024 for a period of months, and that his tenure is valid up to 10/6/2025. In the meanwhile, the respondent number 1 appointed the petitioner as Chief Executive Officer with effect from the date of the notification. Full stop. The notification also mentioned about replacement of Mr. C.N. Devraj with immediate effect. Full stop. The petitioner has purportedly assumed the charge of the Chief Executive Officer of the Apex Bank during the subsistence of the tenure of Mr. C.N. Devraj, though there is no vacancy as the term of Mr. C.N. is not terminated by the board. Full stop. It's also contended that under section 29G of the Act 1959, a CEO to an assisted society is appointed by the state government, and in respect of other societies, a CEO is appointed on the request made by a society. Full stop. It is contended that the petitioner is contended that the bank is not an assisted society, but is a cooperative credit structure and an apex body, and therefore the appointment of the CEO has to emanate from the bank, and the respondent number 1 cannot impose Chief Executive Officer. It is also contended that while Mr. Devraj is still in office as the Chief Executive Officer, the respondent number 1 had no authority to appoint the petitioner as the Chief Executive Officer.
Also refer to
in
that
view of
page
the-
33, that letter at page, which
I'm
RBI
coming
has
to that. I'm
accepted.
coming to that. Full stop. In view of the confusion created by the appointment of the petitioner, the respondent number 3 addressed a letter dated 17/1/2025 to the Reserve Bank of India. Full stop. In response to the same, a reply dated 21/2/2025 was issued by the Reserve Bank, holding that the appointment of the petitioner is without prior approval or permission and the same is not in accordance with law. Full stop. The NABARD also addressed a communication dated 23/1/2025 to the respondent number 3, inquiring about the approval of the Reserve Bank for termination of the existing CEO, Mr. Devraj, and approval of the appointment of the petitioner as the CEO as per Section 35B reduced Rule 56 of the Banking Regulation Act. Full stop. The petition, respondent number 3 contends that on 4/3/2025, it held a meeting with the General Manager, Governance Section, Department of Regulation, Central Office, Reserve Bank of India, Mumbai. And in the said meeting, the respondent number 1 was directed to address non-compliance of the mandatory provisions of law without any further delay. And the President was questioned as to why action was not taken immediately on receipt of the letter dated 23/1/2025. Full stop. The petitioner, the respondent number 3 contends that based on the above, he addressed a letter dated 5/3/2025 requesting the petitioner to vacate the office with immediate effect. Full stop. It is contended that the respondent, being the head of the institution, has to act in accordance with the Banking Regulation Act and is answerable to the Reserve Bank of India, as any lapse would result in punitive action and sanction against the bank. Full stop. Therefore, it is contended that the appointment of the petitioner without prior approval of the Reserve Bank and the NABARD does not confer any right on the petitioner to continue in office, and therefore the impugned order passed by the respondent number 3 is just and proper. Next para. The learned senior counsel representing the respondent number 3 reiterated the above contentions and contended that under Section 29G, small Roman 2, under the proviso to Section 29G1, in respect of societies which are not an assisted society, the state government has no power to make an appointment. Full stop. We contended that the state government would come into the picture only when the society makes a request for appointment of a chief executive term, which shall not be less than 5 years. Full stop. He therefore contends that the appointment of the petitioner itself is illegal. Full stop. Further, he contends that the appointment of a chief executive officer has to be with the prior approval of the Reserve Bank of India and as prescribed under the Banking Regulation Act. And since the same was not done, the appointment of the petitioner was not in accordance with law. Full stop. Besides this, he contends that the term of Mr. Devraj, who was appointed as the chief executive officer after the same was approved by the Reserve Bank of India, has not come to an end, and hence, the petitioner cannot continue as the chief executive officer, and therefore, in that circumstance, the impugned order was passed, directing the petitioner to vacate the office of the chief executive officer. Next para. The consider submissions of the learned counsel for the petitioner, learned senior counsel for the petitioner, and the learned senior counsel for the respondent number 3. So the learned AGA also adopted the arguments of the learned senior counsel for the respondent number.
With regard to the post facto approval, Lordship, it was in process and.
The learned AGA submitted that appointment of the petitioner submits the appointment of the petitioner was though not
As per 35B.
Was not in accordance with Section 35B of the Banking Regulation Act, but a request was made by the respondent number 1 for an ex post facto sanction of the appointment of the petitioner. Therefore, he contends that until the Reserve Bank of India considered the case of the petitioner, considered granting ex post facto sanction, the respondent number 3 could not have issued the impugned order directing the petitioner to vacate the office of the chief executive officer. Next, I consider submissions of the learned senior counsel for the petitioner, the learned AGA for the respondent number 1 and 2, as well as the learned senior counsel for the respondent number 3. Next, an assisted society is defined under section 2A11 of the Act 1959, and the same is extracted below. Talking about an apex society is described under section 2A, and the same is extracted below. V2, which is extracted below. Full stop. Section 29C, sorry, under section 28, sorry, 29G, comma, G. There shall be a chief executive for every cooperative society who could be appointed and be removed by the society. Full stop. Proviso to section 29(1), G1 reads as follows, copy note. The second proviso to section 29G also reads as follows, copy note. The reading of the above makes it more than evident that in respect of an assisted society, the power to appoint a chief executive officer is exclusively with the government or the registrar. Appoint and remove a chief executive officer is exclusively with the government or the registrar. In all other cases, the government or the registrar may appoint chief executives only when such society makes a request for appointment. Full stop. Insofar as a society in cooperative credit structure, it shall have the option of getting the chief executive officer appointed by requesting the government or the registrar, as the case may be. Full stop. Though the learned senior counsel for the petitioner contended that the Karnataka State Cooperative Apex Bank is also an assisted society. Unfortunately, there is nothing on record to show that the Apex Bank Limited is assisted by the state government in the manner mentioned in section 2A11 of the Act 1959. Full stop. Therefore, it can safely be held that the Apex Bank is not an assisted society, and hence the petitioner could not have been appointed by the respondent number 1 as the chief executive officer of the bank. There is also nothing to show that a request was made by the Apex Bank in exercise of state government pursuant to such request had appointed the King Regulation Act.
35B, subsection 1, clause B.
Under section 35AB
Yes.
of the Banking Regulation Act. 35B, Banking Regulation Act. Comma. 35B 1B of the Banking Regulation Act. No appointment or reappointment or termination of appointment of a chairman, a managing or a whole-time director, manager or chief executive officer by whatever name called shall have effect unless such appointment, reappointment or termination of appointment is made without the previous approval of the Reserve Bank. Full stop. Admittedly, comma, the appointment of the petitioner was not with the previous approval of the Reserve Bank. Full stop. Though the petitioner has placed on record letters indicating that the respondent number 1 had commissioner, comma, since the appointment of the petitioner itself was not in accordance with the section 29G, comma, the letters addressed by the respondent number 1 and 2 to the Reserve Bank had no consequence. Consequently, the impugned order passed by the respondent number 3, calling upon the petitioner to vacate the office of the chief executive officer is just and proper. Besides this, the respondent number 3 has placed on record the reappointment of Mr. Devaraja, Inta Devaraja,
CN Dev.
Mr.
CN Dev.
Devaraj as the chief executive officer, whose tenure is till June 2025. Full stop. Therefore, the Apex Bank cannot function with two chief executive officers in place. Consequently, there is no merit in this petition. The same is dismissed.
One mention, with 35B read with 56 on
56. Rule 56.
Section 56.
56.
33. Parmeshwaraya,
33. 33, no? Parmeshwaraya.
Regarding alternative remedies concerned, my lord,
Ah,
admittedly, my lord, before acceptance, the petitioner has filed the application for the withdrawal of resignation, my lord. The case laws referred in the Education Act, my lord, regarding 131 is concerned, my lord. Wrongful division bench of this sample court heard that, my lord, wrongful termination of service of teacher.
then judgment ಇಲ್ಲಿ ತಗೊಂಬರ್ಬೇಕಲ್ವೇನ್ರಿ?
ಇದರಲ್ಲಿ ಕೋರ್ಟ್ ಮಾಡಿದಾರೆ ಸರ್.
ಕೋರ್ಟ್ ಮಾಡಿದಾರ್ರಿ.
ಸಾರಿ
ಜಜ್ಮೆಂಟ್ ಓದ್ರಿ ಏನಿದೆ ಅಂತ
ಸಾರಿ ಸಾರಿ kindly take up tomorrow, my lord.
What is this Parmeshwaraya?
Sorry.
ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನ್ 6 ಟೈಮ್ ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ತು ಬೇಕು?
Tomorrow.
ನಾಳೆ ನಿಮ್ ಕೈಲಿ ಆಗಲ್ಲ. ನಾಳೆ ಆಗುತ್ತಾ?
Please, my lord.
ಹಾ?
ಹೇಳಿ.
ತುಂಬಾ ದೊಡ್ಡ ಜಜ್ಮೆಂಟ್ ಇದೆಯೇನೋ?
ಇದೆ.
ಅದೆಲ್ಲ ಓದ್ಬೇಕಲ್ಲ? ನಾಡಿದ್ದು ಹಾಕೊಂಡ್ಲಾ?
No, day after tomorrow.
Yes.
number 40.
I appear for the
Sorry, my lord,
respondent.
20th, sir. 20th. 20th.
ಯಾವತ್ತು ಬೇಕೋ ತಗೊಳ್ಳಿ.
20th.
ಇರಮ್ಮ?
40.
40. ಹಾ.
Place my apologies for not being present in the morning. But on the last date of hearing, my lord, your lordship was pleased to hear me and noted the absence of the first respondent counsel, not therefore it was deferred. It's a case, my lord,
I'm sorry that I could not come as a head.
case, my lord, where
Hope will not ask for time today.
No, I'm not. ಅದಕ್ಕೆ fast.
Yes, Shankar.
my lord petitioner, my lord, is one of the contract employees, my lord, who has been working in the first respondent board. My lord, since 29/5/1997. But all the contract employees, my lord, were before this honorable court at an earlier point of time, filing a writ petition, not seeking regularization. my lord, this honorable court, my lord, found that Uma Devi's case, my lord, is not applicable to all the petitioners. Therefore, my lord, benefit was extended only to few petitioners who had already, my lord, past 10 years, as on the day, my lord, when the Uma Devi case, my lord, came into effect. But this honorable court, my lord, while disposing of the writ petition, my lord, took note of the fact, my lord, that all these petitioners have been working for more than 15 years. Therefore, one time, my lord, they should be provided.
Yeah, you're a data entry operator.
I was data entry operator. But when the writ petition, my lord, was at an earlier point of time, my lord, during the year 2010, when the writ petition was pending, this honorable court, my lord, permitted all those contract employees who had not applied for regularization through the regular process. They should be provided an opportunity because they were thinking that writ petition, they would be a favor. Therefore, my lord, they had not applied. This court, my lord, disposed of the writ petition, permitting all those contract employees who have not applied for direct recruitment to apply. And my lord, this honorable court was also pleased to pass an order saying that in view of the long continuous service, there was a, my lord, circular that came in the circular issued by the government for each satisfactory period of service for each year, 4% weightage should be given. Apart from the, my lord, marks that they take for the qualifying examination. My lord, the question that arose was whether it could be taken for the second time or only once such a facility, my lord, could be given. This honorable court, my lord, said that all these contract employees had applied. Therefore, give them one particular opportunity. My lord, accordingly, we applied. One of the petitioner, my lord, was one of the persons, my lord, who had applied. And the first respondent board, my lord, took a view that you have already taken in the year 2002 for a different post. Therefore, you have exhausted that
Same organization?
same organization. Therefore, for the second time around, you cannot take such a view. But in the very same disposed of writ petition, we have filed an application before this honorable court seeking for clarification as to whether that one time is available now, or if it is already exhausted, it will not apply. This honorable court was pleased to dispose of the said application, saying that since all these persons have applied now, one time opportunity should be given so far as taking weightage is concerned. But in the meanwhile, by keeping my application pending without giving weightage, they had notified the persons who are qualified for the data entry operators. As many as 20 posts were there, out of which 12 of them came to be selected. The remaining 8 posts appear to be vacant. And when they filed a writ petition before this honorable court, this honorable court was pleased to pass an interim order that it is subject to the result of the writ petition. During the pendency of the writ petition, insofar as those 12 persons got selected, they have given appointment letter saying that it is subject to the result of the writ petition. Now, those 12 persons we are not touching. Insofar as those posts which are still lying vacant, my percentage that weightage should have been considered in case. During the pendency of the writ petition, I had filed an amendment application where during the year 2014, government amended that particular one time basis is settled, and it can be taken for all continuously for all subsequent that was amended. The notification came to be presented before the court. At this stage, we have I continue to be working as a data entry operator even till this day, and I have not been removed from service. And they've also given an undertaking in the earlier writ petition that I will not be removed from service, though I am not selected. I'll continue as a contract employee. So the situation is this, if one-time settlement offer that is available to me.
Here is the order passed on that application.
That application, your lordships may kindly find at page 74. That is an order dated 18/9/2012. An IA came to be filed because after the writ petition I applied without taking weightage, they wanted to proceed. Therefore, I sought for clarification. This writ petition was disposed of, granting as many as 5 reliefs. The grievance of the petitioners in this application is that the weightage as ordered by this court has not been considered. The relief number 3 granted by this court, which reads as under. The weightage as prescribed by the government under the government order dated 12/11/2009 be given to such applicants who have made application for direct recruitment. The petitioners were having the experience in respect of the post to which they were working, having regard to their experience in the said post, weightage is given and accordingly it has been ordered by this court.
Where does it say that you can again renew?
My lord, that was the case when at that particular time, my lord, when the writ petition came to be disposed of, my benefit was already taken at an earlier point of time during the year two
But
thousand
did you
two.
ask the court,
Please, my lord,
whether you are entitled for making or claiming this benefit
please.
or weightage?
That was my application.
Perpetually,
That was my application.
no, was it perpetually till you land a job?
My lord, that at that particular point of time, this court felt that all these persons should be given one opportunity. That opportunity, my lord, comes into effect from the date when the, this honorable court disposed of the writ petition.
But did you bring it to the notice of the court that you had availed an opportunity earlier?
Please, my lord, that was raised by the other side, opposing the grant of weightage. They took up a contention, my lord, in this application. They took up a contention that during the year 2002, when I had applied for a different post in the same organization, that weightage has been, my lord, exhausted. Therefore, it cannot be done. However, in spite of that, my lord, final order came to be passed, and this clarificatory order came to be passed.
Correct?
No.
Clarification, yeah, clarification.
Clarification is,
There's
in fact,
nothing.
it's the other way around. The
Then,
court has categorically told my lords.
See, if you had made an application
please, my lord,
saying that you already taken advantage of the weightage
please, my lord,
and you wanted this weightage to be given for the next round.
please, my lord,
And if the court has not given you the benefit,
please, please.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ court ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
My lord, the writ order, my lord, your lordship can see.
So forget the writ order 89/2012 ಅಲ್ಲಿ. there's
ಈಗ
nothing
ಆಗ್ಲೇ
mentioned.
ನಾವು ಅದ್ರ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಟ್ಟಿದೀವಿ, ಅದರಿಂದ ಇನ್ನು ಮಧ್ಯದಲ್ಲಿ ಇನ್ನೇ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಕೊಡುವಂತದ್ದು ಏನು ಇಲ್ಲ ಅನ್ನೋ ತರ ಬಂದಿದೆ.
Court said weightage as prescribed the government under the government order so and so be given to such applicants who have made the application for direct recruitment.
Please.
If
Now-
you've taken the benefit and where?
Now, there is one more, my lord, event that has taken place, as your lordships, my lord, can see, annexure Q, my lord, which is part of the amendment application that came to be filed, where, my lord, that one-time basis word has been removed, and I have been authorized to, my lord, take forever, till, my lord, I get, my lord, selected. Your lordships can,
ಯಾವಾಗಿಂದ ಅದು?
annexure Q,
Perspective 2014 in that.
Annexure?
my lord, annexure Q, it is part of the amendment application, my lord, that came to be filed.
Annexure Q na?
Annexure Q, my lord, it is part of the amendment application that came to be filed on 2/6/2014.
Yes.
Lord, your lordships may kindly see the bottom portion of annexure Q. Lord, this is with reference to the, Lord, ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ಅಪಾಜಿ 2 EPC 2008 ದಿನಾಂಕ 12/11/2009 ಭಾಗಶಃ ಮಾರ್ಪಡಿಸಿ ಆದೇಶ ಭಾಗದ 7ನೇ ಪಂಕ್ತಿಯಲ್ಲಿರುವ ಒನ್ ಟೈಮ್ ಬೇಸಿಸ್ ಎಂಬ ಪದಗಳನ್ನು ಈ ಮೂಲಕ ತೆಗೆದುಹಾಕಲಾಗಿದೆ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಮಾಲಿನ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿಯಲ್ಲಿ ಗುತ್ತಿಗೆ ನೌಕರರು ಸಲ್ಲಿಸಿರುವ ಗರಿಷ್ಠ 15 ವರ್ಷಗಳ ಸೇವೆಗೆ ಮಾತ್ರ ವರ್ಷಕ್ಕೆ -4 ಕೃಪಾಂಕಗಳನ್ನು ಮಂಡಳಿಯ ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಾವಳಿ 1992 ಅನ್ವಯ ನಿಗದಿಗೊಳಿಸಿರುವ ವಿದ್ಯಾರ್ಥಿ ಶೇಕಡಾವಾರು ಅಂಕಗಳೊಂದಿಗೆ ಸೇರಿಸಿ ಅದರ ಮೊತ್ತವು ಒಟ್ಟಾರೆಯಾಗಿ -100 ಮೀರಿದ -100ಕ್ಕೆ ಸೀಮಿತಗೊಳಿಸಿ ಎಲ್ಲಾ ನೇರ ನೇಮಕಾತಿಯಲ್ಲೂ ಅನುಕೂಲವಾಗುವಂತೆ ಅವಕಾಶ ನೀಡಲು ಸರ್ಕಾರವು ಆದೇಶಿಸಿದೆ. ಈ ಆದೇಶ ಸಿಬ್ಬಂದಿ ಮತ್ತು ಆಡಳಿತ ಸುಧಾರಣಾ ಇಲಾಖೆ ಸೇವಾ ನಿಯಮಗಳು ಶಾಖೆ ಟಿಪ್ಪಣಿ ಸೋ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯ ಹೊರಡಿಸಲಾಗಿದೆ. This was also gazetted, my lord, by annexure R. Annexure R, my lord, various gazetted information is available, but the relevant one, my lord, would be in the last page of annexure R, where the government order, my lord, has already been gazetted. Therefore, my lord, if this particular, because it's a situation, my lord, where subsequent to 2012, for data entry operator, they are not at all calling, my lord, any, my lord,
No, where's the application filed by you before the coordinate bench?
my lord, the application is not produced before the court.
Memo, what it be?
No, the application.
Clarification ಕೇಳಿದ್ರು ಇಲ್ಲಿ.
No, in the court, what he has filed.
ಇದೆಯಲ್ಲ ಇಲ್ಲಿ
Annexure P, Annexure P minute,
107.
please. Hello, 102 ಇದೆ Annexure P ಅಂತ.
Why you can't extend this benefit of
That's the-
2014 notification?
I make the point of law, my lords, then I tell the facts. The admitted position of fact is that, my lords, on admitted position of law in terms of notification, in all the notifications which the petitioner has applied for, there's a specific statement which goes on to say that this benefit is for once for all. If you can apply and take that benefit at once, you can't keep repeating on that. The petitioner here had applied back in the year 2002, which is an admitted fact in their paragraph number 7. Our time, she didn't apply for one, she applied for 2 posts. A ಎರಡು post ಅಲ್ಲಿ 44% ಅಂತ 6 years experience ತಗೊಂಡು ನಾವು we have given 24% to her. Still she didn't qualify, madams. Now, that's the second factum of the issue is that in 2009 she applies for it, madams, and she seeks for the same benefit. Then, madams, it gets rejected on the fact that she does not get that 4% weightage.
This was the second time.
Second time. Now, during that time, what has happened is that, is what my friend told, there have been a batch of petition, the association has gone to the High Court, has come before my lords, and an order has been passed. May I pass the copy of the judgment? The reason I'm passing, my lords, is that I've entered this petition a bit later, my lords, purti copy is done. But still, my lords, I just want to point out a couple of observations here.
That's an Annexure F to the.
At page 26, my lords, paragraph number 29. The same contains the petitioner is urging before my lords. May I read, my lords, with permission? The government order dated 12/11/2009 itself speaks that it is a one-time measure, and even according to the judgment of the Apex Court in Umadevi's case, if daily wages ad hoc contract employees are qualified and fulfill the norms prescribed therein for regularization, their case shall be considered as one-time measure. The Apex Court reconsidered judgment in Umadevi's case in so far as the norms prescribed therein are concerned, and held that one-time measure would be concluded only when all the employees were entitled to be considered in terms of paragraph 53 of this judgment in Umadevi's case. Once cases of such employees are considered and given benefit of weightage and also qualification, I do not think there can be any justification to the said benefit again and again. If they do not qualify despite giving such benefit, it cannot be said that such weightage and benefit should be extended till they are selected. That's paragraph 30. Since in this case, the board stated that it would extend the benefit of weightage as per government order dated so and so, 12/11/2009, applications of the contract employees will be considered as if the rules were made under the rules of 1992, and if the selection is made by considering those 2 criteria, one-time consideration stands fulfilled. My lords, with this observation, my lords, the operative portion is at page number 28.
No, will you put it on affidavit that you're not given the benefit of this weightage to persons more than once?
I
Will you
will,
put it on affidavit?
yes, my lords, I will instructions. And I'll put it there.
One submit that the benefit of weightage as per the government order dated 12/11/2009 more than once. He therefore contends that the petitioner is not entitled for one more opportunity. Full stop. He contends that the coordinate bench of this court in WP number 27983-984 of 2012 had therefore precisely held that the benefit of weightage cannot be given until the petitioner is selected. Per contra, the learned counsel for the petitioner submits that the state government has now modified its order dated 12/11/2009. Of a,
Annexure Q, my lord, notification,
which of a notification dated
24 to 2014.
one-time measure in the
One-time
notification.
basis.
The government order dated 12/11/2009. It therefore contends that the effect of the subsequent notification is that the petitioner is entitled to claim the benefit of weightage until he is selected. Full stop. Next para. The learned counsel for the respondent number one, however, contended that following the government order dated 12/11/2009, the benefit of weightage was granted only once to all the employees and not more than once by filing an affidavit. Learned counsel for the respondent number one readily agreed to do so. Consequently, the learned counsel for the respondent number one is directed to file an affidavit of a responsible person of the respondent number one, declaring therein that the benefit of the notification dated 12/11/2009 was given only once.
Next week.
On date.
That's one more. In fact, for the amendment which came to be allowed, that's, we have taken a statement. That's, our submission is that it's applicable only prospectively, even if it is applicable. And anyways, I'll put that on an affidavit
Consider that, yes.
saying that if more months.
Let's see whether you accepted it prospectively, retrospectively,
That's 2012 probably. Yeah.
whether other considerations have worked.
That's a readily acceptable law. Order dictation.
No,
That's
Marty will tell us.
Yes, that's
You are bound to file an affidavit.
yes, that's a see, please, that's
Hmm.
43, Vivek Holla.
The last occasion, my lords, we were the direct recruitees, my lords. Certain peoples were deputed to the second respondent institution from the government departments.
Hmm.
They actually, by way of an absorption, they were absorbed to the second respondent.
Undertaken that they will be placed,
Please,
the
They are
absorbers.
about, now they are presently, my lords, they are senior most, my lords.
Correct, whether you undertake that the absorbees will be placed below the petitioner.
Yes, my lords.
ಎಲ್ಲಿದೆ?
ಅದು affidavit ಅಲ್ಲಿ ಹೇಳಿದೀನಿ sir.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು? The petitioner is challenged
I still,
an order dated 9/4/2013 bearing number so and so issued by the respondent number one, by which the petitioners were placed below,
please, my lords.
petitioners were placed below the respondents, right, below the absorbees.
Please, my lords.
Pursuant to their absorption in the respondent number two,
Please, my lords.
full stop. Next para, the sum and substance of the case of the plaintiff, the petitioners, is that they were all directly recruited as
Assistant,
professors in the respondent number two. Full stop. They contend that many other persons were appointed as ಏನು ಹೊರಗಡೆಯಿಂದ ಬಂದಿದ್ದ ಏನಿದು?
please, my lords.
Were they deputed? They contend that several doctors who were working in district hospitals were deputed in the Department of Health and Family Welfare was not equivalent to the post of an assistant professor under the Department of Health, Government of Karnataka. Nonetheless, the respondent number 1, decided to absorb the deputies from the Department of Health and Family Welfare, and in terms of the impugned, place the absorbees above the petitioners. The petitioners are therefore before this court challenging the said order. Full stop. When this petition was taken up for final hearing, an affidavit is filed by the director of the respondent number 2, which reads as follows. Since it is specifically stated that specifically stated that the petitioners who are directly recruited are placed for the absorbees in the seniority list, and that the seniority of the petitioners will not be affected by the absorption, this petition deserves to be disposed of in the light of the affidavit filed by the director of the respondent number 2. Consequently, the respondent number 2 shall ensure for all purposes that the seniority of the petitioners shall be placed above the absorbees Full stop. Yes.
Great.
Next, serial number 44, respondent, serial number 45, Rangnath is Joyce. Serial number 45.
I'm appearing for respond number 3 and 4, Your Honor. Please short time for hearing, Your Honor.
Mr. Rangnath Joyce. There is no appearance for the petitioner. List on date.
4th March. Serial number 46. The Swami,
Only respond.
Yes, madam. T.R. Aparna. Where is your advocate? Where is your advocate, madam? Yes, Rangnath Joyce. He is online but not speaking.
Rangnath Joyce. Serial number 45, sir.
Second case, I'm not filing any objection. It is related to my case only. Second case, they are not government and.
Final time. Yeah, kindly have it next week. I am filing the synopsis.
Yes, Nanjan Song.
Synopsis and also written argument.
Petitioner.
I'm filing the written arguments and the synopsis.
Yes.
The petitioner, my lord, in called in question, my lord, the order passed by the respond number 1 as per annexure, we told this, 50% of the pension amount. Lord, petitioner, lord, was an employee of complaint, lord, 15/5/2002, lord. He was, lord,
What is the mistake in the inquiry?
Inquiry report kind of what happened. Same set of fact, my lord, was initiated, my lord, in special case number 38 of 2004, as per annexure F, my lord. In the annexure, my lord, the honorable district judge, my lord, after considering all the evidence given by the, my lord, prosecution, and I held that, my lord, acquitted me, my lord, from the offense. And my lord, the respondent, my lord, KPCTL, my lord, has filed a criminal appeal
237 of 220. This all quote, my lord. This on the page number, my lord, 74, my lord. Page. The observation made by the this all quote.
ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಆದ್ರೆ ಏನಾಗುತ್ತೆ?
But ಇದರಲ್ಲಿ criminal case ಅಲ್ಲಿ, my lord, this all court held that, my lord, there is no demand of bribe. Bribe demand.
On the point. What is the law?
Law, my lord, an inquiry is a separate inquiry is conducted. My lord, but this all court, my lord, held that, my lord, there is no demand. And my lord, the amount ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ, ಅವ್ರೇನು ಫಸ್ಟ್ ಇದ್ರಲ್ಲಿ ಹೇಳೋದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ 3,000 ರೂಪಾಯಿ 3,500 ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ರು, ನಾನು 1,500 ಕೊಟ್ಟೆ, ಇನ್ನು 2,000ನ ಅವತ್ತು ಆಸ್ ಆನ್ ದಟ್ ಡೇಟ್ ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಲಾಡ್ ಅವ್ರು ಏನು ಅಮೌಂಟ್ ನಮ್ಮನ್ನ ಇದು ಮಾಡಿದ್ರು, ಆ ಡೇಟ್ ಅಲ್ಲಿ ಲಾಡ್ ವರ್ಕ್ ಹ್ಯಾಸ್ ಬಿನ್ ಆಲ್ರೆಡಿ ಓವರ್.
Technically, if you have been acquitted, that is not a ground. Technically, if you have been acquitted.
Same set of witness, my lord,
Could
same
be,
set of
Mr.
fact.
Technically, if you are acquitted, no, please come to paragraph number 19,
19 of
the judgment of the court.
Page number 57. One more reason as to why the court is rejecting the case of prosecution is that it is a positive evidence that he has already sent the estimate sought for. If it is found in the evidence of even the shadow witness that the records in connection with the estimate being sent were verified by him along with other pancha, and he identifies the entry as per exhibit P8 and P8A would show by 95212. The paper of the complaint are sent, whereas the complaint itself is filed on 16/5/2002. One more, so my lord, as on the date, my lord, complaint, my work has been done, my lord, I have already sent my.
Is that sufficient? Maybe for PC Act, what you say may be sufficient. PC Act, that defense may be sufficient.
ಅಲ್ಲ, ಅವರು ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿರೋದು ಅಮೌಂಟ್ ಏನ್ ಹೇಳ್ತಾರಲ್ಲ, ಅದು ಇಸ್ ಎಂಟೈರ್ಲಿ ಡಿಫರೆಂಟ್. ಇಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅಲ್ಲಿ 3,500 ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ 3,000 ಹೇಳ್ತಾರೆ. ಅಮೌಂಟ್ ಕೊಟ್ಟಿರೋದ್ರ ಬಗ್ಗೆ ಎಂಟೈರ್ಲಿ ಡಿಫರೆಂಟ್ ವರ್ಷನ್ ಟೇಕನ್ ಬೈ ದಿ ಕಂಪ್ಲೇಂಟ್.
What is the law, mister? What is the law on the point?
Lord, since Lord, the special case ಅಲ್ಲಿ
Please point out, acquittal in a criminal case should also result in closure of the departmental proceedings. Adantan ಹೇಳ್ತಿರೋದು. What is the law on the point?
And the evidence, my lord, in the evidence, my lord, kindly peruse, my lord, evidence, PW1, my lord, is the evidence of the PW1. PW2 is the complainant, my lord. In his evidence.
ಓದ್ಕೊಂಡ್ ಬರ್ತೀರಾ ಕರೆಕ್ಟ್ ಆಗಿ? ನೋಡ್ಕೊಂಡ್ ಬರ್ತೀರಾ?
The evidence ಅಲ್ಲಿ
ಅಲ್ರಿ, what is the law on the point?
I will.
You are not even prepared and you have come ready to argue. ನೀವು ಪ್ರಿಪೇರ್ ಆಗಿಲ್ಲ ನೀವು.
Evidence description is the main submission.
For the petition seeks time, this on.
4th March. Date may.
Serial number 47.
There is a list of judgments, ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. GM ಟ್ಯಾಂಕ್, ಆ ಕಲ್ನಲ್ಲು ಏನೇನೋ ಇದಾವೆ.
ಆಂಟನಿ ಕೇಸ್ ಇದೆ.
ಆಂಟನಿ ಆಮೇಲೆ ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ GM ಟ್ಯಾಂಕ್ ಬಂತು, ಅದಾದ್ಮೇಲೆ ಅದೇದೋ ಕಲ್ನಲ್ಲಿ ವಾಟ್ ಇಸ್ ದಟ್, ಅದ್ ಬಂತು.
PTCL versus Nagraj itself, there the court has.
ಅದೆಲ್ಲ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಬಂದ್ರೆ ಹೆಂಗೆ?
Lord, one submission, 24th, I'm not there, 25th if it may be taken up.
Madam, all these matters, old matters will be listed on Monday.
Station.
ನಿಮ್ ಕಲೀಗ್ ಯಾರೋ ಇರಕ್ ಹೇಳಿ ಸಾಕು. Yes.
25
ನಿಮ್ ಕಲೀಗ್ ಯಾರೋ ಇರಕ್ ಹೇಳಿ. We can't change the rule only for you.
Final year in matter.
Madam, we can't change the rule only for you. All old matters were listing on Monday up to 2018. So we can't change the rule for you.
Obliged.
My lord, this is what has happened is, my lord, under the that is urban family planning welfare centers are being run by certain urban family plan welfare centers are being run by all over India, mother and child care. And what happens is the salaries to these workers who work in this urban family welfare centers are being paid by the central government by way of grant in aid to them.
Naik and Niva,
Swami,
you are appearing in serial number 47.
47.
Okay, NR Naik and
49.
I'm sorry.
Serial number 47, NR Naik.
There is no representation for the petitioner.
That's, I appear for the respondent.
Bandila yen mas.
ಅದೇ ಬರ್ತಲ್ಲ
Last time bandilwa.
ಕೇಸ್ ಸ್ಟ್ರಾಂಗ್ ಇಲ್ಲ ಅಂತ ಬರೋದಿಲ್ಲ. Earlier and all the inquiry officer, all of it, advocate was changed and all that.
There is no representation for the petitioner as a last chance list on it.
Serial number 48, H.A. Anand. Serial number 48.
The petitioner. The petitioner, my lord, is the retired employee of the Karnataka state.
Manjesh. Yeah, what is challenged?
My lord, annexure A and B, my lord, withholding of retirement benefits, my lord, of rupees 9,02,000 rupees, my lord, from the retirement benefits, my lord. On the ground that, my lord, while working as a warehouse manager, there is a storage loss in the Malabinuru warehouse, my lord. Departmental inquiry was held. In the departmental inquiry, my lord, the charge number 1 was proved. And based on the same, my lord, the punishment order came to be passed, my lord. Now, my lord, after all these developments, the Karnataka State Warehousing Corporation has been appointed as procurement agency from the year 2004-5 till 2014 and 15, my lord, for the procurement of maize and paddy, my lord, under the MSP scheme, minimum support price scheme from the farmers, my lord. This petitioner, my lord, was while working as a warehouse manager in the year 2013-14, my lord, 9 and 10, my lord, the maize was procured from the farmers, my lord. My lord, whenever the under the MSP scheme, maize and paddy was procured from the farmers under the MSP, there is a inordinate storage loss, my lord, in all over Karnataka, my lord. Therefore, my lord, the warehouse corporation has appointed the expert committee under the chairmanship of Deputy Registrar of Cooperative Societies, my lord, to assess the reasons why there is a storage loss occurred in the warehouses, my lord. The report was submitted stating that, my lord, in spite of taking all precautionary measures by the warehouse manager, there was a inordinate storage loss due to various reasons, my lord. Now, my lord, the warehouse corporation, my lord, respondent number 1, by accepting the said report, has forwarded the proposal to the state government, taking all precautionary measures. There is a storage loss as a one-time measure. Admittedly, my lord, the warehouse corporation, based on the reports, has come to the conclusion that, my lord, their employees are not responsible for the said storage loss.
Illegal thing.
My lord,
Rats.
ಹೌದು ಮೇದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಒಂದೊಂದು ವರ್ಷ ಸ್ಟೋರೇಜ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಮೆಕ್ಕೆಜೋಳ ಅದು ಏನಾಗಿದೆ ಡ್ರೈಯೇಜ್ ಬಂದಿದ್ಬಿಟ್ಟಿದೆ ಪುಡಿ ಆಗಿ ಹೋಗಿದೆ ಸ್ವಾಮಿ therefore there is a storage loss. The allegation is only storage loss. ನಿಮ್ಮ ಅವಧಿಯಲ್ಲಿ ನೀವು ಇಷ್ಟು ಪ್ರೊಕ್ಯೂರ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ ರಿಲೀಸ್ ಮಾಡುವಾಗ ಇಷ್ಟು ಕಮ್ಮಿ ಆಗಿದೆ ಅಂತ ದಟ್ ಇಸ್ ದ ಈ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ಮಲಡ್ ನನ್ನ ಅವಧಿಯಲ್ಲಿ 2.65% ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಆಗಿದೆ.
ಎಷ್ಟು 2.65
ಟನ್ ಮಲಡ್ ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜಸ್ ಮಲಡ್ ಆಸ್ ಪರ್ ಆರ್ಟಿಕಲ್ ಆಫ್ ಚಾರ್ಜಸ್ 126.574 ಮೆಟ್ರಿಕ್ ಟನ್ ಸರಾಸರಿ 2.65 ಟನ್ ಇದು ಪರ್ಸೆಂಟೇಜ್
ಎಷ್ಟಾಯ್ತು ಅಲ್ಲಿಗೆ?
ಟೋಟಲಿ ಸ್ಟೋರೇಜ್ ಮಾಡಿದ್ದು 4,000 ಮೆಟ್ರಿಕ್ ಟನ್.
2% ಎಷ್ಟಾಯ್ತು?
That is 126 ton.
126 metric tons of storage loss.
Storage loss. Out of 4,646 metric ton. That is 2.65% storage loss ಆಗಿದೆ. MSP scheme ಒಳಗೆ from the year 2004-5 to 15-16 ವರೆಗೂ there is a storage loss of about 23 crores in the warehouse alone.
Government ಏನ್ ಮಾಡಿದ್ರು?
Government is not the employer of the petitioner, my lord. ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಸ್
ಸ್ಟೋರೇಜ್
ಮಾಡಿಲ್ಲ.
ಹ್ಮ್.
ಇವರು ಜಿಕೆವಿಕೆ ಕಲಿಯೋರು. ಅವ್ರ ಪ್ರಕಾರ ಇಫ್ ದ ಮೇಜ್ ವಾಸ್ ಸ್ಟೋರ್ಡ್ ಫಾರ್ ಮೋರ್ ದನ್ 1 year, ದೇರ್ ವಾಸ್ ಅವರೇಜ್ ಸ್ಟೋರೇಜ್ ಆಫ್ 4.29% ಸ್ಟೋರೇಜ್ ಬಾರ್ ಲಾಸ್ ಬರುತ್ತೆ ಅಂತ ಅವ್ರು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎನ್ಕ್ವೈರಿ ಕೇಳಿದ್ರೆ ಅದೆಲ್ಲಾನು
ಅಲ್ಲ ಇದೆಲ್ಲ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇವೆಂಟ್ಸ್ಗಳು.
ಅಲ್ಲ, ಈ ಎನ್ಕ್ವೈರಿ ಕೇಳಿದ್ರೆ ಏನಾದ್ರು ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಎಷ್ಟು ಬರುತ್ತೆ, ಪರ್ಮಿಸಬಲ್ ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಎಷ್ಟಿದೆ ಅಂತ.
ಪರ್ಮಿಷಬಲ್ ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಇವ್ರ ಪ್ರಕಾರ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಕಾಸ್ಟಿಂಗ್ ಶೀಟ್ ಪ್ರಕಾರ ಎವ್ರಿ ಇಯರ್ 1% ಅಂತ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ಫಾರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ 6 months ಸ್ಟೋರೇಜ್ ಇದ್ರೆ 1% ಅಂತ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಡಿಡಕ್ಷನ್ ವಾಸ್ ಗಿವನ್. ನನ್ನ ಕೇಸಲ್ಲಿ 1% ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 1.65%ಗೆ ಯಾವ ಡಿಡಕ್ಟೆಡ್ ದಿ ಬೆನಿಫಿಟ್ಸ್, ರಿಟೈರ್ಮೆಂಟ್ ಬೆನಿಫಿಟ್ಸ್. ಈಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ
ಗವರ್ಮೆಂಟ್ ಅವ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಲಿ ಆಮೇಲೆ.
ಅಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಅವರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡೋದಲ್ಲ ಸ್ವಾಮಿ. ವೆನ್ ಒನ್ಸ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೈ ಎಂಪ್ಲಾಯರ್ ಹ್ಯಾಸ್ ಕಮ್ ಟು ದಿ ಕನ್ಕ್ಲೂಷನ್ ದಟ್ ಮಲಾಡ್ Anshar Q kindly see malad.
Counsel for the petition 6 times list on ಗಿಡಗಳ ಜೊತೆ
ಅಲ್ಲ,
ಮನುಷ್ಯರನ್ನು ಕಳ್ಳರಾಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಅಪ್ರೂವಲ್ ಅಂದ್ರೆ
26 ಟನ್ ರೀ. ಟಾಕಿಂಗ್ ಆಫ್ 126 tons.
ಹೌದು ಸ್ವಾಮಿ. ಅಲ್ಲ,
ಪಕ್ಷಿ ತಿಂದೋಯ್ತು.
ಅಲ್ಲ, ಇಟ್ ವಾಸ್ ಸ್ಟೋರ್ಡ್ ಫಾರ್ 1 year. 1 year ಆದಾಗ ದಟ್ ಇಸ್ ದ ಸೈಂಟಿಫಿಕ್ ರಿಪೋರ್ಟ್ ಇದೆ. 1 year
ತಕ್ಕೋವಾಗ್ಲೇನೆ ಕಡಿಮೆ ತಗೊಂಡ್ಬಿಡ್ತೀರಿ.
ಅಲ್ಲ, ಏನಾಗುತ್ತೆ MSP ಒಳಗೆ ತಗೋಬೇಕಾದ್ರೆ ಮಾಯ್ಚರ್ ಕಂಟೆಂಟ್ ಅಂತ ಇರುತ್ತೆ ಸ್ವಾಮಿ. ಇಮಿಡಿಯೇಟ್ ಹಾರ್ವೆಸ್ಟಿಂಗ್ ಮಾಡ್ಕೆ ಬಂದು ಕೊಟ್ಟು ಬಿಡ್ತಾರೆ ಫಾರ್ಮರ್ಸ್ಗಳು. ಜಾಸ್ತಿ ಹೆವಿ ಕ್ರಾಪ್ ಬಂದಾಗ ಅದು ಮಾಯ್ಚರ್ ಕಂಟೆಂಟ್ ಏನಾಗುತ್ತೆ,
ಕಂಟೆಂಟ್ ನೀವು ತಗೊಳ್ಳೋದೇ ಇಲ್ರಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, MSP
ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ.
MSP ಒಳಗೆ ಅಂಡರ್ ದಿ MSP ಸ್ಕೀಮ್
ಆದ್ರೂ ಕೂಡ ಮಾಯಿಶ್ಚರ್ ಕಂಟೆಂಟ್ ಇದೆ ತಗೊಳ್ಳಲ್ಲ.
ಅಲ್ಲ, ಹೆವಿ
ಯಾವ ತರ ಮಾರಾಟ ಮಾಡಕ್ ಹೋಗಿದ್ರೆ ನೀವು?
ನಾನು
ಎವರ್ ಗಾನ್
ಮಾಡಿಲ್ಲ.
ಇಫ್ ಯು ಎವರ್ ಗಾನ್ ಓನ್ಲಿ ದೆನ್ ಯು ವಿಲ್ ನೋ.
ಅಲ್ಲ, MSP ಒಳಗೆ ಬಂಪರ್ ಕ್ರಾಪ್ ಬಂದಾಗ MSP ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಓನ್ಲಿ ವೆನ್ ದೇರ್ ಇಸ್ ಎ ಬಂಪರ್ ಕ್ರಾಪ್.
ಒಳಗಡೆ ಮಾಯಿಶ್ಚರ್ ಇದ್ರೆ ಒಂಥರ ಏನಂತಾರೆ ಅದಕ್ಕೆ, ಫಂಗಸ್ ಬರುತ್ತೆ.
ಹೌದು,
ಅವರೇ ದಡ್ರಲ್ಲ ತಗೊಳ್ಳೋರು.
ಅಲ್ಲ, ಇಲ್ಲಿ ಅವರು ಬಿಸ್ನೆಸ್ ಮ್ಯಾನ್ಗಳು ಆತರ ಇದು ವ್ಯಾಪಾರಗಳು
ಕಳ್ಳರು. ನೀವು ಇರ್ತಿರಲ್ಲ ಮ್ಯಾನೇಜರು, ಅದು 49 kg ಹಾಕ್ಸ್ಕೊಂಡಿರ್ತೀರ ಮುಟ್ಟೆ. ಆಕ್ಚುಲಿ 51 kg ಹಾಕೋಬೇಕು. ಚೀಲದ ತೂಕ, ಹ್ಯಾಂಡ್ಲಿಂಗು ಎಲ್ಲ ಸೇರಿ ಅರ್ಧ kg ಮೂಟೆ ಮೇಲೆ ಹಾಕೋಬೇಕು.
ಅಲ್ಲ,
ನೀವೇನ್ ಮಾಡ್ತೀರ, 49 ಹಾಕ್ಸ್ಕೊಂಡ್ಬಿಡ್ತೀರ. ಇನ್ನು 1.5 kg ಗೋವಿಂದ.
ಅವ್ರ ಕಮಿಟಿ ಎಕ್ಸ್ಪರ್ಟ್ ಕಮಿಟಿ ಅಂತ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅವರ ರೆಕಮೆಂಡೇಶನ್ ಪ್ರಕಾರನೇ ಇಷ್ಟು
ಡೀಲಿಂಗ್ ವಿತ್ ಥಗ್ಸ್. We are dealing with thugs. On managing really managically ಒಂದೊಂದು ಲೆವೆಲ್ ಅಲ್ಲಿ ಅಟೆಂಡರ್ ಒಂದು ಲೆವೆಲ್ ಅವ್ನು ನಡೀತಾನೆ. ಎವ್ರಿಬಡಿ ಡಸ್.
ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಬಂದ್ರದ್ದು ಬರೀ MSP ಆದಾಗ ಮಾತ್ರ ಬಂದಿದೆ.
ಒಂದ್ ಮೂಟಲ್ಲಿ 20 ತೂತ್ ಇಟ್ಟರೆ ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಆಗದೆ ಇನ್ನೇನಾಗ್ತದೆ? ಒಂದು ಮೂಟೆ ಒಳಗೆ ಇಡೋರಲ್ಲ ನೀವೇ. 126 metric tons 2600 kg ಸ್ಟೋರೇಜ್ ಲಾಸ್ ಹೆಂಗಾಗಕ್ಕಾಗುತ್ತೆ ಅಂತ ಒಂದು ವರ್ಷದಲ್ಲಿ?
ವೇರಿಯಸ್ ರೀಸನ್ಸ್ ಮಲಾಡ್ ಆಸ್ ಪರ್
ವೇರಿಯಸ್ ರೀಸನ್. ನೀವೇ ರೀಸನ್
ಅಲ್ಲ, ನಾವಲ್ಲ, ಅವ್ರ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ GKVK ಅವರು.
Number 3. ಹೌದು, ಕಂಟೆಸ್ಟಿಂಗ್ ಪಾರ್ಟಿ ಸ್ವಲ್ಪ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಬೇಕು ಇದ್ರ ಮೇಲೆ. ಇಟ್ ಈಸ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ಸ್ಯಾಲರಿ. ನೌ ಇಟ್ ಈಸ್ ಕ್ಲೋಸ್ಡ್. ದಟ್ ಸ್ಕೀಮ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕ್ಲೋಸ್ಡ್. I just make my small submission.
No, if it is not ready, then what's the point in wasting time? ಯಾವತ್ತು?
2 weeks. Any day.
ಎಲ್ಲ ಇಂಪಾಸಿಬಲ್. ಯಾವತ್ತು? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಆಗ್ಬೋದು.
ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2
3
6 time. The last chance list on.
I'm sorry, but I'm held up in another court.
But you should ask somebody to be here. Central, you appear for the central government.
Please, my lord, I will.
In fact, one case I said that you are not appeared. I called it twice. Parlele Arun.
Sorry, my lord, I was held up in another court.
Central government ಎಲ್ಲ ಮಾಡ್ಬೇಡಿ.
Please, lord, in this matter, central government is only formal party. What's
Security.
Please. In this matter, my lord.
Central government appear ಆದಾಗ ನೀವು ಇರಬೇಕು.
Please.
ಇಲ್ಲ ಅಂದ್ರೆ unnecessary.
ಎಷ್ಟು? Serial number 50.
Vijay Simha Reddy. Ready?
I appear for the petitioner.
ಯಾರು ಅದರ್ ಸೈಡ್ ಆನಂದ್ KR.
My lord, I appear for respondent.
Omshekhar. Yes.
I
I
appear
appear for respondent number 3, my lords, in this matter, the complainant.
Yes, Mr. What is this case about?
My lord, the petition is challenging the order passed by the internal complaints committee at Annexure A, my lord.
Aneksha?
Annexure A at page number 15. Subsequently, I have been terminated by the respondent, my lord, the
Yes.
PS college. That is at Annexure A1, my lord, 27. My lord, in 2003,
But
I-
how is a writ petition maintainable against this?
my lord,
How is a writ petition maintainable against this?
I'm challenging the
That is,
validity of the constitution of the internal committee report, my lord.
It's okay, but
Committee
how can you
itself.
challenge it in a writ petition is what I'm asking you.
Please, my lord, I'm not challenging on merits, my lord. I'm challenging the validity of the committee, constitution of the committee itself. The internal complaints committee that has been formed under the POSH Act, that is Sexual Harassment of Women at Workplace Act. This committee, my lord, kindly see, my lord, I'll just point out a few facts, my lord. In 2003, I get appointed as a teacher, my lord. At the time of termination, which is at 2017, I am the head of the department of the automobile department at the university. The inquiry is conducted at the instigation of filing of a complaint by respondent number 3, who is an temporary employee, the temporary teacher that is appointed at the university in 2016. My lord, kindly see page number 34, my lord. The complaint given by the respondent number 3 to the principal. May I read, my lord? So I am Priyanka C, lecturer in mechanical department. It is found that my notice that BL Dayananda Sagar, that is the petitioner, HOD of automobile department, has downloaded my personal photos from unknown source. He is being discussed about that photo and my personal matters with my colleagues. I am deeply hurt by this incident. I request you to inquire him about the matter. I need to know the source of the photo. I hope accidents like this will not happen again.
Accidents, incident.
Sorry, incidents. My apologies. Also, he has showed the photo to me and Somshekhar, lecturer of mechanical department, and he has discussed my marriage matter with us. This has become humiliation to me to work in the department. Please take suitable action. This is the complaint, my lord. The next page is the photo, the alleged photo that I have downloaded from unknown source. 36, my lord. This is a photo posted by the complainant's friend, who is part of the committee, the internal complaints committee. This photo has been uploaded by the complainant's R3's friend on WhatsApp, my lord, which is a public portal. This is public information. I have not downloaded any personal matter that pertains to R3. That is point number 1, my lord. After this,
Where's your reply?
my lord, yes. Page number 37, Annexure E, is the notice that I get sent, my lord, from the university, saying this is the complaint that I've received. No, they just mentioned there is a complaint received from R3, and that I have to appear before the internal complaints committee, that is the ICC, on this and this date. That is, my lord, 8/9/2019 at 4 p.m. They don't ask what is my reply, nothing, my lord. As per the rules, procedure rules, my lord, I have to be given a copy of the documents and the complaint and ask for a reply to it, and provide me 7 days for time, my lord, to provide that reply. I have not been given that opportunity at all. They only asked me to appear before the internal complaints committee on this date. There, my lord, on the left-hand side of the same Annexure E, my lord, that it shows the constitution of the complaints committee.
That is the presiding officer, that is Tejaswini A. Edward, member secretary Devraju HN, members, students and social workers, so on. Totally 9 committee members. Most of them, including the presiding officer, are friends and confidants of the respondent number 3 complainant. My lord, may kindly request your lordship to see section 4 of the POSH Act, my lords. Formal part. My lord,
May
section
May I submit, my lord, if I'm not mistaken? Sorry for the interference.
Yes, please go on.
ಏನಾಯ್ತು, ಆನ್ ಮೈ ವೇ ಫೈಲ್ ನಮ್ಮ ಕಲೀಗು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ನಾನು ದಾರಿ ಬರೋಷ್ಟರೊಳಗೆ ಲೇಟ್ ಆಯ್ತು ಅಂತ ಐ ಜಸ್ಟ್ ಬಾರ್ಜ್ ಇನ್ ಟು ಮೈ ಫ್ರೆಂಡ್ಸ್ ಆಫೀಸ್ ಅಂಡ್ ಮೇಕಿಂಗ್ ಮೈ ಸಬ್ಮಿಷನ್ ನೌ. ವಿತ್ ಡ್ಯೂ ರೆಸ್ಪೆಕ್ಟ್ಸ್, ಅಡ್ವೊಕೇಟ್ ಆಫೀಸಲ್ಲಿ ಕೂತ್ಕೊಂಡು ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಫೈಲು ಅಲ್ಲಿದೆ, ದಯಮಾಡಿ ನಾಳೆನೋ ನಾಡಿದ್ದು ಹಾಕೊಂಡ್ರೆ ಐ ವಿಲ್ ಅಪಿಯರ್ ಮೇಲೆ ಅಂಡ್ ಮೇಕ್ ಮೈ ಸಬ್ಮಿಷನ್.
Whom do you represent?
ಅದು the writ petition may not be maintainable because there is an appeal provision before the Education Appellate Tribunal, no?
Yes.
So that objection I have raised in my objection statement.
No, but whom do you represent?
I represent the education institution, madam. PES education institution.
Yes, please read.
Please.
Before that, my lord, may I make a submission on their maintainability, my lord? Section 8, appeal provision, my lord. Any person aggrieved from the recommendations made under section 2, subsection 2 of section 13 or subsection 1, clause 1 or clause 2 of subsection 3 of section 13 or subsection 1 or subsection 2 of section 14 or section 17 or non-implementation of such recommendation may prefer an appeal to the court or tribunal in accordance with the provisions of the service rules applicable to the said person. Well, this is the appeal provision that they say it would be applicable in this matter. My lord, this appeal provision is with a limited scope of on merits, my lord. If it's get dismissed or if it's allowed or convicted.
No, you've been dismissed.
No, I'm on the constitution, invalidity of
Anyway, you have
constitution
been
of the committee.
Terminated from the employment.
I'm terminated, my lord. I'm saying that the committee, the ICC committee that's formed, my lord, that is with vested interest of the outcome of the case.
Can
Even
that
the
not be
presiding
gone into by
officer
the
are
tribunal?
friends. Please, my lord.
Can that be not gone into by the tribunal?
Sorry, my lord, I didn't quite understand.
Can that be not gone into by the tribunal?
My lord, like I said, my lord, the appeal provision is only on merits, my lord. I'm saying.
What do you
the
mean by merits?
merits of the case on the
Now you
findings
have
and
been
the.
terminated.
Please,
Now
my
you have been terminated.
I've been terminated, my lord. I'm
So
saying that has
therefore-
been wrongly terminated based on a speculation and all these things committed by R3 and her friends and.
ಆಯ್ತಪ್ಪ,
the
ಈಗ
cooperative.
you have to file an appeal before the Education Appellate Tribunal on
Yes.
merits,
Yes, ma'am.
correct? You have to challenge the termination there.
Yes.
On what ground?
Whether the
On what ground
termination
will
is
you challenge?
reasonable or not.
On what ground will you challenge the termination?
Saying the findings is wrong because.
On what? Again, you have to go back and say that ICC was not properly constituted, that there was people who are known to the complainant.
I'd raised that,
So
query,
all
my
those
lord.
things can be gone into by the tribunal.
My lord, my submission is, my
The
lord,
rules
I've
frame
already-
ಮಾಡಿದಲ್ಲ, government has issued, a central government has issued a notification.
Please.
Please go through the rules.
I've already made an appeal to the university, my lord, stating all these things, that the committee is not properly formed and there are people with vested interest forming, being the members of the committee, my lord. That also has been rejected. Please, my lord, if I may kindly read out, my lord, section 7. which provides for the composition of the internal committee, complaints committee. It says the local committee, which consists of the following members to be nominated by the district officer, namely a chairperson to be nominated. My lord, 1 minute, one moment. Sorry, section 4, my lord. Section 4. Every employer of a workplace shall by an order in writing constitute a committee to be known as the internal complaints committee, provided that where the offices or administrative units of the workplace are located at different places or division or subdivisional level, the internal committee shall be constituted at all administrative units or offices. The internal committee shall consist of the following members to be nominated by the employer, namely a presiding officer who shall be a woman employed at a senior level at workplace from amongst the employees, provided that in such a level, in case a senior level woman employee is not available, the presiding officer shall nominate from other offices or administrative units of the workplace referred to in subsection 1. My lord, I am saying the presiding officer, that is Tejaswini Edward, is the head of department of another department, which is the mechanical department, and is junior to me, even at the time of the inquiry, my lord, who has a vested interest directly. If I am out of the way, she will be next in line to become the principal. I was senior to her. This is a chance she took personally, and that she terminated, my lord. I'm not even going on the merits, but this is directly a vested interest that is carried by the presiding officer.
There is only one, there are other 2 members.
Yes, my lord. All of them subsequently after the termination, my lord, the R3 filed a police complaint against me. 524 and 509 has been, FIR has been done against me. In that, my lord, all of them, I'll provide the details, my lord, the document. All of them have given witness statements that before even I made the 2016 complaint, that they have known about the incident and the allegations, and they personally have witnessed the incident happening, which is not true. That plays against the rules, my lord.
Yes.
How can they give, like, my lord, my question is, how can they give like personal statements that they personally knew the complainant and the petitioner involved in this incident before the police, my lord?
Yes.
May I kindly pass over the documents, my lord?
First of all, you get out regarding maintainability of the writ petition.
My lord,
How is the writ petition maintainable? How is the writ petition maintainable?
yes, my lord. The, like I submitted earlier, my lord, the appeal provision is for limited scope of section 13, section 14, and section 17, my lord.
Please
Section
go through the
13,
law, there's something called public law.
please, my lord.
Welcome. If it deals with a public law element, writ petition is maintainable at the judgments ಇದೆ. ನೋಡ್ಕೊಂಬನ್ನಿ.
Please, my lord. A date may be fixed, my lord, kindly.
When will you get ready?
Anytime this week, my lord. Day
Next
after
week?
tomorrow, my lord.
Next Monday.
Monday, please, my
Come
lord.
ready?
Please, my lord.
Grand counsel for the petition seeks time. List on. 24th April, 24th March.
24th March. Oblige, my lord.
ಕೊಡಿ ಯಾವ್ದು ಆಗೋಯ್ತು ಎಲ್ಲಾನು ಫೈನಲ್ ಇಯರಿಂಗು ವಿಜಯ್ ಸಿಂಹ ರೆಡ್ಡಿ ಆಯ್ತಲ್ಲ 51 ನಾಗೇಂದ್ರ ನಾಯಕ್ ಜೆ.ಎಂ. ಅನಿಲ್ ಕುಮಾರ್
Serial number 1, J. Anil Kumar. Mood matters.
ಜೆ.ಎಂ. ಅನಿಲ್ ಕುಮಾರ್ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಟಿಲ್ಲ. There is no representation for the petitioner. ಬರ್ಕೊಳ್ಳಿ, ಇದು office objections are not complied. Subject to compliance of office objections, AG is directed to accept notice for respondent number 1 and 2. State Commission ನೀವೇ ಇದ್ದೀರಾ? State Consumer Forum. ತಗೋತಿರಲ್ಲ 1 and 2. Full stop. If the petitioners have not availed the benefit of a second term as members of the there is no representation for the petitioner. List on date. Fayaz Saab,
Serial number 2, Fayaz Saab BG. Kindly take that, the writ petition number 7747, Lord, first. 7747. Lord, in this case, Lord, pursuant to the order dated Annexure M, Lord, 3/3/2020, these petitioners have been appointed as a members of the District Consumer Forum, Lord. And Annexure, Lord, see page 37, Lord. In terms of section rule 10 sub-rule 2 of that Consumer Protection Rules 2020, Lord, the provision is made page 37, Lord.
yes.
So the persons who have completed first term, they are eligible and entitled for to continuation for second term. But considering this, Lord, this code in identical annexure N page 101, Lord.
Not come, second term ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
Literally, Lord, kindly see this page 6, para 6, Lord. Para 6 of my writ petition, Lord. Para 6 of my writ petition, 6th line from the bottom, Lord. 6th line from the bottom. And also in the para 13 of that grounds also.
ಓದಿ 6 ಅಲ್ಲಿ ಓದಿ.
Lord, kindly said 6th line from the bottom, Lord. It is relevant to mention that the petitioners herein are just completed the employ their first term of office as members of the Consumer Dispute Resolution Commission, and they have not completed the second term of office.
Accept notice for response 1 to 3.
In identical case, Lord, this annexure N, Lord.
Since it is stated by the petitioners that none of them have completed the second term in office as members of the Consumer Disputes Redressal Forum, and in view of the order,
Annexure N 101,
in view of the notification dated 15/9/2022, the petitioners are entitled for reappointment for another term of 4 years. In that view of the matter, interim order
to continue the
as sought for is granted till the next date of hearing. This on date.
Seeking for handover of the interim order.
3rd April.
Yes.
Serial number 3, Sadanand
Sadanand G. Shastri.
I'm seeking for hand delivery of the.
To appear for the petitioner, my lord, seeking a mandamus, my lord, against the respondent Energy Department to consider my representation at Annexure A. The urgency is this, my lord, for the last 11 months, 9 months, I have not been paid my salary. I have not been relieved from my previous workplace, that is at Ballari, and I've been working at Kalburgi. Now, my lord, two cases came to be filed against me, my lord.
AG is directed to accept notice for response 1 to 3. Full stop is directed to secure instructions regarding relieving of the petitioner. You have been transferred to which place?
Now, presently, I'm at Kalburgi, my lord. However, I should be relieved from Ballari, my lord.
Yes, list on yavat.
Date may be
List on
fixed,
date.
Lord.
Yes.
Lord, I've sought for an interim prayer, Lord, the
Again interim prayer.
urgency 50% salary are 9 months in the.
Next.
25th March. For preliminary serial number 4, payouts of.
This petitioner has firstly she worked as an honorary versa of this annexure EM lot, 2015 lot. After coming to force that new act, that is the Consumer Protection Act 2019 lot. So annexure, not kindly see, first she has worked as a honorary member, annexure EM lot, and 12/3/2015 lot, and consolidated salary of 12,000 or 600 rupees per sitting lot. Then lot again, by virtue of this new amendment act 2019 lot, again she was appointed on 4/3/2024 annexure B lot. As per that lot, that it is taken into consideration that has to be treated as a first term lot. First, earlier she was worked as a honorary, approves the document annexure E and B lot.
Honorary ಅಂದ್ರೆ ಏನು? Rules ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
ಅವಾಗ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, because for 2019 ನಲ್ಲಿ ಹೊಸ ಆಕ್ಟ್ ಬಂದಿತ್ತು, there after the 2022
Who are
ನಲ್ಲಿ
you appointed? You are appointed under the Consumer Protection Act which was in force then.
first she was appointed on basis of that honorarium or 600 rupees per sitting. Then for that, after coming to force of this new act, again she was appointed on 3/3/2020 lot. In my writ petition lot, I stated that in first param lot.
That we have to consider then.
Shall I read more that first param lot?
ಒಂದ್ಸತಿ ಆಗ್ಲೇ ಇದಿರಲ್ಲ, ನೀವು ಒಬ್ರನ್ನ ಇರೋದು, ಬೇರೆ ಯಾರಿಗೂ ಅವಕಾಶ ಬಡವಾ?
ಇಲ್ಲ ಈಗ ಅದು ಇದಿದೆಯಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿವರೆಗೂ ಅದು ಅಟ್ಲೀಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮೆಂಬರ್ ಅಪಾಯಿಂಟ್ ಆಗೋರ್ಗಾದ್ರು.
ನೀವು ಆರಾಮ್ ಮನೇಲಿ ಎಷ್ಟು ಮುಂತ ಮಾಡ್ತೀರಾ ಆ ಕೆಲಸನ? ಬೇರೆಯವ್ರಿಗೆ ಅವಕಾಶ ಕೊಡಿ.
ಟಿಲ್
ವರ್ಕಿಂಗ್ ಫಾರ್ ದ ಲಾಸ್ಟ್ 10 years, ಮಿಸ್ಟರ್.
ರೆಗ್ಯುಲರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗೋರ್ಗಾದ್ರು ಅವಕಾಶ ಕೊಡಿ.
No.
Regular appointment ಆಗೋರ್ಗು till then brought. Earlier
Even
that
undertaking-
our appointment
No,
was
you
based
given-
on this honorarium.
You give an undertaking that soon after there is a regular appointment, you will vacate.
ಆಯ್ತು ಸ್ವಾಮಿ.
ಕೊಡಿ. File an affidavit.
Sir, tomorrow itself, kindly have done tomorrow.
Also
brought
for the
file now.
petitioner seeks time, list to more.
Much obliged.
Office objection comply ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ, ಇಲ್ಲಾಂದ್ರೆ hand
ಅದ್ರಲ್ಲಿ ದಕ್ಷಿಣ ಕನ್ನಡ, ಉತ್ತರ ಕನ್ನಡ ಅಂತ ಇದೆ, ಅದನ್ನ ಅವರು ಇದಕ್ಕೆ ಧಾರವಾಡ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದಾರೆ. ಅದೊಂದೇ ಸ್ವಾಮಿ, ರೆಸ್ಟ್ ಆಫ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ಕಂಪ್ಲೀಟ್ ದಟ್ ನೋಡಿ, ಕೈಂಡ್ಲಿ ಸಿ. ಅದು ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ದಕ್ಷಿಣ ಕನ್ನಡ, ಉತ್ತರ ಕನ್ನಡ, ಇದು ಮಂಗಳೂರು ಎಲ್ಲ ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ. ದಟ್ ಈಸ್ ಓನ್ಲಿ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಅದರ್ ಆಲ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ಕಂಪ್ಲೀಟ್ ನೋಡಿ.
P3 ಎಲ್ಲಿರೋದು? Petition number 3 is
ಕಾರವಾರ ಬ್ಲಾಡ್, ಉತ್ತರ ಕನ್ನಡ ಅಂತ ಬರುತ್ತೆ.
ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ?
ಇಲ್ಲಿಗೆ ಬರುತ್ತೆ ಸ್ವಾಮಿ, ಅದು ಉತ್ತರ ಕನ್ನಡ, ದಕ್ಷಿಣ ಕನ್ನಡ ಮತ್ತೆ ಇದು
ಧಾರವಾಡ ಬರುತ್ತ್ರಿ ಇದು.
So that is only the objection, bro. So other objections are complete.
Office objections are kept open. Yes.
Serial number 5, Adi Narayanappa.
Petitioner challenges the annexure A.
Petitioner
Challenges the annexure A notice issued by the third respondent.
notice issued by the third respondent.
Third respondent.
As National and Rural Education Association.
ಹೌದು.
How can you challenge it in a writ petition?
The earlier, I am the senior most teacher in the third respondent institution. After retirement of the one Ramakrishna Day superannuation, I have claimed the vice principal post.
Already writ petition ಹೆಂಗ್ ಬರುತ್ತೆ private society ಮೇಲೆ?
Aided
ಆಗ್ಲಿ.
aided institution.
How is the writ petition maintained?
This honorable court earlier, there is a specifically directed the third respondent institution. May kindly see that it was filed the writ petition in the earlier occasion, where this honorable court is directed the third respondent institution, may annexure D at the ink page 27.
What was the relief sought for?
Promotion of appointing him as a vice principal in the third respondent institution. This honorable court is specifically directed the third respondent institution at the relevant page at 25. Sorry. The sixth respondent is directed to fill up the post principal or vice principal, master or headmistress to the institution run by the sixth respondent, Acharya
Correct, Appa, but
Pre-university
how
contract.
can you challenge, how can you challenge it in a writ petition is what I'm asking you. How can you challenge in a writ petition?
Since they have violated the court directions issued by the.
ಅದಕ್ಕೋಸ್ಕರ ಒಂದು ಆಕ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಅಥಾರಿಟಿ ಅಂತ ಇರ್ತಾರೆ. ಸೆಕ್ಷನ್ 131 ನೀವು ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು, ಇಲ್ಲಿ ಯಾಕೆ ಬರ್ತೀರಾ? To go before the concerned principal secretary.
Earlier, two writ petitions, specific direction is issued by this honorable court. Without complying the direction issued by the
Sorry.
court, they have directed me to terminate the post and directed me to hand over the keys in respect of since I am having only
Sir, but you
2 months
challenge
of
it.
service at this stage, they have made me to terminate the post, which is against the direction of this honorable court.
ಯೋಚನೆ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ, 131 ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. Learn counsel for the petitioner seeks time list on date.
May kindly have it on day after tomorrow.
24th March. Serial number 51, Nagendra Naik R.
13, my lord. Once are been submitted before lordship favor. So, Commissioner.
I was appointed as a commissioner in this matter, Lord. I have submitted the report, Lord, because I visited the Canara Bank, Lord, the head office, and there, Lord, they showed me many files. But in respect of the petitioners, Lord, there was no file at all, nor even the original file or the Xerox file, as they kept, they say that, Lord, they have never kept the original files with them. They prepare one Xerox file, and that will be kept in the file, the records, and that is also not available in the records. That is what I have filed the report before the lordship.
My lord might recall, this is the case where the provisional appointment was granted, the final posting order was never granted. There was also no cancellation order which was placed on record. When it comes before this court, my lord, the contention of the petitioners comes to be their original documents, including, my lord, various school records, etc., kept by the bank. The bank, my lord, in the previous roster had asked the learned counsel, my lord, to clarify whether original records are kept with them and whether any cancellation order was passed. In 2021, my lord, in the order sheet it's recorded that certain time was sought to place the cancellation order on record. Similarly, that was ordered again in 2024.
Madam, I don't remember the facts. You have to,
Please, my lord.
someone will have to appraise me the facts.
My lord, this is a matter in 2015, my lord. There are 19 petitioners here. In 2015, my lord, they all come to be summoned for interview for the post of housekeeper, cum peon, in Canara Bank. Thereafter, my lord, provisional appointment order comes to be issued to all of the workers. No cancellation order is passed. They go for interview, they hand over their original documents, and nothing happens further. My lord, they raise a number of representations are given by them, and thereafter, my lord, they go to the National Commission of Safai Karamcharis. In 2018, for the first time, before the Safai Karamchari Commission, the management comes forth and files its objection saying that there's a 2015 Allahabad High Court order which says that opportunity has to be granted, my lord, to all persons, and hence we have taken the decision not to go ahead with this. The 19 petitioners thereafter filed this petition in the year 2018 after those objections are filed, my lord, and they seek for final posting orders be issued to them. Their two contentions, my lord, are that cancellation order has not been, a decision has not been taken to cancel the process, and the reasons have to be tested, my lord, at the time of cancellation. It cannot be justified 3 years subsequently by some extraneous reasons, my lord. In that context, my lord, this court had asked, my lord, the bank whether any cancellation order is passed.
Yes.
And cancellation order has still not been placed on record. An affidavit came to be filed by the bank saying that we don't have the original documents. And that was clarified by the bank also, it's recorded in the order sheet. So my lordship had directed for court commissioner to check the original records, to check whether my names and our original documents are in the file at all.
Yes, what will you do?
My lord,
My lord,
It's
the
a
truth-
serious case. I think we'll have to direct an investigation through the Corps of Detectives.
My lord, my lord, in this case, my lord, there are two issues. One is provisional order was issued and then appointment were not issued because of the Allahabad High Court. That is one. Number two, they say that you have original documents have been taken by the bank. These are all the two issues only in this matter. Regarding first issue, my lord, 2014-15, the bank all over India, they wanted to recruit all these part-time employees because they have stopped the empanelment of the part-time employees, PTs. Then they issued the orders and all the circles, they started conducting interview. One of the condition is that people should be sponsored by employment exchange. And all the people sponsored employment exchange interview was conducted. All these banks, all these circles all over India, they started conducting the interview, but with Bangalore rural circle, one circle, they started immediately conducting the interview and completed the interview. And they issued the provisional order stating that provisional order is that you have been selected. You produce the original documents for verification. After verification, then normally they have to issue the appointment order. Before that, my lord, some of the daily wages approached the Allahabad High Court of Canara Bank. They say that whatever the bank is doing is not correct. This is against the public recruitment policy because only the person, bank is including the only person who has been sponsored by employment exchange. All those daily wages who are put in service, they should be called for interview. Then the bank challenged that order and writ petition, it was decided against the bank. Then the bank filed a writ appeal. Writ appeal also that decided against the bank. The writ appeal also upheld the order stating that quoting to so many Supreme Court judgment that what bank is doing is not correct. Opportunity should be given to all these daily wages who are working, and then only then they have to select. And they're choosing only employment sponsored candidates is against the law. Then afterwards, my lord, this 2015, immediately that after this writ petition, then the bank and the majority union, they discussed this matter because there is no empanelment, what we should do. Then they entered a settlement in 2015. As per a settlement, they have formulated a scheme. What is the scheme? For recruitment of part-time employees, number one, he should be sponsored by employment exchange. Number two, in that local area, as directed by the Honorable Allahabad High Court, advertisement has been made in the newspapers. And those were all persons who are eligible, age, education conditions, and all these people can participate in the interview. This is the settlement entered into between the bank and the union. Now here, at that time, my lord, because of the decision, then the Bangalore circle, the head office said that informed Bangalore circle, then they don't proceed with the further proceeding. Now, that is why my only provisional order was issued, and then the appointment order was not issued because of these developments. And my lord, then my lord, that this original certificates. Normally, my lord, that they issue first one, they will submit all the copies of the documents along with the application. And after person who has been provisional selected, he will be sending documents. These people verify the original documents along with the attested document which have already been submitted, and then return.
So where are the attested documents?
Attested documents is there, bank.
Where are the attested?
That documents, it should be available in the bank, my lord.
So the commissioner says nothing is there.
No, my lord, now that because of this, bank has filed an affidavit. Bank has filed the affidavit before the court, stating that what is the procedure followed, and there is no question of retention of the original documents at all. And why the bank should retain original documents? Photostat copies, on the basis of that photostat copy, they will find out whether it is eligible or not. Then it is only for showing. And like this, my lord, if it is done, because in all the cases it has been done, that our investigation commission is verified many files.
So have you issued provisional appointment orders?
Professional order was issued.
Provisional appointment orders are issued.
Issued stating that you bring the original documents to issue final order.
Illegal.
They have produced document A.
That, my lord. That B at 22, my lord.
Annexure A to the writ petition.
Annexure B is the provisional appointment, my lord, at page 22.
Annexure,
I asked for something, you're telling me something else.
Annexure A to
It's the provisional appointment order.
Annexure A.
Annexure A, no?
B, my lord, at 22.
Annexure
B at 22.
B.
B.
Ah.
Your name has been sponsored by District Employment Exchange, Bangalore District. In this regard, we had conducted the interview. And you are provisionally selected for the post of posting. Hence, your retirement fixed. So these are all the documents A to H, already submitted for photostat copy. Verification, they brought the original documents. They verify the original documents, they return the documents.
My lord may turn to the next page, my lord. That's the representation immediately issued by all the petitioners, my lord. Para 3 and 4 may be seen, my lord, para 4 especially. On production of the required original certificates on that day, HRM section collected all the original documents, and instead I was issued with the above referred letter asking me to report on so-and-so. There's no reply to this representation. 3 years later, they come and say we are not going ahead with the process.
Yes, you produce the attested copies at least. Produce the attested copies.
No.
Self-attested
I'll-
copies, so produce more.
But my lord, that the commissioner,
Whatever it is, otherwise we'll direct a COD investigation. ಯಾರಿದ್ದಾರೋ ಎಲ್ಲ ಹೊರಗೆ ಬರ್ಲಿ. So what should happen to these people?
my lord,
ನೀವು ಹಿಡ್ಕೊಂಡು ಅವ್ರ ಕೆಲ್ಸಕ್ಕೂ
my lord, this is the first time that bank has come across this, the complaint said that we are not issued original documents.
No, it's
There is
always-
no,
Either you produce the self-attested copies of the documents which you have retained after verifying the originals. Or will direct an investigation maybe to CBI or to COD or any other agency. Whoever is responsible will be in for trouble. Barcode perused the report of the commissioner. ಅವ್ರಿಗೆ ಕೆಲ್ಸಕ್ಕೂ ತಗೊಳಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ವಾಪಸ್ ಕೊಡಲ್ಲ, ಅವ್ರು ಎಲ್ಲೋ
ಅಲ್ಲಿ ಕೆಲಸ ಕೊಡ್ಲಿಕ್ಕೆ ಎಲ್ಲ ರೆಡಿ ಮಾಡಿದ್ದವಲ್ಲ, because of the high court order, we could not, bank could not do, my lord.
Where should they go, sir? Be alive to the situation.
Allah, because of that only, otherwise, my lord, what bank wanted to select all these people.
Peruse the report of the commissioner. It appears that the commissioner had visited the office of the respondent bank at Spencer Towers, MG Road. Full stop. During inspection of the sample files given by the concerned official, he found that only photocopies of the testimonials were secured. Full stop. He also, the concerned official, the senior manager who was present at the time of inspection, informed the commissioner that the file relating to the present petitioners are not available and that the same has to be located from the record room godown situated Lotte, Gollahalli or Hebbal. And the senior manager sought time of 10 days for locating the files. Full stop. Even after he said 10 days has expired, the respondent has not produced the files relating to the petitioner. It's a last chance, 1 week time is granted to the respondents to place the files relating to the petitioner, failing which, this court will be constrained to get the same investigated through a premier agency.
1 week, 15 days, 15 days.
Sir, ಎಷ್ಟು ದಿನ ಆಗಿದೆ ಕೋರ್ಟ್ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ.
Where they have emailed me, not saying that the records relating to the petitions are not at all available. And on the basis of that, I have go further and investigate
ಬರ್ಲಿ ಅವ್ರು ನೋಡು ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡು. ನಿಮ್ ಫೀಸ್ ಏನೋ ಕೊಟ್ರ? ಕೊಟ್ಟಿದ್ದಾರೆ.
B group matter, serial number 52, K.R. Prasadyevar.
ಡೇಟ್ ಕೊಡಿ ಅದು ಯಾವತ್ತು? ಮಿಸ್ಟರ್ ಮುತ್ತಣ್ಣ, 24th. 24th. Yes. Mr. Prasadyevar, are you ready?
For the first respondent.
Respondent, my lord, respondent number 1 is a government company. came into existence in the 1964, and C and R rules came in the year 1966, Annexure A. Next, he contends that he has amended service rules in the year 1982. And there's Annexure B. Next, in the Annexure B, he has given manpower requirement and mode of filling, everything. That is page number 125. 124, please turn on. Page number 124. The last one, personal assistant. Is direct recruitment or here written here, direct recruitment. The required qualification.
One 124 ಅಲ್ಲಿ ಇಲ್ಲಪ್ಪ ಇದು 124 ಇಲ್ಲಿದೆ. ಸೇಲ್ ಸೂಪರ್ವೈಸರ್ ಅಂತ ಇದೆ. Page 124.
Sir, annexure B1. B1.
Page.
Next. Serial number 22. In that serial number 20 page in that annexure B1. Last.
Personal assistant.
Personal.
123.
120. I mistaken. Sorry.
Direct recruitment.
Or there is direct recruitment, graduate, senior shorthand, senior typing. This is the graduate with the 3 years experience in the handicrafts.
He should be a graduate with senior shorthand and senior typing
Yeah.
experience.
Yeah. And he should have minimum 3 years experience.
Yes.
This is the criteria. Based on this, I have filed this writ petition.
ನಿಮ್ಗೆ 58 ವರ್ಷ ಆಗೋಗಿದೆಯಲ್ರಿ.
Yes.
You're already 58 years. Petition is filed in 2014. Does it survive?
No, already 2 times he has approached. At that time, there was no right to information act. So he, though this honorable court has directed, considered representation, they have given negative replies.
2014 ಅಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿರೋದು.
ಅದಕ್ಕಿಂತ ಮೊದಲು ಹಾಕಿದ್ವಿ 2 ಸಲ.
ಆಯ್ತು, ಮೊದಲೇ ಹಾಕಿ ಸಂತೋಷ. ಪರಮೇಶ್ವರಯ್ಯಂಗೆ 58 ವರ್ಷ 2014 ಇಸ್ವಿನಲ್ಲಿ. So now he's attained the age of superannuation.
Yeah.
What is the big fun in keeping this writ petition alive?
No, I tried several times. They were telling it is senior, final year, you have to
What
wait
is
till it comes under
ಆಯ್ತು, what is
seniority. I have to wait, sir.
what is challenged here? ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
His appointment, he was not considered as a personal assistant. Personal assistant ಯಾಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅಂತ ತಿಳ್ಕೊಂಡು ಫೈಲ್ ಮಾಡಿದ್ರು ಸರ್. Just let me express something. So there were earlier 2 stenographers in the head office. Head office is in Bangalore, not in Delhi. And there were 2 stenographers. The management thought of observing those 2 stenographers as a assist personal assistant for one for managing director, another for general managers. So there are 2 candidates who were just senior to him. They were observed as a personal assistant with higher pay scales. Next, to fill up that 2 stenographer post, again they called for the applicant, fresh applications. Is my petitioner, present petitioner, and another lady. Both were selected by submitting their academic records. In due course of time, those 2 personal assistants who were promoted, they were promoted as assistant managers. Again, to fill up that personal assistant post, again this management thought of interviewing in internal candidates. So they called 4 persons per interview. Your Honor, please, page number 168. Once again, J1. Here, including this petitioner, these were 4 persons. They were interviewed and they selected one person, Mr. Fayez Nazrat. He is from Delhi. He attended the interview, but he was promoted, but he never reported for that personal report at Bangalore. He lost promotional avenues. Okay. Next one, Mr. S.S. Hussain. He is just SLC. He was selected for the personal assistant post, violating that personal assistant qualification as per C&R rules. It is illegal. They kept this appointment are very secretly without disclosing. He was not, petitioner was not knowing what is going on. But they were extracting work from this man. He was a personal assistant. In anticipation that he will get the order, he was working. When he registered, when years passed on, they started him, they placed him under the seniority list as a assistant. Page number, please. 228. 228, he is assistant, sales assistant.
ನಾನು ಕೇಳಿದ್ದೇನು ನೀವು ಹೇಳ್ತಿರೋದು ನಿಮ್ಮ ಕ್ಲೈಂಟಿಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದಾಗ 58 ವರ್ಷ 2014 ಇಸ್ವಿನಲ್ಲಿ
ಹಾ.
ಇವತ್ತು 2025 ಇದ್ದೀವಿ.
Yes, sir.
ಅಂದ್ರೆ ನಿಮ್ಮ ಕ್ಲೈಂಟಿಗೆ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಆಗೋಗಿದೆ.
ಹಾ, ಆಗಿದೆ.
What is the relief that can be granted to him is what I am asking you.
That is, I have faced the interview. I was not given the appointment order. So I may be considered that a personal assistant court to give me all the money benefits. That is,
Yes. Was it a selection post? Direct recruitment ತಾನೆ?
that is the interview, internal recruitment, by interview, internal candidates they are selected.
Yes. If it is by way of direct recruitment, what is the qualification prescribed? 3 years.
3 years experience.
3 years experience. Plus senior shorthand typing ಎಲ್ಲ ಇರಬೇಕು. ಕರೆಕ್ಟಾ? Even if you have that qualification, we can't appoint you because you already attained the age of superannuation.
Huh?
ನಿಮ್ದು ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಆಗೋಯ್ತು ಅಂತ.
No, prior to that, Your Honor, it was prior to that, not after retirement and hearing pay end of my service. Prior to that, 86 it was.
Yes.
So I got, they were hiding. When RTI came, we discovered. Now they are saying his post was a amalgamated assistant. Now after RTI got, we got, that committee was constituted for amalgamating post. This committee report they are given, nowhere is mentioned his stenographer post. And this, they are saying this committee has approved, signed by all members. Nobody has signed, except the executive alone has signed.
ನೀವೇ
This
ಹಿಡ್ಕೋತೀರಾ?
is bogus.
ನಮಗೂ ಕಾಪಿ ಕೊಡ್ತೀರಾ?
It is already enclosed.
ಹಾ.
It is page 175, 176. Under RTI report, they are cheating employees.
ನೀವು ಇದೇ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ರ ಮುಂಚೆ
Oh, sir.
ನೀವು ಇದೇ ಹ್ಯಾಂಡಿಕ್ರಾಫ್ಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಕಾರ್ಪೊರೇಷನ್ ಇದ್ರ ನೀವು ಮುಂಚೆ ಅಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರಾ?
So nobody has signed it. That means amalgamation order is bogus. Based on that bogus amalgamation order, whatever senior list they apply is all bogus. Even this honorable court under bill 450/91, 2019, they are directed to enforce to implement a roster since 1978. Till today they are not done.
Yes.
Under what roster point they have appointed these people? This is not clear. Even he has given drama by publication that I am going to prepare roster register. He has given paper publication. Page number 369, Your Honor. Volume number 2. 369, he has called for expert for preparing the roster since 1978.
$369.
Annex V3. And RTI Act report. So he has, till today, he has not completed that work. Even RTI next page, V5 next year. Even RTI commission also directed. So you implement 1978 that roster in the institution. They have not yet done. Simply they are promoting at their whims and fancies. For example, annex V5.
ನೀವು
They are expecting
2014 ಪ್ರಾಕ್ಟೀಸ್
promotions.
ಪ್ರಸಾದ್ ಅವರವ್ರೆ,
ಹಾ, ಹೇಳಿ ಸರ್.
ನೀವು 2014 ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ದೀರಾ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ?
I attended myself,
ಯು ಆರ್ ಮಿಸ್ಟರ್ ಪ್ರಸಾದ್ ಅವರು?
yes, myself,
ಹಾ. ಯಾವಾಗಿಂದ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ದೀರಿ?
after retirement,
ಯಾವಾಗ?
2011.
ಹಾ. ಬಟ್ ವೈ ಡೋಂಟ್ ಯು ಮೇಕ್ ಸಮ್ ಬುಲೆಟ್ ಪಾಯಿಂಟ್ಸ್? ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಬೇಕಲ್ವಾ?
Just now.
They're going everywhere.
No, this is what actually they are not follow these CNO rules properly. Next is they are telling we have Amalwadi sport. That is bogus.
Amalgamate.
Several employees are suffering like this only. I want to show, but this is all due to one person, handiwork. That is annexed P. Press has reported that fellow is taking bribe and promoting. That is whims and fancies.
ನೀವು ಅಲ್ಲಿ ಇದ್ದಾಗ ಹೇಳಿಲ್ವಾ ನೀವು?
ನಾನು ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದೆ ಸರ್, ಯಾರು ನಮ್ಮ ಕೇಳಿದ್ರೆ ಎಲ್ಲೋ ದೂರಿಗೆ ಹೋಗಿರ್ತಾರೆ, ಇದೇ ನೀರು ಸಿಗೋದೂರಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ನಮಗೆ.
ಅದಕ್ಕೆ ಹೆದರ್ಕೊಂಡ್ಬಿಟ್ರಾ?
ಹೆದರ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ.
ಅನೆಕ್ಷರ್ ಪಿನಾ?
Annexure P.
ಹ್ಮ್.
198 page number.
Yes. What is this?
The fellow was doing all this. Later on, he resigned.
ಯಾರಿದು?
One administrative manager.
Huh?
Administrative manager, ನಾಯಕ ಅಂತ.
ಹೆಸರು ಹೇಳ್ರಿ, ಇವಾಗಾದ್ರು ರಿಟೈರ್ ಆಗಿದೆಯಲ್ಲ ನಿಮ್ದು, ಹೆಸರು ಹೇಳಿ, ಧೈರ್ಯವಾಗಿ ಹೇಳಿ.
ಅಲ್ಲ, ಅವರು ಇದಾಯ್ತು ಸರ್, ಅವರು ನಾನೇ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಾಗ ಅದು ಗೌರ್ಮೆಂಟ್ ಇಂದ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಯ್ತು, ಅವ್ರ ಮೇಲೆ he resigned. It was proved that he has done some fraud.
ಸರಿ, ಏನ್ ಬೆನಿಫಿಟ್ ಕೊಡಕ್ಕಾಗತ್ತೆ ಇವಾಗ ಹೇಳಿ?
ಈಗ ನಾನು ಇಂಟರ್ವ್ಯೂ ಫೇಸ್ ಮಾಡಿದ್ದೀನಿ. ಮೊದಲೇ ಕ್ಯಾಂಡಿಡೇಟ್ ಡೆಲ್ಲಿ ಕ್ಯಾಂಡಿಡೇಟ್ ಅಟೆಂಡ್ ಮಾಡಿದ ಇಂಟರ್ವ್ಯೂ ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಹೆಡ್ ಆಫೀಸ್ ಬಂದು. ಸೊ ನೆಕ್ಸ್ಟ್ ಒನ್ ಮೋರ್ SLC ಕ್ಯಾಂಡಿಡೇಟ್. So when you are giving your condition for sales personal assistant, he must be compulsory graduate. He is not a graduate, he is a SLC candidate.
ಯಾವತ್ತು ಇಂಟರ್ವ್ಯೂ ಇದ್ದಿದ್ದು? What is the date of interview? ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರಮೋಷನ್?
ಪ್ರಮೋಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. He is favor those two fellows.
ಅಲ್ರಿ,
He is directly recruited as a stenographer.
He is directly recruited as a stenographer.
In the year stenographer appointed out of the stenographer, he was appointed as stenographer.
Which is the
As a stenographer. He was confirmed on 23/1/1985. 1 year probation ittu. Subsequently, it was confirmed.
What is the next?
In the year 1982, two persons were promoted to the post of assistant managers who were Rangaswamy and Ranganath. After the promotion of these two persons, the post of assistant manager got amalgamated with personal assistant. Sorry, personal assistant, they were promoted. They were redesignated as assistant managers due to amalgamation, which took place in the year 1986-87. Now, in the year 1986, Nazarat Pais and SS Hussain were promoted to the post of assistant managers.
Promoted amalgamate ಆಯ್ತಲ್ಲ?
ಅದೇ ಇವರಿಬ್ರು ಬಿಫೋರ್ ಇದು ಆಫ್ಟರ್ ಅಮಾಲ್ಗಮೇಷನ್ ಇವರಿಬ್ರದ್ದು ಪ್ರಮೋಷನ್ ಆಯ್ತು. Where he was also an interview candidate. He was placed at serial number 3. When these two persons were promoted around, now he has come before this court challenging the amalgamation of the post which took place in the year 1986-87. If you can come down to page number 32, my lord, for just one moment. If I can read the prayer, it gives a lot of clarity to what the intention of the petitioner is. Please take to the first prayer, my lord. To quash the arbitrary, illegal, erroneous, published final seniority list, published wide circular dated so and so, under RTI Act wide letter number so and so, enclosed original
annexure Q6 or modified if any published to quash amalgamation of certain posts who had order dated 6/7/33/86/87 issued original copy under RTA. Now he is trying to challenge some action that took place way back in the year 1986-87. He himself has challenged this particular issue before this court and suffered an order, my lord.
Yeah, this.
He himself
Rosario.
had, as an employee of the corporation, he had challenged this order. In the year 2007, I would just pass on this one, judgment. Sir. I request your lordship to page 6, my lord. He had contended that he should be promoted as manager and the amalgamation was illegal. The petitioner during fifth line from the top, my lord. The petitioner during this period from 1987 to 2007 earned certain promotions on different occasions and also revision of pay scale, and therefore at this length of time, it is not just and proper to quash the order of amalgamation at annexure K. This is what is now challenged in annexure B here, my lord. The court opines that further, in the event of allowing the prayer to quash an order of amalgamation at annexure K, the same will result in serious civil consequences to other employees of the respondent corporation. Therefore, the writ petition insofar as it relates to quashing of annexure K, the amalgamation order is liable to be dismissed. This has attained finality because he did not challenge it before the.
I have filed appeal, Your Honor. I have filed appeal against the.
Let him
writ
give,
petition. Okay.
let him give the status of
that's
that
I will
appeal at
accept
least,
it.
my lord.
This is the documents we are not aware of this document. When RTA came, we have got this document. Now we have challenged. That is bogus documents. Social Welfare Department is asking every now and then sending implement roster 1978. Till date, they are not implementing. Honorable dealing they are doing and promoting as at their whims and fancies.
So, my lord, in the seniority list, the petitioner has been placed in just next to one Zarina Begum, my lord, on basis of the date of joining, my lord. If your lordship were to come to page number 260, where the seniority list of the concerned cadre is there.
260.
260, yes, my lord. There, stenographer. There, stenographer, Zarina Begum, she is placed on the top of the list. Second is Parameshwaraya, my lord. Now, he says that the seniority list is erroneous and it is illegal. But he has not explained any part of his writ petition as to how it is illegal, my lord.
See here, after submission,
Please
allow
allow
me to
me
conclude.
to.
He's arguing to the court, submitting to the court.
So, once there is no ground made out, my lord, by him as to how this particular placing of Parameshwaraya at the second stage next to Zarina Begum based on the date of joining is erroneous, then this particular prayer would not survive for consideration at all, my lord. There is not a single ground made out in the entire writ petition. Before that, my lord, this particular seniority list was submitted, circulated among all the employees, and objections were called around. He has not chosen to file any objection at that particular point, relevant point of time. After having done that, after having accepted it in the office level, once the seniority list has been published, he says that it is erroneous, but he does not explain his writ petition as to how it is erroneous. The only thing he says is that somebody is taking money and promoting others, but he by himself is not eligible for promotion. That he has also suffered an order from this court, the present petitioner, which he has placed it in page number 300. 352, my lord, wherein in 2005, the petitioner came before this court and sought an order from this court to promote him to the post of personal assistant. This court went through the entire issue and finally, at page number 361, my lord,
Yes.
having regards to the above rival contentions, the assertion on the part of the petitioner that in terms of Annexure K, the petitioner was eligible to be promoted as personal assistant or assistant manager, and therefore Annexure R1 ought to be read with K, and the effect of Annexure K should not be negated by reference to Annexure R1 cannot be accepted. The respondent can only act in terms of rules existing at present, which is in terms of Annexure R1. The claim of petitioner that he be considered as eligible for promotion to the post of assistant manager, which is also designated, contemplated in R1, is not tenable. Petitioner is bound by cadre and recruitment rules as they exist in terms of Annexure R1. Hence, the petitioner's claim can only be considered for promotion as a supervisor and not as an assistant manager, notwithstanding the position as it stood in terms of Annexure K. Accordingly, writ petition is dismissed. The dismissal of this writ petition does not, however, take away the right of the petitioner for promotion to the next promotion post, namely as supervisor, if
Stenographer
otherwise
in the-
eligible.
Stenographer in the next post to supervisor, huh?
Before merger, it was personal assistant manager. Now it has been designated as supervisor,
Stenographer in the next promotional post is personal.
supervisor.
Before the amendment,
Before the amendment, it was personal assistant.
personal assistant.
Yes,
Amendment was in 1986, 87.
86,
And this personal assistant was amalgamated with assistant manager
assistant manager.
in
They were
86.
promoted,
86.
he is telling lie, he was assistant manager. Don't,
ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ನೀವು ನೋಡ್ಕೊ ಬಂದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು.
sir, ಅವರು ತಪ್ಪು ಹೇಳ್ತಾ ಇದ್ದೀರಾ
ತಪ್ಪ ನೀವು ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ರಿ.
ಸರ್,
ನೋಡಿ
H1 ಎಷ್ಟು I given, sir, H1 ಎಷ್ಟು I given.
ಪ್ರಸಾದ್
Please
ಅವರೇ
refer. H1 ಎಷ್ಟು?
ನಿಮಿಷ ತಾಳಿ. ರಾಮಾಯಣ ಹೇಳಿದ್ರೆ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ? ರಾಮಾಯಣ ಕತೆ ಹೇಳ್ಬೇಕು, ಹೆಂಗ್ ಹೇಳ್ತೀರಾ? ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ಸರ್?
ಅಲ್ಲ, ಕತೆ ಹೇಳ್ತೀವಿ
ಅಲ್ಲ,
sir,
ಹೇಗೆ?
brief ಆಗಿ.
ಅಲ್ಲ ಇದು
ಇಲ್ಲೇ.
ಬಿಟ್ಬಿಡಿ. ಈಗ 5 ಗಂಟೆ ಆಗೋಗಿದೆ, ಕೋರ್ಟ್ ಅವರ್ಸ್ ಮುಗಿದೋಯ್ತು. ಇದು ನೌ ದಿಸ್ ಇಸ್ ಮೈ ಟೈಮ್. ರಾಮಾಯಣ ಹೇಳ್ಬೇಕು ಒಂದ್ ಮಗುಗೆ, ಹೆಂಗ್ ಹೇಳ್ತೀರಾ? ಹೇಳ್ರಿ. ಹೆಂಗ್ ಹೇಳ್ತೀರಿ? ಒಂದ್ ಊರಲ್ಲಿ ಒಬ್ಬ ರಾಜ ಇದ್ದಂತ ಹೇಳಲ್ವೇನ್ರಿ? ಅಲ್ಲಿಂದ ತಾನೇ ಶುರು ಮಾಡ್ಬೇಕು. ಲಂಕಾಗೆ ಆಂಜನೇಯ ಹೋದಂತೆ, ಸೀತೆ ಅಲ್ಲಿ ಇದ್ರಂತೆ, ಕರ್ಕೊಂಡ್ ಬಂದ್ರಂತೆ, ಆಮೇಲೆ ಹಿಂಗಂದ್ರೆ ಏನ್ ಉಪಯೋಗ ಆಗುತ್ತೆ? You start from the point where you have to start. Starting narration correct ಆಗಿ ಹೇಳಿ. You're jumping from here to there to there to there to there.
ಇಲ್ಲ, ಸ್ಟಾರ್ಟಿಂಗ್ ಹೇಳಿದ್ನೆ ಸರ್, ಅವರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಯ್ತು ಸ್ಟೆನೋಗ್ರಾಫರ್. ಸ್ಟೆನೋಗ್ರಾಫರ್ಗೆ ಪ್ರೊಫೆಷನ್ ಪೀರಿಯಡ್ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು. ಆಮೇಲೆ 2 ವರ್ಷ ನಂತರ ಅವರು ಸೀನಿಯರ್ಸ್ ಪ್ರಮೋಟ್ ಮಾಡಿದಾಗ ಆ ಪೋಸ್ಟ್ ಫಿಲ್ಅಪ್ ಮಾಡಲಿಕ್ಕೆ ಇವ್ರನ್ನ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದ್ರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಅದು ನಾನು
ಕ್ಯಾಂಡಿಡೇಟ್ ಮಾಡ್ತಾರೆ. ಮಾಡಿದ್ರೆ ಇವರು ಜೂನಿಯರ್ SS ಕ್ಯಾಂಡಿಡೇಟ್ ಔಟ್ಸ್ಟೇಷನ್ ಪ್ಲೇಸ್ ಸೆಲೆಕ್ಟ್ ಮಾಡಿ ಇವರಿಂದ ವರ್ಕ್ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಇವ್ರು ಮೋಸ ಅಲ್ವಾ?
ಅದು ನೀವು
ಕೊಡಬೇಕಾಗಿತ್ತು.
ಈಗ ನೀವು ವಕೀಲರು, you are an advocate now, you are not an officer of the whatever corporation. So therefore you should have clarity in your thought. ಯಾರನ್ನ ಪ್ರಮೋಟ್ ಮಾಡಿದ್ರು, ಎಷ್ಟನೇ ತಾರೀಕಿಂದ ಮಾಡಿದ್ರು, ಪ್ರಮೋಟ್ ಮಾಡೋಕೆ ಅವ್ರಿಗೆ ಎಲಿಜಿಬಿಲಿಟಿ ಇತ್ತಾ ಇಲ್ವಾ, ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು. ನೀವು ಪ್ರಮೋಟ್ ಮಾಡಿದ್ರು ಅದ್ ಮಾಡಿದ್ರು ಇಲ್ಲಿಗಲ್ಲೋ ಮೋಸ, ವಂಚನೆ, ದ್ರೋಹ ಎಲ್ಲ ನೀವು ಅಲ್ಲಿಟ್ಕೊಳ್ಳಿ.
ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ನಾನು.
ನೀವು ಇಲ್ಲಿಗೆ ಬಂದ್ಮೇಲೆ ಅಡ್ವೊಕೇಟ್ ಆದ್ಮೇಲೆ ಕ್ಲಾರಿಟಿ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕು.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದೇನೆ.
ಹೇಳಿ.
ನಿಮ್ಗೆ ತೋರಿಸಿದ್ನಲ್ಲ ಆಗಲೇ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೋರಿಸಿ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇವರನ್ನ ಅವರು ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ
ಇವರನ್ನ ಅವರು ಅಲ್ಲ, ಇವರನ್ನ ಅವರಲ್ಲ, ಯಾರು ಅವರು? ಅವರು ಅಂದ್ರೆ ಯಾರು?
ಹೆಡ್ ಆಫೀಸ್ ನಲ್ಲಿ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ಮ್ಯಾನೇಜರ್ಸ್ ಮ್ಯಾನೇಜರು ಇವನು ವರ್ಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಈ ಸೆಲೆಕ್ಟ್ ಆಗಿರೋ ಇಬ್ರು ದೆಹಲಿಯವರು ಮತ್ತು SSL ಕ್ಯಾಂಡಿಡೇಟ್ ಆ ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ದನ್ನ ಬಚ್ಚಿಟ್ಬಿಟ್ರು. ಇವರಿಂದ ವರ್ಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ರು. ಇವರು anticipation that I will get personal assistant ಅಂತ ವೇಟ್ ಮಾಡ್ತಾನೆ ಇದ್ರು. ಈ ಫೈಲ್ ರಿಟ್ ಪಿಟಿಷನ್.
ನೀವು ರಾಮಾಯಣ ಕತೆ ಹೇಳ್ದಂಗೆ ನೀವು ಬಂದು ಯಾವಾಗ ಹೇಳ್ತಾರೋ ಅವಾಗ ಡಿಸೈಡ್ ಮಾಡ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಐ ಕೀಪ್ ದಿಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಎವರ್. ಕ್ಲಾರಿಟಿ ಇಟ್ಕೊಂಡ್ ಬನ್ನಿ. ಎಷ್ಟನೇ ತಾರೀಕು ವೇಕೆನ್ಸಿ ಬಂತು, ತಾರೀಕು ವೇಕೆನ್ಸಿ ಯಾವ ಬಂತು, ಯಾವಾಗ DPC ಆಯ್ತು, ಆ DPC ಆದಾಗ ಯಾರು ಎಲಿಜಿಬಲ್ ಇದ್ರು,
Even government is asking, where is vacancy? They are saying they don't have any records.
See, Mr. We have to
See,
be-
ಈ ತರ ಹೇಳಿದ್ರೆ ನಾವು ಏನ್ ಮಾಡಿ ಸರ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳುದು.
ನೋಡಿ, ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ರೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗಂಗ್ ಬರೀಬೇಕು. ನಾವು ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ರೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗಂಗ್ ಬರೀಬೇಕು.
ಆಯ್ತು ಸರ್.
ನಾವು ನಿಮ್ಮಂಗೆ ದಡ 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 ಅಂತಂದ್ರೆ
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಆಗಲಿ.
ನಿಮ್ಗೇನ್ ಅರ್ಥ ಆಗುತ್ತೆ?
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಆಗಲಿ.
Please come with some clarity.
Right, right.
Come with proper facts. ಇದನ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ನಿಮ್ಗೆ. You are repeating the same thing. Clarity ಇರಲಿ ಸ್ವಲ್ಪ.
ಆಯ್ತು.
Non-counsel for the petitioner seeks time, list on next Monday. ಮುಂದಿನ ತಾರೀಕು ನೀವು ಸರಿ ಬಂದು ಹೇಳಿದ್ರೆ ನನ್ಗೇನ್ ತಿಳಿಯುತ್ತೋ ನಾನು ತೀರ್ಮಾನ ಮಾಡ್ತೀನಿ.
Oblige.
All other cases. ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ, ಅದೇನೋ ಇಯರ್ ವೈಸ್ ಮೇಲೆ ಕೊಡ್ತಾರೆ, ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ.
My lord, CL number 88.
My 2018 ವರ್ಗು ತಾನು ಮಂಡೆ ಆಯ್ತು. 2018 ಅದ್ರಲ್ಲಿ ಇದು ಮಾಡಿ, ಇದು ತೊಂದರೆ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಬೇರೆ ಯಾವ್ದು ಇದೇನಿದೆ ಅದ್ರ ಕೊಡಿ. ಲಾಸ್ಟ್ ರೋಸ್ಟ್ ಅಲ್ಲಿ ಯಾರ ಜ್ಞಾಪಕ ಇರುತ್ತೆ
My
ಸರ್?
lord, CL number 88.
ಆಯ್ತು, ಯಾವತ್ತೋ ಒಂದು ಡೇಟ್ ಕೊಡ್ತದೆ ತಗೊಳ್ಳಿ. ಅಲ್ಲ, ಇದು 2018 ವರ್ಗೂ ಮಂಡೆ, 2018 ವರ್ಗೂ ಮಂಡೆ. ಯಾವ್ದು ಹೇಳಿ ಹಾಕಿಲ್ವಾ, ಡಿಸ್ಪ್ಲೇ ಮಾಡಿಲ್ವಾ? ನೋಡಿ ಅಲ್ಲಿದೆ ನೋಡಿ, ಯಾವತ್ತು ಬೇಕೋ ತಕೊಳ್ಳಿ.
My lord, one small submission, my lord. CL number 88, my lord, as law officer's appointment against the violation of section 20, rule 26 of Karnataka law officers appointment rules, my lord. That was heard on the Friday, my lord, but on the request of the government advocate, it was adjourned today. 88 matter may be taken up tomorrow, my lord. Anytime the charge.
ಯಾವತ್ತು 2025?
Yes, my lord. Fresh matter.
Come on Friday.
Seal number 6. Start date.
Seal number 62.
Date
Serial
ಕೊಡ್ತಾರೆ,
number
ಎಲ್ಲ date. All
59.
interim orders will be extended. The court officer will give a date depending upon the days assigned.
My lord, 88
Seal
will be
number
taken up
62.
tomorrow.
May I mention serial number 59?
88, my lord.
Lordship, may I
It
mention
will be
serial
given by
number?
the court officer. You can collect the date.
Date.
Interim order ಇಲ್ಲ ಅದಕ್ಕೆ.
Interim order ಇದೆಯಲ್ಲ ಯಾರ್ದು ಸರ್? 85.
88
Sir, 75 and 76, sir.
Part heard ಅಲ್ವಾ?
Then the part heard matter, seal number 62.
ಇದು ಎರಡು
Yes, sir, 75 and 76 next Monday, sir. 75